the Register of Copyrights, and I would like to welcome you to our first hearing in Washington, D.C. with respect to Section 1201. Last Friday, we began our hearings in Palo Alto, California. Hopefully the hearing today will not be as long as the hearing on last week, which was about 10 hours. Last Friday, we addressed some of the proposed exemptions that are the subject of this rulemaking. Today, we will continue to examine the proposed exemptions to the prohibition on circumvention. And obviously, this hearing is part of an ongoing triennial rulemaking process mandated by Congress in the Digital Millennium Copyright Act. I'm sure if you're here, all of you know that Section 1201A1 provides that the Librarian of Congress may exempt certain classes of works from the prohibition against circumvention of technological measures that control access to copyrighted works. The exemptions, if there are any, last for 3 years, and they begin on they will begin on October 28, 2009. The purpose of this rulemaking proceeding is to determine whether there are any particular classes of works as to which users are or are likely to be adversely affected in their ability to make non-infringing uses of copyrighted works if they are prohibited from circumventing the technological access control measures. This rulemaking establishes a record on which my recommendation to the librarian will be based. After the Copyright Office's initial notice of inquiry in this rulemaking, published in the Federal Register on October 6, 2008, the office received 20 comments proposing exemptions to the prohibition. We received 56 responses to these proposed exemptions, and obviously everything related to this rulemaking, including the comments, and shortly thereafter, the record of these proceedings are available on our website. In addition to today's hearing, there will also be hearings on tomorrow, Thursday, and Friday. The agenda for the rest of the hearings is also on our website. As I mentioned, we are basically having full transcripts of all hearings, and they will, in fact, be posted on our website as soon as possible. The comments, responsive comments, and hearing testimony will form the basis of evidence in this rulemaking, which, after consultation with the Assistant Secretary for Communications and Information of the Department of Commerce, will result in my recommendation to the librarian. As I mentioned, the librarian will make a decision by October 28, 2009, on whether exceptions to the prohibition against circumvention should be instituted during the next 3-year period. And if exemptions should issue, which particular classes of work should be exempted. The format of the hearing will be divided into 2 basic parts. First, the witnesses present their testimony, and those of you who have done this before, this is your chance to make your case, explaining the facts, the technology, and making the legal and policy arguments that support your particular claims, and whether or not there should be a particular exemption. The statements of the witnesses will be followed by questions from the members of the Copyright Office panel. The panel, I hope, will ask you tough questions in an effort to define and refine the issues and the evidence presented on both sides. This is an ongoing proceeding. No decisions have been made as to any critical issues. In an effort to obtain relevant evidence and to have as much evidence and help as we possibly can, we do reserve the right to ask questions in writing of any participants in these proceedings. And when we ask those questions and we get your answers, those are also posted on the website. So let me start by introducing, maybe you know all of us, the Copyright Office members of this rulemaking process. To my immediate right is David Carson, General Counsel of the Copyright Office. To my immediate left is Rob Kasanick, Principal Legal Advisor and Assistant General Counsel in the Office of the General Counsel. To Rob's left is Ben Golant, also a principal legal advisor and assistant general counsel in the Office of the General Counsel. And to David's right is Chris Weston, an attorney advisor in the Office of the General Counsel. So let us begin. Are you all ready? Who's going first? Chris. Okay, Chris, you're first. Yes.
Yeah. So this is my first time doing this. I appreciate you making this available. My name is Chris Segoyan. I am a PhD student. I'm a doctoral candidate at Indiana University, and right now I am a student fellow at the Berkman Center at Harvard. I want to first clarify that I'm here in my personal capacity.
Okay.
I'm not representing Harvard's positions. So just as a point of clarification, are we doing both exemption requests at the same time? Or are we doing one after another? How is this going to work? Because we have two, or I have two.
I think you can address them in any order that you see fit.
Okay.
You are doing both?
Yeah.
Yes.
Okay. All right, so let's deal with the first one, which is, I believe, A, which is the exemption after the media stores fail. So we're seeking an exemption to allow people to circumvent DRM in the event that authentication server-based DRM stores fail. This has happened several times over the past few years. For the most part, in the realm of online music, we've seen Walmart, we've seen Microsoft shutter one service, we've seen Yahoo. We've also seen some video services go down, such as Google's brief video service. This is a very real threat. In some of the comments that we got, it was stated that this is a hypothetical scenario because in the instances we've seen so far, all of the firms that have gone under have either given refunds or provided an alternative means of access to consumers. And I'll get into that in a minute. One of the first issues that was brought up in the response comments as well, the fact that services can go down, this isn't such a bad thing for rental markets. And I want to first clarify that we don't care about rentals. We're only concerned about purchased works. When you rent a movie, you only get it for a few days. So if a year later the service goes down, it's not a problem. We're only focused on media stores where consumers purchase a work with the expectation that they will be able to keep using that in the future. So I just want to take the issue of rental, anything but purchases, it's off the table. All right, so we have this general idea of a store, right? So consumers go online, they buy a work. The work is advertised as purchased music. It's not advertised as a lease. It's not you can listen to this work for the next 2 years and then it may disappear. It's, go online, you can buy this movie, you can buy this song. In many cases, these stores require that users check in with the server whenever they transfer to a new device or they reinstall their computer after they get a virus or an infection of some kind or the battery on their iPod fails. In some cases, like the Google Video Store, consumers actually had to check in every single time they played the movie, which meant that the moment the video store went down finally, all works ceased to function. So, that's sort of the general category of media store we're looking at. So we've seen multiple failures. I think maybe 4 or 5 different failures over the last 3 years. So we've definitely had Microsoft, we've had Yahoo, we've had Walmart. There may be 1 or 2 more that I'm not thinking of off the top of my head. And in each of these instances, the services initially said, sorry, we're going to be going down, or we're going to be shutting our service, this is not profitable anymore. In the case of Yahoo, they said, we're switching completely to MP3. So they decided that DRM was not the appropriate solution for the market anymore. We're switching to MP3, we're going to be turning off our authentication servers. So, they gave consumers, a few months, and then what happened was that there was a huge outcry. Consumers said, no, this is not appropriate, that we're going to be cut off from works that we've paid for. And in these instances, these very, very large companies with huge pockets, because of other more profitable businesses, were able to subsidize, remedy for those consumers. So in some cases, consumers were given refunds. Initially, Google offered consumers, I think, $10 coupon off of Google checkout on a future purchase, and this was such an insult that Google immediately said, no, sorry, we're going to give full refunds and then something else. And I think Walmart didn't give refunds, but they extended the life of their servers. And at some point, they could decide to turn them off again. But in all the instances, we've seen services provide some remedy. But that was only because these were multi-billion-dollar companies. And there are smaller fish in the DRM market who wouldn't have the means to provide a remedy to consumers in the event that they failed. VC-funded companies, they burn through all their venture capital, and then they have no money left. They decide to turn the service off. That's it. There's no magic bank account that they can tap to then provide refunds to consumers. So, the first point that I'd like to make about this situation is that this is not a theoretical harm. Companies have gone under, or companies have shuttered their services, and the only thing that has been the issue is that these have been rich companies. But this is a very real harm, and in the future, we're likely to see other services fail or other services shutter because at least in the music realm, there is finally recognition that DRM is not something that consumers want. Now, the stores still seem to be pushing this in video and in TV shows and in games and in books and these other media services. But at least in music, they seem to be moving away from DRM. Another thing to mention is the economy isn't very good right now, and so any part of a business that is not pulling its weight, that's going to be shut down. And so we're definitely likely to see more services shuttered in the next 3 years. So this is not a theoretical harm. This is a real harm. The next point I'd like to make is that consumers are not able to predict that services are going to fail, right? Consumers can't predict that banks fail, which is the very reason we have the FDIC, right? Consumers are protected from the failure of services. And nowhere else in the IP world do we see a business go under and consumers lose access to their works, right? When Sony finally lost the Betamax VHS war, the Betamax tapes in people's houses didn't miraculously stop working one day, right? You could keep, as long as that player worked, you could keep playing those tapes that you'd purchased. And even if your player stopped working, you could go onto eBay and buy another player, a used one, and keep playing those works. This is the first sort of instance we've had where the merchant can sort of reach into the home and disable access to works that people have already paid real money for. Now, it was mentioned in the reply comments that, it says in the terms of service that the services can go under, or the services can change, or they can decide to not offer the authentication servers anymore. And it's true. In iTunes, in the 22 pages of the iTunes Terms of Service, there is a paragraph in there that states that the services can stop working. But I would argue that most consumers don't read those terms of service. I would argue that most consumers are not capable of reading those terms of service and understanding the text in there. It's not in clear English. It's in legalese. There have been studies by academics that showed that if consumers had to read every privacy policy of every website they interacted with, it would take years of their time. And so I don't think most consumers read the iTunes Terms of Service before they go online and buy a song. And I think so to many of them, it's a surprise that these works that they've purchased can miraculously disappear. Let's see. So people expect to be able to listen to the works that they've paid for years and years and years. My father is a jazz musician, and he listens to vinyl records from the 1940s and 50s. When his record player poops out, he goes out and buys a new needle, but the discs keep on working. They're, a little bit scratchy. And he's able to go onto the internet and buy, used vinyl records. Consumers expect to be able to listen to their works for, decades, not 10 years or 5 years or 2 years. There was a statement made a few weeks ago at a Federal Trade Commission hearing on DRM where a woman who had played a key role in shaping the DMCA, had said that if a consumer goes out and buys a copy of the Bambi movie, they don't expect to be able to watch that in 5 years. And I would argue that that's false. Consumers have an expectation that they'll be able to keep watching the works that they've paid for. One of the other points I'd like to make is that, so let's look at a hypothetical situation. So a consumer builds up a catalog of lawfully purchased works. They go out and they spend real money to build up this catalog, and then one day the service decides to shut. They're given 2 months notice, and they say, okay, in 2 months you lose access to your works. The business is not in the position to be able to offer refunds, so the consumer loses access to their works. Now, what are they going to do? They've already paid all this money. They could go out and buy the same works again, but what's more likely going to happen is that consumer is going to be driven to piracy. Those works are all available online for free in the underground. And I would argue that by shuttering these services and denying consumers the ability to keep accessing works they've paid for, we're going to be making life so difficult that we're going to be pushing these consumers in a direction that we really shouldn't be pushing them. We're not talking about making life easier for pirates, because people who want to pirate can already go online and download those works for free anyway. We're talking about making life easier for people who buy works. These are the people we're supposed to be encouraging to purchase, right? These are the people who should have faith in the system. And by taking the works away from them, we're going to make them lose respect for the system. So, I mean, one of the points that's been raised in criticizing this is that this could lead to piracy, that this exemption could make it easier for people to pirate works. And I'd like to argue that that's not the case, that if you want to pirate, there are way easier means to obtain unauthorized copies. No one is going to go through the effort of sharing a DRM-encumbered file, downloading that file from a peer-to-peer network or their friend, then going out and finding some tool to strip the DRM, and then stripping that DRM off. They're just going to go straight to the internet and download the DRM-free version that is available everywhere. This is not at all about making life easier for pirates. There are already means for them to do that. There's one last point I'd like to make about the first exemption request. There seems to be a bit of an elephant in the room with regard to some of the issues that I've seen in the exemption process. And I think that relates closely to our exemption, but it relates to some of the others, which is that we sort of pretend that people don't use tools. I listened to some of the MP3s of Friday's session on the plane yesterday, and I thought it was really funny that people kept saying, if you're a professor, how would you make a clip of a movie? So, well, hypothetically speaking, we would do this, right? And everyone knows that there are tools out there, right? And there's this sort of missing piece in copyright policy in America today that we don't like to talk about, and that's the French, right? So if you are a film studies professor and you want to make a clip of a film, what do? You go to a French website and download Handbrake, which is the most popular Macintosh DVD ripping tool. You download Handbrake, you make your 20-second clip, and then you use that in your class, right? So there are no I would argue that there are less than 5 film studies professors in this country who have the cryptographic skills necessary to break CSS by themselves. I would probably argue that it's less than 2. They all use tools. The same way that, if people want to do the region unlocking themselves, they're not going to, circumvent the DRM on the phone themselves. They're not going to reverse engineer it. They're going to go and download the tool. And I realize that the DMCA does not give, you the power to allow people to use tools. But I think we should at least recognize that tools do play a very real part in the process, right? We cannot expect consumers to circumvent DRM themselves. These tools will always exist. And right now the tools are made. They just happen to be illegal. And so, this is not nothing in this process, whether you make the exemptions or not, is going to either increase or decrease the likelihood that tools are going to be available. Handbrake was available long before the exemption for film studies professors was created. DECSS was available long before anything was discussed. Those tools are there. They just happen to be released outside U.S. borders. And what this process does, it doesn't legitimize the tools. What it does is allows lawful use. It allows people to circumvent the encryption without sort of being in the shadow of the underworld. And so in that same situation in our exemption request, we should recognize that there are going to be tools, because we cannot expect consumers to circumvent this stuff themselves. They're not, very, very few people have this capacity, which is sort of leading me into my researcher exemption, which is that we need to provide the ability for researchers to collect the information necessary to make these tools. And the DRM that surrounds these authentication server-based systems is unique in that once it gets turned off, the information necessary to circumvent the DRM disappears, right? So once Apple turns off their servers, researchers lose the information necessary to tell people how to circumvent the DRM, right? So if you buy a DVD today, even though let's just pretend that DECSS has never been released, you could potentially reverse engineer the DVD, even if all the companies producing it have gone bankrupt. You experiment with it, you see which signals are getting sent back and forth between your player and the DVD, you can reverse engineer it. But once that authentication server has been turned off, you lose access to the basic information that will tell you what's happening. Because those signals, the unlock code, the message that says it's okay to play that song today or it's okay to play that movie, those are no longer being sent. It's sort of like Alibaba and the 40 Thieves, right? If all the 40 Thieves had disappeared, Alibaba wouldn't be able to listen to them saying open sesame, right? You need to be able to overhear that message at least once to figure out what's happening. And once those services have been turned off, we lose the ability to do that. So, while we really would like our first exemption to be given, without the second, it loses much of its power, in that it's far less likely that even if people have the lawful ability to circumvent DRM after the service fails, if they're not able to gather the information necessary ahead of time, there's not going to be much they can do. I mean, it might be possible to circumvent the DRM, but it's going to be exceedingly difficult, far more than if the information was available ahead of time. So I would like to stress the importance of providing this exemption to good faith researchers. Okay, so I think that's everything I wanted to cover for now, and hopefully we can get into some more in the questions.
Thank you.
Mm-hmm.
Thank you. Sandra.
Do you want to start, Steve? Because I think mine adds just more
okay.
practical.
Thank you very much. And I appreciate the chance to be back here and talking about these two exemptions. Well, Mr. Segoyan has made an ingenious argument here, and I'm glad he's had the chance to develop it at a little more length. There's only four main things wrong with his argument with regard to Exemption 10A. There's some other problems with regard to Exemption 10B, the research exemption. Under the ground rules for this proceeding, as set by Congress and as the office has developed them over the last decade, the burden of persuasion, of course, is on the proponent of an exemption to the prohibition on circumventing access controls. And I don't think that Mr. Segoyan, in his submission or in his testimony today, has carried that burden. He's sketched out a scenario, but he hasn't shown any evidence that it has happened or that it is happening. And of course, those are the tests that the statute requires, which is whether people are being impeded in their ability to use non-infringing works as a result of the prohibition in Section 1201A. nor has he shown that it's likely to happen in the next 3 years. Nor has he shown that if it did happen, it would have any cognizable impact on the ability of people to make non-infringing uses. Nor, if there were such a cognizable impact, he hasn't shown that there would not be lots of alternatives available, lots of ways that people could make exactly the same use of exactly the same works without circumventing access controls. Now, our arguments in support of this are all spelled out in our submission that we made, but I'll go through that briefly. I do want to say that the type of technology we're talking about here through the use of authentication servers is really a prime example of the sort of access control that Congress was thinking of when it adopted the DMCA. And we know that from the legislative history, which talks about use facilitating access controls. And this is, as Sandra Astars will demonstrate and talk about a little bit more in just a minute, this is a prime example of use facilitating access controls. It provides a kind of flexibility and responsiveness to consumer concerns or to market forces that is really quite unique when you compare it, for example, with other types of access controls like CSS that we've been talking about on DVDs. So it enables companies to respond to the marketplace, to give people greater flexibility in how they use the materials that they've gained lawful access to. And that's really been, I think the record is replete with examples of that, perhaps not as much with regard to this exemption, but elsewhere in the record, to show that these use facilitating access controls that are enabled through authentication servers have been employed to give consumers greater flexibility and more ability to make non-infringing uses. So I think one thing that the office has to be concerned about here as a policy matter is what would be the signal sent by allowing an exemption or approving or recommending an exemption to allow or to facilitate circumvention of these use facilitating access controls. And in particular, the question of whether you would basically be telling companies that if you get into this market, you have no exit strategy. You're not allowed to get out of this market, or if you do, you will be subject to people hacking through your circumvention. Now, 10B raises some other questions, which I'll get to in a minute. But let me just talk a little bit about 10A. Of course, some services using authentication servers have closed down or have changed their policies or have, I think Mr. Seguin has narrated well what has happened in these cases. But I think when you look at all of them, what has happened is that consumers have retained access to the material that they purchased access to, or that they licensed access to, and when they haven't, there have been plenty of alternatives made available to them, whether through refunds, through the ability to burn copies to other media, or other types of alternatives. So the scenario of consumers being stranded really has not occurred. There's nothing in the record to indicate that it has ever occurred. Mr. Seguin says that will occur he's confident that will occur in the next 3 years when the smaller fish get into this circumstance. The problem is that in this proceeding, he can't just refer to the smaller fish. He'd better catch one, bring it to you in the net, and show you that this either has happened or demonstrate that it is more likely than not to happen in the next 3 years. And I don't think he's met either of those tests. So we don't, it seems to me, have evidence, persuasive evidence that people are or are likely to be impeded in their non-infringing uses as a result of this scenario. Now, if this scenario did occur, what impact would it have on non-infringing use? I think there are two answers to that, one more legal in character and one perhaps more practical in character. On the legal side, I think it is a fact that in virtually every case, the terms of service under which consumers have gained access to this material contemplate the possibility that the service might not last forever. They're not signing up to be buried in the pyramids at Giza, where something is they could be counting on being there 5,000 years from now. They're signing up for a service in a rather volatile marketplace, one marked by a lot of experimentation and change, often change that increases, I would say, their ability to access, make use of, and disseminate the material that they're obtaining access to, but also the possibility that the service might not continue. So the limits of what use they have, what uses they are making that are non-infringing, are defined by that license. That license spells out what uses are authorized and what uses are not authorized. So if in a situation where the consumer has entered into that license agreement that provides for or contemplates termination of the service, if the service were to in fact terminate, that wouldn't have any impact on non-infringing use. Now, Mr. Seguin raises, and quite properly so, issues about whether consumers read the contracts, could they be expected to read these license agreements, what are their expectations, and those are all, I think, completely legitimate issues. They're not issues relevant to this proceeding. Those are issues are relevant in the buildings 8 blocks from here at 600 Pennsylvania Avenue at the Federal Trade Commission, which is looking at this issue, and we know that from the town hall meeting that he and I participated in and that Rob Kasnick participated in, that the Federal Trade Commission is looking at issues like consumer expectation and disclosures, and whether disclosures in the terms of service are adequate and the use of certain terminology and so forth. And I don't question the legitimacy of those issues, but they really don't have anything to do with this proceeding. This proceeding is about access for non-infringing use. And as a legal matter, in these circumstances, once the service is terminated, the further use is not non-infringing. Now, let's turn more to the practical side of this and not the legal side. And that really has to do with what has happened and what is likely to happen when a service like this, like one of these services, decides to shut down. And as I said, there have been shutdowns, and there undoubtedly will be shutdowns in the future. But the record so far is that many alternatives are made available, whether they are alternatives that involve the ability to port the work from the system in which authentication is required into a medium such as a CD on which authentication is not required. That's one example. I should say that for most of these services, I won't say all of them. I think Google Video might be the only exception to this, as Mr. Seguin describes it. But for most of these services, if you're going to continue to access the material on a piece of equipment or on a platform that has already been registered with the authentication server, there may be absolutely no impact whatsoever. You can continue to access it because authentication is generally only required when there's a change in the equipment, change in an operating system, or to register or authenticate a new piece of equipment and so forth. So in many cases, I won't say all, but in many cases, people will be able to continue to make the same uses that they have made in the past, even if the server is not continuing to authenticate. But in those cases where they can't continue to make those uses, I think the record has shown that they are offered plenty of other opportunities, some of them subsidized in the past, have been subsidized by the operator of the service, some perhaps not. And again, I think from the standpoint of this proceeding, that's probably a distinction without a difference. The question that this proceeding asks is, do they have no alternative way of making non-infringing uses of these materials? And the answer is clearly no. They do, or rather, no, they don't have any. They're not blocked from doing that. Yes, they do have many other alternative ways. For example, I don't think Mr. Seguin has cited a case of a single title that is available only through a single authentication server system. And if that's the case, then any title that someone accessed through an authentication, through a system backed by authentication servers that stopped operating, they would have other ways of finding that in the marketplace, through other systems, through other services, or by the great old-fashioned method that his father uses and a lot of other people use. You can go out and buy a copy of it, a hard copy, in a store or on the internet. And in many cases, that's going to be a higher quality copy than you're getting from the online service anyway. But regardless of whether it's a higher quality copy or not, there certainly are plenty of ways to continue to make the non-infringing use that you were making before of listening to or enjoying the product without having to resort to circumvention. Again, issues such as whether you have to pay for this or not are legitimate issues at 600 Pennsylvania Avenue, not really issues here where the precedent is quite clear that the fact that there might be some charge incurred, which has not happened, I would point out, in any of the previous examples, but even if it were to happen, that would not really make a difference in terms of the of meeting the burden in this proceeding to establish this exemption. Let me just talk briefly about 10B, the proposal for, as I would call it, anticipatory circumvention. I think this would convey to companies that are thinking about entering into this business, thinking about experimenting with this new method of delivering product to consumers. It would tell them your service is legally hackable from day one. Anybody who wants to, because Mr. Seguin's submission rejects the idea that there would be any qualifications or certification or credentialing involved here. Anybody who wants to can circumvent them against the possibility that someday in the future the service is going to end. And it's also very clear, both from his submission and from his testimony today, that the purpose for this is to make tools that violate Section 1201A2. In other words, to make circumvention tools or prepare to offer circumvention services that are in violation of the law. Now, he's absolutely correct at one level that nothing that's done in this proceeding has any impact on the availability of tools. And again, at one level, that is correct because this proceeding is only limited to Section 1201A, the act of circumvention. So granting an exemption or not granting an exemption doesn't change the legal status of any tool that is developed. And if the tool is developed for the purpose of circumventing an access control that's used by copyright owners, and if it meets the criteria in the statute, and without going into all of those, then it's illegal to manufacture and it's illegal to traffic in it and so forth. So again, he's correct that this proceeding doesn't change that one way or another, but it strikes me as it would be an odd use of this proceeding, and probably one that Congress did not intend, if an exemption were granted for the rather explicit purpose of allowing people to do the work necessary to develop and be prepared to distribute tools that violate Section 1201A2. Finally, on the 1201, on the 10B matter, it wasn't clear to me from the submission, and I think it's less clear to me now, what case he has made that circumvention is actually required in order to study, test, and document, which is what the verbs that he uses in his submission, study, test, and document the DRM systems that are involved here. I think he says that it may be necessary. I believe that he said today that you can reverse engineer these, if an authentication server is operating now, you can reverse engineer it by observing the signals that are transmitted back and forth, and apparently can do that without circumvention, and you wouldn't be able to do that if the server had turned off. But I didn't really hear any clear explanation of why circumvention is even needed to do this for a functioning server. But I think that's almost a footnote to the larger problem that we would have with 10B, which is that it's an anticipatory circumvention exemption that's being proposed explicitly for the purpose of developing illegal circumvention tools, and it would be open to anybody. So I think beyond the four basic reasons that I talked about with regard to 10A, I think there are a lot of other issues regarding 10B that would argue against recognizing that exemption. So I'll conclude my remarks at that point and turn the microphone over to Sandra Starr.
Thank you. I'll not repeat the points that Steve has made, but note that Time Warner agrees with those comments and agrees with the legal analysis that Steve's put forth. What I'd like to do is speak a little bit about our practical experiences using these sorts of technologies and give a sense of where we use them and the sorts of benefits that they do offer consumers. And I'd like to start by noting that although Mr. Segovian notes that his main concern is perhaps the smaller fish, or however it was termed, I don't know if that was your or Steve's note, but if that's the primary focus, unfortunately, the sorts of exemptions that have been proposed would, in fact, harm all of the players in the ecosystem and would, in my experience and in my view, looking at the sorts of services that we offer, harm consumers in terms of the types of access to works and functionalities that consumers have been indicating that they'd like. It would harm their ability to continue having such access. As we noted in our written testimony, we believe that the use of authenticating servers to deliver new and more flexible means of experiencing our copyrighted works to consumers is precisely the sort of practice that Congress intended in enacting the DMCA. And as I said, we believe there would be a far-reaching negative effect on our ability to deliver content to consumers in innovative ways because of the way that we use these servers. Virtually every digital distribution service that we license at this point makes use in some form or another of an authenticating server. And most frequently, those sorts of servers are used to facilitate granting additional privileges to consumers. So as Steve noted, while things may vary from service to service, for a pure playback of a permanent download on a device that's already been registered to the account, typically there's not a check-in function necessary. But the sorts of functionalities that we enable by using these servers are, either to consummate a financial transaction to begin the purchase or to grant an additional set of rights, to authenticate accounts that allow users to access content from remote locations and not the one to which they're ordinarily receiving the content. We use servers to enable multiple devices that are associated with an account to access content, and also to allow a user to manage the devices associated with their account. So if they decide to take one off and add another one, they can do that by using an authenticated service. As I said, we facilitate the incremental addition of rights. In my written testimony, in talking about the sorts of services we're offering now in the marketplace, I talked about the kind of try it, like it, buy it model that we're offering with a couple of services, and that's a perfect example of granting incremental rights. Somebody decides to do a video on demand download to watch the movie, but then decides that they really like it and they want to upgrade their rights to a permanent download. We'd use an authenticating server to facilitate that. But most interestingly, and I'll show an example of that in the demo in a few minutes, we're using these sorts of services to enable consumers to take advantage of special offers, like obtaining access to special events or to community screenings of movies, to facilitate their own commentary on our works that they can then distribute around to others. And those are all things that would be putting our content at risk if the authenticating servers were to be hacked to, facilitate the sort of research that Mr. Seguin is suggesting they'd like to do, and that's regardless of, whether he directs it to purchased works only or to rental works and other works more broadly, because the hack is the hack and it applies equally to the technology. I'll note also that the use of authenticating servers is not a new concept. Even traditional services like cable TV depend on the use of authenticating services, and cable TV uses it to establish that a customer has paid the bill or subscribed to the channel that they're trying to access, and more recently, in order to determine the person has sufficient room on their DVR to make the recording that they're seeking to make. So this is a very, very wide-reaching proposal, and a lot of industries would be affected, not just small kind of mom-and-pop shops that might go out of business. Obviously, the viability of all of these services would have to be reconsidered if an exemption such as 10A or 10B were to be granted. We do a market analysis for every new business model that we roll out, and we balance the risk to the content with the price that's offered for the model, and to the extent that our content would be put at risk, it would more than likely lead to a reconsideration of the sorts of flexible uses that we are excited about offering now. And I'll note, and I think Steve mentioned this to some degree, I think it's very significant that there is insufficient record evidence to support that there's a need for this exemption, because consumers won't be able to access the titles that they've acquired through services by other means. Our content, for example, is licensed to so many different digital channels of distribution. I find it very hard to believe that one title would not be available in some other form. We license cable, satellite, internet, VOD, various subscription services. We distribute on DVD and in Blu-ray. We license online rental services. We distribute through iTunes, through platforms like Xbox and PlayStation and Roku and mobile services. So there's a wide variety of services to go to if necessary. And I do, share Steve's points about the fact that, Mr. Seguin raises valid concerns about consumers and their continued use of works that they've purchased, perhaps because they don't understand the terms of the license or what have you. But I agree with Steve that the exemption that we're talking about here, the proceeding is not aimed at solving those particular concerns, and I can say from experience that the FTC is, in fact, looking into these sorts of concerns from the consumer impact perspective. I'd also like to add that the exemption is unnecessary because licensors, such as we, of content to services, are taking appropriate steps to ensure that the services to which we license our works have the financial wherewithal and the technical wherewithal to stay in business. It does us no good as a business to license a service that's not a viable service, and it certainly does us no good to upset our consumers about the quality of service that they're receiving through a third-party service. So we're very acutely aware of that, and we have due diligence processes in place at our studio and at our other divisions to do full technical evaluations, to discuss financial viability and so forth as we license services. So I think we're acting as responsible parties to try and minimize the risk that Mr. Seguin has indicated may exist. I think probably the best thing to do is just to use the rest of my time to show you a short demo of BT Live, which is a new functionality that we've launched. And do I need to be speaking into the microphone for the? I don't know if we need to move it over there then. And not the sound from the projector. The searching for signal to your computer. I think it's the computer, not the...
No, the projector's on. Oh, here we go.
Okay, thanks.
Try again.
So what I'll show you is a demo of BD Live, and what you're seeing as this opens up is what a user would see when they come into the Warner Brothers BD Live portal. You see the main page, and it shows a trailer, and then at the bottom it gives you various navigational choices, and from the home page you can go to the live community screening function, and here we are demoing a community screening that we did with Christopher Nolan, who's the director of The Dark Knight, in December of 2008. Consumers who lived in the United States and in Canada had the ability, if they owned the BD copy of the work, to watch the film with Mr. Nolan and to submit questions in advance and during the event. And we got over 45,000 questions that were submitted and conversation that occurred with the director of the film. I'll let you watch it for a little bit without speaking, but so you see the questions popping up at the top of the screen, Mr. Nolan answering them. Interestingly enough, it's a very interactive service. We actually had a marriage proposal happen on this particular screening. We're not going to show you that, but she said yes. So here we're just showing a scene. It was filmed in IMAX, and Christopher Nolan is talking about why they chose that particular way of filming the scene. I'll just talk over this while it's showing a note that when you set up a community screening, this is something that we did for obviously a very large community, the entire BD Live community, but this is something that a user can set up on their own with friends and family who may want to watch a movie together. I can imagine it would have applications in other scenarios as well. You would want to use it perhaps in an educational context for a professor to have an interaction with students.
Three of a kind. Let's do this.
That's it? 3 guys?
2 guys on the roof.
Lower the volume a little bit. But the moderator who sets up the screening has the ability to pause and to fast forward and to go back and forth as you're watching the film. Now, the next thing I'm going to show you are a couple of my WB commentaries, and the first one I'm showing is of Senator Patrick Leahy, who actually acted in the Dark Knight movie. And he's recorded a commentary just like any other user would, talking about his experiences acting in the film.
I don't want to use the word schizophrenic, but basically the Bruce Wayne is 2 different people. He may think of himself as Bruce Wayne in one moment, but then when he thinks of himself as Batman, it's almost an entirely different person. And Alfred's comment.
So the way this works is the user just makes the, the audio video clip that they want to share with the community in their own home, and they have the ability to choose whether they do just an audio narration or an audio-visual narration. If they do an audio-visual narration, shows up as a picture-in-picture, and they can choose the placement on the screen of where they want it to show up. And the consumer can choose whether they want to comment on one particular part of the film or whether they want to comment on the entire film. And record it accordingly. And so when somebody plays back a film for which commentary is available from the user community, they can, select which commentary they want to hear, and that will be delivered to them from the server while they're watching the playback of the movie. The other commentary that we'll show is just what a typical users have done. This is by two guys who are very enthusiastic Dark Knight fans.
Oh, hey, look, here we are.
Hey, we're on TV.
I'm Adam Badney.
Hi, I'm Troy Benjamin.
And we are here doing our own Blu-ray commentary for The Dark Knight.
Great movie.
Fantastic movie. And we get to do this very awesome video commentary for you all so we can talk about how we felt about the movie, as if you should care.
I think our opinion is well-renowned.
And I'm going to check. I got 3 fingers, headspace. Right?
It's pretty good.
In any event, the commentary that people record provides sort of a social networking functionality so that the fan community for movies can interact with each other, comment on the movies, make jokes about the movies.
The Dark Knight, and we've got plenty of
there's no particular,
tons and tons of things
there's no restriction or vetting of what's done on the site.
The Dark Knight,
so it already provides some social networking functionality, and what we're looking at and exploring with other social networking sites is how to further enable this and allow users to perhaps take something that they've done as a commentary in this space and maybe move it to a blog or move it to their homepage on a social networking site. We're also continuing to evaluate other ways to let consumers interact with our content through BD Live, and we've looked at a couple of things in other formats which could potentially be imported into some of the services that we offer here. Examples of what we've done are like a pick your own scenes sort of function where you can create a playlist of your favorite scenes and then exchange them with your buddy list and vote on them and make comments about them. Another example of functionality that we've offered is the Magic of Editing, which is an interactive editing suite that enables users to edit a scene as if they were the editor of the movie. And with that, we've also had director and editor demos that allow you to show what the difference is between a good edit and a less good edit, and what their decision making is. So, in any event, this just gives you the sense of some of the kind of additional services and additional functionalities that we offer using authenticating services, and something that hopefully adds to the Copyright Office's understanding of the kind of scope of use of these sorts of functions. So thanks, I'll end there.
Okay. Before we begin our questioning, I want to know if you have any responses that you'd like to give to what you heard.
Fantastic, thank you. Thank you for showing that film. I like Dark Knight, and I think it's quite poetic that in discussing this problem of consumers being robbed of works they've paid for that we see a heist movie beginning with a bank robbery. I think it's quite poetic. So there are some points I'd like to address. First, those made by Steve, and then I'll get to the other ones. There's clearly a disagreement between Steve and myself, which is whether this is a theoretical threat or whether this is a real threat. And I would argue that this is a very real threat. Steve would like to say that this is a theoretical threat and I haven't shown any real harm yet. I think this is real. I don't know what else I can do to say in that area. So the first thing that I guess that I can say is that while consumers have the ability to back up their works with regard to music, no services that I'm aware of, very few if any, provide consumers the ability to burn a purchased movie to DVD themselves. Very few. So while consumers may have the ability to back up works that are from a failing store in music, in movies they have no option there. In TV they have no option there. Ebooks they have no option there. Not that we're discussing ebooks, but just example of that service. There's no way to back up a game. It's a piece of software that runs. At least with a piece of media, you could maybe play it on your stereo. But when a game is taken away from you, it's gone. Steve also argued that while many of these services they only require authentication when consumers switch to new hardware. That's true. I don't know how many of you own iPods up front or how many of your family members own iPods, but their batteries don't last very long. But luckily, Apple has a warranty program. But after a year, that's up, and the price of the battery is about 2/3, maybe 3/4 of the price of a new iPod. So myself, I've gone through 3 or 4 iPods in the last 6 years. When a new iPod comes out, it's basically cheaper just to buy a new one than it is to pay for your year-and-a-half-old iPod to get a new battery. And so that when you buy that new one, if you want to port your existing works over to that new iPod, you need to call home. You need to call the authentication servers. I run Windows on occasion because my colleagues use Microsoft Word. I'm forced to use Windows, and it suffers from horrible virus problems. And so every time I get a virus, I have to reinstall my computer from scratch. And when that happens, I need to call home and get permission from these authentication servers. Now, if Steve and the people he represents can fix the antivirus problem on the internet, and we don't have to reinstall our computers, then that's great. But right now, consumers do have to reinstall their computers on a regular basis. Hardware does fail. People, and the way that Microsoft's operating system works, when you add more than 1 or 2 pieces of equipment to a PC, even if you just get them fixed, it's considered a new computer from Microsoft's perspective and has to call home. So, I would argue that consumers do, in the course of their everyday affairs, have to replace hardware. That's just the way it works. We live in a society where people are replacing their computers every 2 to 3 years. Now, the point that I guess is most surprising to me, and I can't really get my head around, is this idea that, there are no works that are only available via one service, and so if consumers lose access to works they've paid for, well, then they can just go to Best Buy and buy the work again. I understand that that's true. It seems a little bit screwed up to expect people to go out and purchase again something they've already bought in the first place. And I think, as I argued before, all that is going to do is push people towards piracy. These are people who have gone out and paid for works once. It's very true that they can go to another online media service and yet again take another risk. But I think it's completely unreasonable to force consumers to purchase something that they've already bought because the service that they bought the first time decides that they want to go under. Now, with regard to the second set of comments, I'm really confused by this claim that my exemption request puts their content at risk, because everything that you sell already is available online on the Pirate Bay and other sort of darknet pirate sites. There is no work that you sell via an authentication server-based system that it hasn't been pirated and is available with an easy download. And so I'm sort of confused as to how allowing consumers to continue to access works they've paid for puts your work at risk, given that anyone can download those works right now without any DRM for free. That just doesn't make sense to me. Let's see what else. This idea that authentication servers are already used for cable TV and so other industries would be harmed, we're only talking about works that people pay for, where they buy works. I don't know that cable TV sells content. They provide content, you pay a monthly fee to Comcast, but Comcast doesn't sell you any works. So as we've said, we don't care about rentals, we don't care about leases, we don't care about streaming services. We only care about services where people pay for the works. If the service is being advertised as buy this song or buy this movie, we care. If they say rent this song or rent the movie for 3 days, turn the services off. We don't care. That's not our concern. So I don't see why the cable TV example is valid at all. This idea of a try to buy and then you can unlock the movie after you've rented it for a few days, and then you say, oh, I really like this, I'm going to keep it, and the idea that the authentication server can enable that model, that's true. Another way of doing that would be after people rent the movie and they pay you some more money, you unlock the DRM completely and give them the work that they've paid for. I mean, you've chosen to implement that based on authentication servers, but you could just as easily provide consumers that work with when they decide to switch from the rental to the purchase, you could strip off the DRM completely. We heard on Friday, I heard it on the MP3s, and we're hearing it again today, that DRM enables new technologies and it provides new options to consumers, right? That it helps consumers out. No consumer is asking for DRM. No one says, please take away my rights. Make technology more difficult for me to use. Consumers are not clamoring and demanding DRM in the marketplace. This is something that the technology firms and the IP holders would like to push down our throats. But this is not about an enabling technology. This is a technology that takes away the ability for consumers to use their works. And so whenever people bump into DRM, there's always a bit of angst and surprise for them. One of the things I forgot to mention before is that, y'all have granted exemptions for dongles in the past. And dongles are expensive, right? They cost $5, $10 each. Software companies use dongles for Photoshop or for, software that costs $200 or $300 or $1,000. They don't use dongles for something that costs 99 cents. And authentication server-based DRM schemes are the dongles of today, right? So dongles are being used less and less because authentication servers provide the same functionality, except that you don't have this physical good that you have to ship out to the consumer and send it in a box, right? And then support it. You have one server that you pay for, and you can provide access to many, many consumers without having to deal with these little USB or serial port dongles. But they're effectively the same thing, except that when a service goes down, the dongles don't stop working. When an authentication service goes down, every consumer loses some of their access rights. Right? But there is a very, very strong comparison that can be made between the dongles and the stuff we're talking about today.
Okay. Thank you.
Mm-hmm. Thank you.
Are you okay? Okay. We're going to start the questioning with David Carson. No, good. Rob? He told me you.
Okay. Well, let me start where you left off, Chris. In discussing dongles and the relationship between those and authentication, one of the differences between, we have had exemptions for dongles in the past, but one of the differences here is that in the case of dongles, we had a significant record of actual problems occurring in the marketplace. And here that is very different situation because, as has been pointed out, there's actually absolutely no evidence of any harm. We have had authentication servers go down, but they have been remedied in all cases. So isn't this a different situation in light of that different marketplace solutions that have been offered?
So I guess I would disagree slightly. So we've seen, say, Google provide refunds. We've seen Yahoo provide refunds. The remedy provided by Walmart was to extend the life of the server. They could just as easily decide a year later to turn that service off. I mean, they're not selling the system anymore. They clearly have no intention to run that server forever. So at some point, they're going to turn it off. I think that there is a strong likelihood that at some point they will turn that service off and will not provide consumers with a refund. So I would say that in that instance, the remedy is probably not 100%. Now you are right in that the harm suffered by consumers in the dongle arena is far more documented than in this instance. But there is a strong parallel between the two, and I would argue that these services have failed. It's just that the companies have been rich enough to provide remedy. But we've already seen that there are companies who've decided, this isn't a model that we want to pursue anymore.
In response to that, if you said that this is likely essentially sometime, we have to deal with particular and look at the likelihood regarding ensuing 3-year periods. Is there any evidence to suggest that this is in fact likely on any kind of significant scale during the next 3-year period?
I think given how bad the economy is right now, I think that can I point to evidence that a company is about to go bankrupt? No, but clearly this is the time in the business cycle where failing products are going to be shut down. I mean, companies cannot afford to subsidize products that lose money anymore. I think in the next 3 years we will see services shut down with no remedy for consumers, with no refunds at all. I think one of the things we're seeing is that when the first service got shut down, I think Yahoo was the first one. I'm not totally sure, but when the first one was shut down, this was a new thing, right? This was consumers who'd purchased works, and they lost everything, and suddenly there was outcry in the blogosphere, and the tech journalists were talking about it, right? And each time this has happened, there's been a little bit less of an outroar, I think. And I think maybe that's because at least the journalists are becoming a bit jaded to it. And you have to recognize that a lot of the pressure here doesn't come from consumers. It comes from journalists calling up the companies and saying, consumers are angry, how do you respond? Right? And as companies continue down this road of shutting down these services, and the journalists themselves get jaded, and this stops becoming a page one story in the tech magazines, I think we're going to see less pressure for the companies to provide refunds. Now, the harm is the same, but the pressure declines. And so, maybe they'll say, we're going to take the hit. Whatever, we'll shut the service down on a Friday afternoon. There'll be a story on Slashdot on Sunday, and by then it'll be over with. I think we will see services that decide that whatever the minor PR hit, it's worth it, in terms of not having to provide $1 million worth of refunds.
Steve or Sandra, do you have any responses to the likelihood of this occurring during the next 3-year period?
Well, I think in the opening comments that I made, I pointed both to the long history of the use of authenticating servers, including through cable TV services where issues like this have not occurred. There are parallels even to the purchase context in cable TV, such as making a DVR copy, which a consumer expects is going to work on their DVR in their home. So I think the long history of experience with companies standing behind their products should give us comfort. I also mentioned the due diligence that we engage in in terms of evaluating companies to whom we license our works to ensure that they have the financial backing and that they have the technical skills to keep services up and running. So I think both of those would weigh against granting an exemption where there's absolutely no evidence in the record that companies have failed and then failed to stand behind their relationships with consumers. I'd also, if I could mention, when Mr. Seguin was making his rebuttal, I guess there are two things that I want to mention. One, he commented on the fact that consumers are unwilling to look to other services to replace their entertainment works when a service goes out of business. And interestingly, that was in the context of talking about how it's necessary to repeatedly replace hardware because hardware fails, and the iPod isn't practical to just get a new battery, so you go out and get a brand new $300, $400 device. So I just found that to be an ironic counterpoint. And I'd also note that I think underlying all of this, all of the comments supporting this exemption, I think it really does get down to what Mr. Seguin was suggesting as the appropriate remedy: just strip off DRM entirely. If that's what these exemptions are aiming towards, is just doing away with the business models that allow different flexible uses. I think that's something that the Copyright Office should take into account as well as you evaluate the evidence in support of and against granting an exemption. So,
sir, can I just say one quick thing, which is, if their company does this, if they make sure that no service that they license their content to is ever in a financial situation where it wouldn't be able to provide remedy, and if these services aren't even going to go bankrupt, where's the harm? If Time Warner only licenses its content to huge companies that will keep their services running forever or will always provide remedy, I'm even okay with y'all narrowing down my exemption request and saying, in the event, for 10A, in the event that the service doesn't provide any remedy for consumers, we allow the following exemption. And that would seem like that would mesh well with Time Warner's concerns, right? Like all of the companies they're licensing their content to are in great financial shape, and they would be totally able to provide remedy to consumers. And if the situation I'm talking to is purely hypothetical because it's only small companies and they don't license their content to small companies, well, let's narrow this down a little bit. I'm willing to compromise, but I think that they are licensing their content to companies that aren't going to provide remedy. So let's find somewhere to agree here.
Well, that's good, because that's one of the issues, and that was my next question, is that there was no limitation in this exemption, as we had in the dongle exemption in the past, that there had to actually be no kind of remedial efforts undertaken or available in the marketplace. Another difference, though, with the dongle situation is that dealt with a specific subcategory of copyrightable authorship. So here, that was computer programs, a subcategory of a class of works, literary class of literary works. Here we have an extremely broad statement of the types of works, and in some ways I think this may be leading to part of the problems even dealing with this that we're having is, what are we really talking about when we're talking about audiovisual sound recordings and software programs? Is there any kind of consistency in the way there is authentication used in all of those different categories of works?
So my understanding is, say, for example, with Apple, that the same DRM scheme is used to protect movies, music, and software. So in that instance, I see the similarity in that it's one system that's being used for everything. Now, with regard to the first part of your question, the reason the dongle exemption is so narrow is because the only product that dongles have been used for is software, right? if you bought a CD and had to plug a dongle in to the side of Narrow, is because the only product that dongles have been used for is software, right? If you bought a CD and had to plug a dongle in to the side of the stereo, maybe people would have come to you and sought a dongle exemption for music too. But the fact is that because of the ease and the price of setting up a DRM authentication server scheme, they're using this for more than software. They're using this for all kinds of works. Anything digital, they're using it for, and which is why I feel that this more broad exemption is necessary.
Do either of you see any kind of problem having this cover those number of classes of works in the case of authentication servers?
Yeah, I mean, yes, we see that as a problem. That's one of the breadth of this is one of the concerns. I think the distinction with dongles, I think Mr. Segoyan referred to it, that the availability of alternatives is limited not only because it's that particular version that's for which the dongle is used is no longer supported, but because that's more generally used for very high-priced items. And I mean, that was certainly the record in this proceeding, and therefore that's a different situation than here with the kinds of stores that we're talking about. I think the problem with Mr. Segoyan's proposed compromise is that he is not satisfied with any of the alternatives that were provided historically by these companies. He's complained in his submission that the ability to burn the music to an MP3 format or to some other format results in an inferior quality track than the one that you originally gained access to. Although there are obviously a lot of ways to get superior quality in most cases. He objects to taking 4 or 5 minutes to create a 60-minute audio CD. That's not fair. That's not an alternative from his perspective. So I think it would just send us down a rat hole of trying to figure out what is an acceptable alternative, and it seems like a fruitless task when you consider that, as I think he's conceded, the harm has not been visited upon anybody yet. There's no record that it's happened, and I think his speculations about the state of the economy, well, let's just say it falls short of demonstrating that it is more likely than not that this will happen in the next 3 years and that no alternative will be provided. I do need to reserve the point that we made before, that for the purposes of this proceeding, the fact that you might have to spend something in order to take advantage of the alternative is not a bar, is not something that gets him over the hump of demonstrating the likelihood of an impact of the prohibition on non-infringing use.
If I could quickly disagree, which is that there is one remedy that I'm very happy with, and while I'm not too keen on people having poor quality CDs of their purchased works, I am very, very happy to take refunds for customers. If a service wants to provide full refund to customers who've been suckered into using one of these stores, they don't need to do anything else. A refund is totally fine.
Leaving aside whether there's proof of any problem occurring, just in getting to your point, Steve, about this being different from the dongle exemption because of the expense of those programs compared to these individual works that may be available in other formats, isn't one of the issues involved here that in the case of these types of works that for which authentication may be needed at a later point, it can typically involve large quantities of works, which when you put those together, actually are probably could be the same amount. We're talking about the same amount of actual investment in these works as was at issue in the dongle situation.
It could involve large quantities of works, but the availability, I mean, the problem with the dongle is in some cases there wasn't any support at all. There's no ability to get back to the status quo, if you will. And that was, I think, the basis for the concern. But here, there's always going to be alternatives. Up till now, there have been alternatives that require little, if any, cost to the consumer. There might be circumstances in which there would be some cost to the consumer.
Well, can you explain that? I'm not sure I follow exactly. I know that there can be, these works could be available in other forms for purchase, and one of the considerations, I don't like to turn this into a dongle discussion, but one of the considerations that was made there was that the offer was given to some of the purchasers of those programs whose hardware locks malfunctioned or no longer operated, was that if they just repurchased the program, they could use it. They could get a new one. And that seemed to be an insufficient remedy in that situation. So here, if someone has a large library of iTunes songs or any kind of a music library, an audiovisual library, and that authentication server fails, is it an adequate remedy to have to repurchase those works in order to be able to just listen to them again?
Well, I'd have to go back and look at the dongle exemption and the reasons that you granted it. My recollection is that the reasons that you granted it were that there was some evidence that there was simply no way other than circumvention in order for people to regain this functionality that they had before.
Well, I believe in some cases there was the opportunity to repurchase the program. So we can look at that, and maybe we'll address that in some kind of follow-up. Ben, did you have something that you wanted to just...
Sure. No, I was going to follow up on your comment about cable, and I just wanted to get clarification. What was the intent of that example, so I can just get it straight?
Oh, sorry. In terms of answering Rob's question about the likelihood of harm in the next 3 years, I was referring to the fact that we have a long history of, in at least one marketplace, of using authenticating servers, and so since there's no record evidence currently about unremedied harm to consumers, and we've got a long history by which to, speculate whether or not there would be harm in the future, that the cable example is one to look to. The other point that I believe I made with respect to cable was more in answer to Mr. Segoyan's kind of rebuttal comments to us, where he said he was, not sure how cable was at all relevant here, since he was talking primarily about works to which a consumer are expected to have permanent access. And in that instance, I was drawing a parallel to making a recording on your DVR, which similarly to other services which are offered on terms of service, as long as you're a customer, or as long as the entity survives, or what have you. It seemed like a parallel worth looking to. So
Let me ask you this as a follow-up to that DVR question. When Time Warner Cable was still part of Time Warner, and I, say hypothetically, subscribed to Home Box Office for the purpose of recording all the shows I want to see, but I wasn't home to see them, and my DVR is full, and then my set-top box crashes, what was the remedy that Time Warner would provide to me as a cable subscriber in case of that happens?
I would have to confirm with Time Warner Cable folks who are no longer part of the company, but I believe the remedy was that you were allowed to, re-download content, but I'm not sure that I'd have to confirm. I know that is a remedy that is often offered in other contexts. For instance, iTunes and other services that we license have the ability to allow a re-downloading of downloaded content if there's a hardware failure. But I honestly I don't know what the remedy was in the case of Time Warner Cable, but I'd be happy to check.
Chris, in terms of the discussion of one of the examples you had was Circuit City's DivX service, and that raises an interesting issue just in terms of what some consumers had purchased were they could purchase these discs for time limited periods and watch a show and then could pay more to get that. Are you focusing your comments in terms of the people who just paid for complete access to the works contained on those discs?
So the question is basically, should people be able to circumvent the encryption on try until you buy and then unlocked works?
Right. So, for the use limited discs, so they owned these discs, but they walked into this arrangement knowing that they were only going to be able to use it one time or for a limited period of time. Should they, because this authentication keeps them from using it more times than they had agreed to, is there any reason why that should not, why they should, even though they continue to have the disks after the servers go down, did they really lose any?
Sorry, I'm still having trouble. So let me just clarify again. So you're talking only not about consumers who paid an additional $15.99 to unlock the disc forever. You're just talking about the instance where they had the $3.99 play for 3 days. You know, should those? Are we discussing just those consumers? Is that right? Just.
How should we handle those consumers?
That's a rental. So,
okay.
If the server fails, that 3-day period is over. So I don't really care about them.
Okay, so it's just the discs that were intended to be completely
just
unlocked.
Purchases.
Okay.
Yeah.
And then, in response to some of the points that Steve made about what is actually going on in terms of what would have to be done in order to conduct research on these systems, can you explain what to your understanding, what would have to?
Sure, and thank you for bringing that up because I forgot to address that point before. I'm glad that I'm going to get a chance to do this. So, I have multiple hats, right? So I care about copyright law and I care about law and policy, but I also have a background in computer security. I have a bachelor's in computer science. I have a master's degree from Hopkins in computer security. I mean, I have the skills, and I've looked at DRM in some instances. I know how this works, and essentially, while the first stage is usually to monitor what's happening on the network, you would do what's called sniffing, which is seeing the packets go back and forth. On a computer, you would run a decompiler of some kind, or you would watch one program send data to another program. So the first stage is essentially monitoring, but then you need to sort of probe the system by trying information out and say, if I get this signal, what do I get in response? So you need to actually, even just to document how the system works, you need to be able to send it signals or to send it commands and see the responses you get. And the minute you start getting in that territory, you're essentially you're definitely engaging in reverse engineering. And when you start to try and unlock content to see if the techniques that you believe you've documented work, you've circumvented the encryption. The line is not solid, and as you get further and further down the road of documenting, the likelihood of you crossing that line just for the purpose of making sure that you have all the information that you would need later is very high.
So to the extent that this begins, once it starts to get to the point of circumvention, begins to get into the realm of reverse engineering, to what extent is this something that Congress, would another computer program have to be created in order to make the works the copies of the works that you had purchased work again? So would this fit within at least the scope of the reverse engineering exemption in Section 1201F?
So I believe that it requires more than reverse engineering.
How so?
So to reverse engineer a program that uses DRM, you need to circumvent the DRM just to figure out how it's working. Now, I'm not a lawyer. I don't have a JD. I've sat in on a couple of classes. So I don't know the ins and outs of 1201. But my understanding from dealing with lawyers in the past is that they don't view the reverse engineering exception to be very wide. And they've always told me to be very, very careful in this area. So I can't speak to the specifics of that rule.
Well, then let's ask the lawyers.
Well, but they have no incentive to be nice to me.
So what do you think? Does it sound like the lawyers have the problem of not understanding the technology?
Right.
So we're even. But what do you think of the?
Well, I think the important thing for this proceeding is that the proponent has the burden of showing that that their activity does not fall within the scope of an exemption that Congress enacted. Whether it's 1201F for 1201J for security testing, there might be other exceptions that would be potentially applicable here. But I think it's clear from the way that this proceeding has been handled over the past decade that obviously in order to make your case that you want an exemption, you have to show that your activity is prohibited by 1201A and 1201A1, and you can't show that if it falls within an exemption. So you have to demonstrate that your activity does not fall within the exemption, really can't be brought within the exemption. So that's the burden that the proponent would have here, and I'm learning more each day about what Chris would need to do in order to under his 10B exemption. There wasn't much about it in the submission. There's been a little more today. I certainly don't have enough facts to be able to render any opinion on it, but I think the question of the applicability of a statutory exemption is potentially a relevant one, and the relevance is that unless the proponent can show that it does not apply, then I think that pretty much seals the fate of that particular exemption.
If I can draw a parallel, Rob, we noted this in our comments. You guys already gave Alex Halderman and Ed Felton an exemption 3 years ago for security testing, or for rootkits in CDs, right? And the research that they were doing to document and discover any security flaws in those DRM schemes is the same. What they were going through, it's the exact same process that people would need to go through. I mean, essentially, documenting and discovering how a system works, it's the same no matter what kind of system it is, whether it's a rootkit, whether it's DRM, whether it's a security flaw, whether it's an authentication server. From the perspective as a computer scientist, you go through the same process, and you all already gave that exemption to them. So, and the reason was because you felt that the reverse engineering rule was not enough in that instance, I believe.
I'd have to object to that characterization of that exemption, but I think the relevant point there is that exemption was issued after a detailed record. There had already been an exhaustive investigation by Professors Felton and Halderman into the rootkit. That was the basis upon which the exemption was granted. So the record there showed harm to the satisfaction of the Copyright Office, and the record here clearly does not. I would like to, if I could just supplement my answer about the dongles exception. Going back and looking at the text of the exception that you recognized 3 years ago, or in 2006, it only applies to obsolete dongles, and a dongle shall be considered obsolete if it is no longer manufactured or if a replacement or repair is no longer reasonably available in the commercial marketplace. So clearly, the idea that if you could go out and find a replacement dongle and get back to the status quo in the commercial marketplace, if it was reasonably available, was not what. If that were the case, then the exemption would not apply.
And that was the issue: is that the sale of a reasonable price for replacement of the dongle was often not available. What was requested was the purchase price of the full program. So that the question of whether that was reasonable and that was the issue. statute to actually have to buy a high price. But
Well, there's nothing in your discussion of this in the November 17th, 2006 recommendation that even, I could see, even refers to the cost of getting the upgrade, which I think is what you're talking about. Your conclusion was, evidence was presented that damaged or malfunctioning dongles can prevent authorized access to the protected software, because in some instances the software vendors may be unresponsive or have gone out of business. The evidence painted a compelling picture of a genuine problem. So that was a problem where you couldn't get the dongle for love or money, and therefore you couldn't get back to the status quo without regard to whether you would get the upgrade. Here, you can get back to the status quo. Up till now, you've been able to get back to the status quo without any expense, but even if there were some expense, I don't think that would be a distinguishing difference.
Chris, this may be going over some ground you've already covered, but I just want to make sure I understand the case you're making here. And let's break it down. One of the things we need to determine is whether persons who are users of copyrighted works are, in other words, already have been, adversely affected by the prohibition on circumvention and their ability to make non-infringing uses. I think what I'm hearing from you, but I want to make sure, is that you're not saying that up till now people have been adversely affected, because up till now you think people have been, when these services have gone down, people have been given acceptable substitutes. Is that a fair characterization so far?
So in the instances of failed DRM services that we are aware of, that we noted in our comments, in all but one instance, refunds were given.
Okay.
And a refund is a totally appropriate and satisfactory remedy.
Okay. And the one instance, remind me again of that.
That was Walmart, and Walmart, under pressure, agreed to extend the life of its server for an undetermined period of time.
So far, no one's been adversely affected.
So far, no one has been adversely affected.
So basically, you're on the second prong, which is you're predicting that within the next 3 years it's going to happen.
I'm predicting that companies will not be in a position
Right.
to offer those remedies.
Right. Now, you can't identify any particular company that you're predicting is going to be in that position. Is that correct?
I'm not telepathic, or I don't have a crystal ball. So, no, I have no idea which service will go under, but we've seen enough services go under in the last few years that I think there's a good chance that one will go under, and I think there's a very, very good chance that one will go under which doesn't have the means to provide a remedy to consumers.
So to the extent that we're trying to predict and determine, is it more likely than not that this is going to happen, I think what your case is, hard times economically, a number of services have already gone out of business. So far, they've been big enough to be able to cover the problem,
right.
But chances are that within the next 3 years, it's going to happen to some service that doesn't have the resources or the will to do the kinds of things that have been done thus far.
And I'd like to stress that if no service goes under, then the exemption won't cause anyone any harm.
Okay. Sandra and Steve, you didn't quite put it this way, but I sort of get the impression that between the lines of what you said, what you're saying about the kinds of services you've been talking about is that the consumer may think he or she has purchased a copy, but he's really just renting a copy. Is that really what it boils down to?
I don't think that's what I'm saying. I don't want to get into rental versus purchase, but I think that their rights are defined in the terms of service. So when Mr. Segoyan refers to the usage rights that they paid for, he's really talking about what's in the terms of service, and in most cases, those make it clear that their access might not be perpetual.
So whatever they're paying for, they're paying for whatever your clients are willing and able to give them, and your clients, for whatever reason, might at some point decide, sorry, whatever you paid for, you no longer have, and that's just the way the contract's written. So that's what they're stuck with. Is that basically what it is, to put it starkly?
I wouldn't put it that starkly.
I'm sure you wouldn't, but is that what it is?
No, I think that in terms of this proceeding, whether they're able to make a non-infringing use, the parameters of that are defined by the agreement that they've entered into.
Now, I know
they also have other alternative ways of making the non-infringing use, but in terms of making the non-infringing use with the company that they've originally licensed with, yes, it is limited by what's in the terms of service. Now, purchase and rental obviously have a lot of other connotations, and It could have tax connotations, as could obviously has connotations for other aspects of the copyright law. So I wouldn't want to get into making pronouncements about how all of these services operate. It's possible that there are some services that don't, in their terms of service, spell out that the access might not be perpetual. And in that case, you might have a different situation.
Is anyone before us, any of the three of you, aware of any such services where the terms of services don't limit the consumer's continued right to continue to use the works? Okay. I haven't looked at the entire record. Do we have examples, at least, in the record of terms of service?
We have some examples cited in our submission. I don't think we went to every single one.
So you are another consumer who apparently hasn't read the terms of service either.
I wonder whether Steve and Sandra read the terms of service when they sign up for these things. No, I don't.
Right. So as I mentioned before, I'm not a lawyer, but luckily I did bring a law student with me. And I've been informed that the 1201F reverse engineering exemption exception only applies to computer programs and not AV content, so it doesn't apply to music or movies.
Okay. And also, I think, Stephen Sanders, your position that it's really not our business, it's the FTC's business if these terms of service don't really bring home to the consumer what he or she isn't really getting. That's nothing we should be worrying about, right?
I think that's essentially a consumer protection issue, and one that, as we've noted, they've been taking a look at in terms of the disclosures and so forth. But I think there is a valid agreement that's entered into legally.
Okay. Tell me this, then. Looking at the statutory factors we're supposed to look at, if someone who was a subscriber to one of these services, which suddenly terminated the service, were to circumvent whatever access controls are on the works they've downloaded, say, in order to be able to continue to use it, what effect would that have on the market for or the value of the copyrighted works?
Well, I think you have to be concerned about the knock-on effects here, and
I'm sorry, the what effects?
Well, the effects going down the road. It wouldn't necessarily have any impact on those copies, but in terms of the willingness and interest of copyright owners and distributors to initiate these types of authentication server-based services, and with all the benefits that they bring, I would think it would make a difference. I think this was Sandra's testimony. If in fact there was permission granted by the Copyright Office, or rather by the librarian, to circumvent those access controls because they related to authentication servers, which might go out of business, that would certainly be a discouraging factor in terms of the dissemination of the works, and it would therefore have an effect on the value of the work in the marketplace. It could be that the cost to consumers would go up because we would be back more to a binary situation in which you either have access to it or you don't. And in that case, I think the economists would say that if you're allowing access, you have to assume that it's totally unlimited access and you have to charge accordingly. The value of the authentication server, I think, as Sandra has indicated and as we tried to spell out in our submission, is that it allows for more of a spectrum for granting some rights, for even expanding the scope of those rights during the life of the relationship. And that means that people can buy what they want or what they feel they need rather than having to buy total unrestricted access to the material. So I think in the long run it would probably increase the costs, and whether that would hurt the value in the marketplace would really depend on how many people were discouraged from even entering into the transaction because the costs were much higher.
Do you think
to underline what Steve was saying, I think it's not also easy to separate the so-called permanent download versus the so-called rental model in terms of if you've hacked or circumvented the authenticating server technology, you may very well have circumvented it for all offerings. So while you may want to make the point that if somebody already has purchased, permanent access to a work in their collection, that collection may also contain a number of works for which they've purchased only limited access, and when you circumvent the access control method that applies to that delivery system, you circumvent it more than likely for all types of access.
Well, that's true with any exemption we give, isn't it? I mean, if we say you can only circumvent with respect to a particular class of works, we're not giving permission to circumvent for other works as well. So if someone goes beyond the permitted class, then that's not it's not because of the exemption, and it's not lawful either, is it?
I agree, it's not lawful, and it's beyond the scope of the exemption. But in the real world, the effect is...
Well, the real world is happening whether we give the exemption or not, isn't it?
Well, this is one reason why we've suggested that in this in the environment now where the office is making more use of descriptions or definitions of users or uses in order to define these classes, that it's important, first of all, to emphasize that the exemption applies only when the sole purpose of it is to carry out the particular non-infringing use that gave rise to the exemption. And also we feel to exclude the situation in which there's an effect, foreseeable effect, that it will sweep more broadly. That's a more general concern that we have about the way the exemptions are fashioned, and that would and if in the case if you felt that there was justification for exemption in this area, we would certainly want those safeguards.
And just to complete what I started saying, in the real world, the evaluations that we make when we offer a new business model and offer different functionalities on top of that business model is a balancing between whether your exemption is intended to grant it or not, is our work going to be put at risk? And when we look at models and at technologies that are presented to us, there certainly are instances where we have elected not to license into a particular model because we feel that the work is put at too great of a risk. So it will, I would argue, diminish the availability of these sorts of additional functionalities that consumers have been looking for, and it would diminish the flexibility that we have in offering and pricing works appropriately to consumers, so they're paying for just what they want and not having to pay for the full work.
Let's say that the only thing that were on the table was this exemption, but dealing only with lawfully purchased sound recordings. Now, we seem to be at a point in time now where sound recordings are now offered without DRM. That seems to be, at least at this point in time, where the industry is. So let's say you've got a service that has traditionally been offering sound recordings using these authentication servers, and you have the scenario that Chris is worried about. It goes out of business. It doesn't offer continued access. You've got these encrypted copies or protected by whatever they are on your hard drive, and they're things that are, in fact, freely available. Well, not freely available. You have to pay for them. What's the harm in letting the person who has this copy that is protected on his device strip that protection off of it when it's being offered to the general public without that protection anyway?
Well, I think I don't know the details of what Yahoo planned to do, but I do think there was some transition that they were offering for people who had previously accessed the DRM-dependent sound recordings to transition to DRM-free. So, but you're talking about a hypothetical situation in which they walk away and DRM-free versions are available in the marketplace.
Well, let's assume we agree that with Chris's prediction that it's going to happen in the next 3 years. One of these services is just going to go totally out of business, not offer anything to its subscribers. And let's say it's purely a music service. That's the situation we're talking about.
Well,
what's the harm in letting the people...
I would suspect that the pricing has been different in the offer, that if you've offered a download of a non-protected work through iTunes or what have you, the pricing is higher than it is for a DRM-protected work, perhaps.
Well, iTunes was offering DRM-protected works for quite some time. Did the prices go down when they stopped offering DRM-protected works?
I believe the prices went up. There was a...
Yeah.
Was there a cause and effect relationship there?
You're paying more for an unprotected work than you do for a DRM-protected work.
And that's precisely because the protection's been removed? Is that why that happened?
Right. I mean, that's at least in theory you would say so, because you're basically enabling a lot of other uses that weren't enabled before, and those are going to displace some of the purchases that you might otherwise have had. So you would expect the prices to be higher. Whether the marketplace actually works that way, I mean, I don't know, but that's certainly what you would expect in that situation. But I think if you're asking the question, is it more in accordance with what Congress intended, that people, if they in that situation go out and buy the DRM-free tracks, or whether they be able to create and use a hacking tool in order to get to exactly the same point? I think I think the intention would be the former.
Well, I guess my question was, where's the harm? That's my question. Where's the harm?
Well, I think the harm, as it is with all of these, I know you asked this question in a different form on Friday as well.
I'll probably ask it tomorrow and the next day too, several times.
All I can say is that there certainly is harm that Congress was sensitive to encouraging the development and proliferation of a market in circumvention tools. And one way to prevent that was to have the prohibition on, in effect, use of those tools. I mean, I realize this doesn't match up exactly symmetrically between the tools provisions and the prohibition. Excuse me. But the idea was to limit the use of circumvention tools to two circumstances. One, those circumstances where Congress had explored the issue and struck the balance of when circumvention would be allowed, and that's, for example, in the reverse engineering area and in the other statutory exemptions. And then in the circumstance that brings you here, which is when the statutory requirements were met for showing that there actually had been a significant interference with non-infringing use. And here, I don't think you would see that interference with non-infringing use. So you would see, in effect, a proliferation of circumvention tools and giving the government's imprimatur to the use of circumvention tools in a much broader range of circumstances. That, I think, would be harmful to copyright owners and to the copyright system.
And I think the other aspect of harm worth considering is that these services that offer unprotected, works for free or for, whatever the pricing arrangement is, the model for each such offering is kind of negotiated in the whole and understood in the whole. So perhaps you're offering access to a work for free, but you're doing it because it's ad-supported, or you're doing it because it's, surrounded by some promotional agreement that you have with the third party through which you're making the work available for free. If the consumer is able to unlock the work that they brought through a different business model, which was intended to be a protected download, and it has no need to go to the, free legal service that's ad-supported or, a promotional effort or what have you, then I think that is cognizable harm. There is a business reason for negotiating that distribution arrangement, and the copyright owner is deprived of whether it's the advertising revenue or the interaction with the consumer on a new platform and the ability to, expose different of its offerings to the consumer.
Yeah, I wanted to answer your question, which is that Apple just recently announced that they would have songs at different pricing tiers, something that the record companies have asked for some time. Before that happened, there was a period where there was DRM free available. Songs are available in MP3 format with no DR, or maybe AAC, which is Apple's system of choice, but no DRM at all for 99 cents. So there was a period in time where some labels had allowed Apple to sell content with no DRM at all, and the price was the same as it was the year before when there was DRM. And also at the same time, even while Apple was selling DRM encumbered songs, Amazon was selling stuff for the same price or sometimes less in MP3 format. So just to clarify that question of yours.
Again, those are negotiations that occur around a particular business offering, and so I can't speak to what the record labels do in terms of negotiating those deals, but I suspect that if they're anything like us, they look at all of the parameters of the offering, and they probably have a different deal with Amazon that results in a different price for that offering than they do, for iTunes or whoever else is in the marketplace offering that service. The fact that the copyright owner was actually able to negotiate a higher price for the sound recordings that were made available without DRM protection recently, I think, indicates that there are those sorts of negotiations going on, and there is a trend in the marketplace to value protected versus unprotected works differently, at least by some copyright owners.
I think it's also indicative of the fact that the hallmark of this market is experimentation. I think a lot of copyright owners are feeling their way and trying to figure out what is the best way to deliver this to consumers in a way that's profitable and that meets consumer needs. So you're going to see some shifting and back and forth on this. To me, that argues for a great deal of caution in recognizing exemptions here, because you would be basically subjecting, if you had an exemption that allowed circumvention of the authentication server model, if you will, you'd be freezing that in place, at least for a 3-year period, and and discouraging the experimentation that's needed.
On the topic of harm, and this maybe isn't as directly to the copyright owner, or not solely to the copyright owner, I should say. If you're talking about authenticating servers, and particularly the sorts of functionalities that I was speaking about in my presentation, oftentimes you may have consumer financial information, as part of that transaction with the authenticating server, and so there's harm to potentially a consumer if you're allowing people to circumvent and circulate tools to circumvent authenticating servers, if the server is carrying financial information or other private data.
Hang on a second. So consumers are going to suffer harm because they're getting access to their own financial information? Because we're talking about a situation where the server is no longer functioning anymore, right? So there's no private information that's floating around on the internet.
You're talking also about an exemption where you're requesting the ability to create tools and circulate tools that allow you to circumvent the authenticating server that is operating.
This is the second proposal,
right.
In other words.
But I can imagine a situation in which you actually would have one consumer's financial information being put at risk by another consumer that is using a tool to gain access to work within their own home. For instance, if you one of the things that we do through Xbox is to allow consumers to access their content from different locations. So I may have purchased a movie at my home, and now I want to go to my friend's home and watch that movie. I can sign on through an authenticating server, and by use of whatever private data authenticates me to the server, I can get access to the movie that I've purchased and watch it at my friend's home. Now, if I leave and my friend has the ability to use either the tools or has an ability to circumvent the authenticating server to gain access to that movie after I've left, they may be gaining access both to my, whether it's my credit card information that verifies me to the company or my private data that otherwise verifies me to the company.
So I do research in data breaches and privacy as well, and no company would be allowed to send credit card information back and forth as part of an authentication scheme. That would violate the PCI rules for credit card companies. I mean, what would happen would be Microsoft would keep your credit card details on file. You would pass your username back and forth or something like that. But in no instance is any company ever passing credit card information back and forth to authenticate some purchased work. I mean, this is not happening. So I think that's a theoretical harm. If even that, this is bogus.
Let me just move on to one other topic. I think the answer is probably no, but I just want to make sure we've covered it. Is there any reason to believe that the exemption in 1201G for encryption research might be relevant to this kind of activity?
I would think it would be relevant to 10B.
And potentially available?
Potentially available, and I think the issue is whether the proponent can demonstrate that it's not available and they can't bring their activities within it and achieve their goal.
Any comments on that, Chris?
I'm not enough of an expert.
Okay. Are we really talking about encryption here, or are we talking about something different?
We're talking about the encryption that's surrounding these services. But my understanding is that breaking or even documenting the DRM involves more than just the encryption. In some cases, that would still be considered to be DRM. So.
Okay, you might get a follow-up question.
That's fine. If you send me a follow-up question, I can sit down with lawyers and I'll do my technical stuff and they'll do the legal stuff, and we can get you a better answer there.
Okay, good. All right, that's it. Thanks.
I want to ask about alternatives again. I apologize for begrudging this issue, but do you think it's useful for us to establish a uniform test for determining potential alternatives, where we can look at a spectrum where it would be easy and free, and that would be an alternative, versus difficult and hard for the consumer? I'm just trying to put this in some way that we can apply it in practice for not only this, but the other exemptions we have, and I just want to get your feelings on how to do that in a standardized way.
I'm not sure that I understand your question.
Well, I mean, we're all talking about whether or not you can go to another store and get the same merchandise that you've purchased before, and then you have to go buy it again, or you have to buy equipment to get that done, or some other way that makes it more expensive and more cumbersome to get what you had already gotten, but for the fact that if you circumvent it, you don't have to go through that expense and difficulty. So I'm just trying to establish some sort of legal paradigm by which to look at these alternatives in a objective way.
May I suggest something on that? I think if you go back and look at your previous 3 recommendations, you will find you've kind of developed a common law of this about what constitutes an acceptable alternative. In other words, a means of carrying out the non-infringing use that obviates the need for circumvention. It's not hard and fast, and it's stated in terms, in more general terms of some of the factors you would look at. But I would think between that and between what's in the legislative history that you're given, that it can't be a mere inconvenience, for example, and that
right, because some of those words are so, I say, squishy that I was just trying to figure out something a little bit more concrete.
I guess I object to the premise of the proposal, really, because, as we were discussing, I find it troubling that consumers are willing to buy, new iPods or new PCs and replace that sort of hardware every couple of years, realizing that nothing lasts forever, and that when it comes to, our efforts to enable new digital delivery models, we're supposed to ensure that the third parties to which we license works are going to remain in business forever, service the consumers appropriately forever, and if they don't, the remedy is somehow on us as the owners of the copyrighted works to provide, and I just find that troubling. I said in my testimony that we take concrete steps to ensure that the people that we license are actually standing behind the agreements that they enter into with consumers. But I think it's kind of a misplaced burden here. The way that the discussion is evolving.
I just had 2 quick questions. One having to do with, Chris, you're not advocating in terms of this particular, the second exemption, the ability to circumvent tools. This is to document the information that would potentially enable accomplishment of circumvention, but not distributing tools for that purpose, right?
That's correct. I'm not advocating that anyone should create tools. I'm not advocating that you guys should allow people. I don't think you have the authority to allow people to create tools, or I don't think you do, at least. This is solely documenting information so that if the service fails, consumers are able to then get to the works that they paid for. Just information getting for documentation purposes.
So that the documentation is preserved.
Exactly.
At that point.
Because it disappears.
Is that, I was hearing something different, I thought, Steve, from that this was somehow encouraging the creation of tools over what may exist without an exemption.
Well, I think that's really what Chris was saying up until about 90 seconds ago. What he said in his submission was the reason that they need this exemption 10B is because consumers don't have the information or technical skills necessary to circumvent a failed DRM scheme. So that you have to study, test, and document the schemes in case they fail in the future. There's a bit of a gap there, but I mean, unless either you're studying, testing, and documenting these for pure research purposes, or you're doing it so that if and when the service fails, or perhaps before the service fails, so that no one will be taken by surprise, there's a tool available.
But documenting something and then later having that information available to make tools for which there would exist an action, independent action that couldn't be covered by the exemption, right, for 1201A2. There could be an action brought under that if someone were to make a tool, correct?
I guess the question is, if the end purpose is to create a tool which is unlawful under the DMCA, then why would it be in the Copyright Office's purview to grant an exemption that allows someone to prepare to make that tool?
Well, that would be assuming the practical inability of consumers to effectuate the exemption, wouldn't it? So it would mean that the practical reality is that no one could use the exemption without the creation of a tool.
Like in every other exemption that's been given.
Okay. Well, one other question is the practical effect in the 3-year period here. If in the absence of any established harm up to date, an exemption, register were to recommend an exemption to the librarian, how wouldn't this in effect be a perpetual exemption? I mean, could the situation ever change after this point? Well, let me leave it at that.
Are you saying essentially that because there's a chance that a service would always fail in the future, that this could go forever?
Right.
I think that we're going to see more and more. The remaining stores that are still doing DRM and music are going to finally give up. And so I think maybe 3 or 6 years down the road, you could restrict this solely to maybe video or solely to games. That once enough consumers, once consumers have completely ditched DRM and music, maybe the services have actually gone bankrupt, and those companies have given some remedy to consumers. All the consumers have been moved away from those old DRM schemes in music. Maybe we wouldn't need that anymore. But if services are going to go down this path of offering this business model, I think as long as companies are doing that and this risk exists to consumers, we should have this option available. And maybe that lasts for the next 20 years if companies are following that business model for the next 20 years.
Well, we would certainly disagree that this proceeding should be in the business of discouraging this business model by imposing this perpetual or 20-year burden on it. We think this is exactly the kind of business model that Congress intended to encourage. It's given people more access to more works in more ways with more flexibility than certainly anything that existed in 1998. It's a big step forward for consumers, and we don't think that saddling it with this type of perpetual or near perpetual exemption would be appropriate.
Okay. That concludes this morning's portion of the hearing, and we will resume at 1:15, 1 hour from now. Some of us will.
Hopefully to rest and recuperate, and we're hoping she'll feel better and be with us in the morning. Rather than reread the opening statement that the Register made at the beginning of this morning's hearing, I'm just making sure that each of the witnesses has a copy of it. It just gives an overview of what we're here for, but I imagine the majority of the witnesses, at least who are sitting at the table, know what they're here for, and we'll proceed. We're here this afternoon to discuss a series of related proposed exemptions. I think it's 8 in total, all variations on a theme. And rather than read each of the proposals, I think it will come out in the course of the testimony, I'll just read the exemption that was issued 3 years ago, because I think each of the proposed exemptions we have here are, as I said, variations on that theme. That exemption was for audiovisual works included in the educational library of a college or university's film or media studies department when circumvention is accomplished for the purpose of making compilations of portions of those works for educational use in the classroom by media studies or film professors. Let me introduce first the panel. I'm David Carson. I'm the Copyright Office General Counsel. To my left is Rob Kasanick, an Assistant General Counsel and Principal Legal Advisor. To his left is Ben Golant, who is also an Assistant General Counsel and Principal Legal Advisor. And to my right is Chris Weston, who's an Attorney Advisor, all in the Office of the General Counsel. While the registrar's not here, she will have access to the transcripts. And maybe Chris Segoyan can point us out to where he found the MP3 tapes of last Friday's hearing, and maybe she'll be able to listen to MP3 recordings of today's hearing, too, pretty soon, for all we know.
We will have audio, too.
Okay. Let me introduce our witnesses, and I believe we're going to go in the following order. We'll start with Peter DeCherny of the University of Pennsylvania, followed by, all right, Rob, what did you say is the second one? Oh, Jonathan Band, okay, of the American Library Association. We're speaking for the American Library Association and Association of Research Libraries. Followed by Renee Hobbs of Temple University, Jeff Clark of the Consortium of College and University Media Centers, Roger Skalbeck of the American Association of Law Libraries, the Medical Library Association, and the Special Libraries Association, Carlton Jackson of the University of Maryland Film and Film Studies Initiative, the Martine Courant-Rife, Fritz Attaway, the Motion Picture Association of America, and Fritz, you're accompanied by someone whose name I don't have? Dan Seymour, okay, also with MPAA, I gather, okay. And is that it, Rob? Or is there a number? Oh, no, there's a... Sorry, I've got a list that's out of order, and Rob's put numbers next to them, and I'm having a hard time following the order. Oh, Steve Metalitz, I've heard of him. He's been at every one of our sessions so far as a witness for what we're calling the joint commenters, a number of copyright owners. And finally, no, not finally, okay, Bruce Turnbull of the DVD Copy Control Association, Inc., and at about 8 p.m. we'll get to Sandra A. Stars of Time Warner. That is quite a lineup. We do have the whole afternoon if we need it, and heaven forbid, maybe the evening, but let's hope not. So let's get started with Mr. DeCherny.
Thank you. Members of the Copyright Office, let me begin by thanking you for granting the exemption for film and media studies professors in the 2006 rulemaking. The exemption has enabled media professors to teach much more efficiently and effectively with digital media, and it has made a palpable difference in the educational experience of thousands of students. In a survey of members of the Society for Cinema and Media Studies conducted in 2007, 62% of faculty members said that they made clip compilations for use in classes. I assume that number is the number of professors benefiting from the exemption is now much higher. It's also significant that the Society for Cinema and Media Studies and the International Communication Association, the two leading professional organizations for media professors, have joined as co-petitioners in this rulemaking, demonstrating both broad support within the field for the renewal and expansion of the exemption. I was also very happy to read that none of the reply commenters opposes the renewal of the exemption or even its expansion to include all university library copies, as opposed to just those copies in departmental libraries. This expansion will allow media professors who have access to university libraries but who do not possess departmental libraries to take advantage of the exemption. Yet this expansion would still limit the class of works, I think, to media purchased by university libraries with pedagogical or research interests in mind. I'd like to use my time this afternoon to reiterate briefly why, first, licensing, I think, is not a valid option for educational uses, to clarify why students need a similar exemption, and to lend enthusiastic support to the other Category 4 proposals. So first, in response to the suggestion of several of the reply commenters, I want to explain why licensing of any kind, or any kind of permission system, that is inappropriate for teaching. The Motion Picture Association of America has discussed assembling a selective clipped library in conjunction with the University of Southern California. This is an interesting proposal, but it's one that clearly remains at a very speculative stage. I contacted a number of faculty members at the USC School of Cinematic Arts, and none of them had heard about the venture. I also attempted to contact the USC deans, but they did not respond to inquiries about the proposal from me or from members of the USC faculty. I look forward to seeing if this project progresses further, but it's clearly at too tentative a stage right now to be a factor in the current rulemaking. Time Warner proposes a much more elaborate regime in which professors would ask permission every time we need to use clips in a classroom. This is a system that was proposed in the 2006 rulemaking and discussed pretty extensively then, and it did not have a bearing on the final ruling. I don't think it should be considered as an alternative during this rulemaking either. There are many reasons to reject the introduction of licensing into the classroom. The most important is that such a system could turn into a form of censorship. Time Warner would be placed in the position of having to answer to its stockholders about why the company either condoned or prohibited the use of clips in classes. What would happen if its stockholders or board members found university course descriptions confounding or confusing or even offensive? They wouldn't be the first. Right? Should Time Warner stockholders be allowed to decide if a Batman clip, just for example, may be used in a course on queer images in mass media or a course on the excesses of consumer culture? A clip licensing system, I think, would be an unnecessary and potentially dangerous intrusion of corporate interests into education. In addition, as the exhibits submitted by Time Warner demonstrate very clearly, licensing clips for classroom use is currently a labyrinthine and confusing process. In one example cited in the Time Warner comment, the company's representative correctly told a professor that his use of an unprotected analog clip from The Wizard of Oz most likely fell within the Section 110 classroom exception. He did not need permission. Yet the Time Warner representative insisted, fallaciously I think, that the professor still needed to contact the Screen Actors Guild to obtain permission from all the performers who appeared in the clip. As an aside, I would also mention that one of the performers, the two performers in the scene in question, was never a member of SAG. Totally. So the joint commenters, with the support of others, also suggest limiting the current exemption further. They recommend limiting the exemption only to DVDs. Such an exemption would discriminate against educators who teach works that are only available in protected formats other than DVD. Television material, for example, is increasingly available as protected online streams long before it is available on disc. Moreover, the goal in many media studies classrooms is to teach students about the experience and aesthetics of theatrical projection. In these cases, even Blu-ray, which contains only a fraction of the resolution of projected film, is still only an imperfect substitute. The joint commenters also suggest limiting the exemption to instances when, quote, all existing digital copies of a work contain access controls that prevent the creation of clips. And their comment recommends Hulu.com as a site that allows for clip creation of encrypted digital copies. I would argue that this additional condition would place an impossible burden on professors, who could never be sure that they had searched every possible outlet. And further, sites like Hulu.com are moving targets, making it virtually impossible to know if all alternative options have been exhausted. Television shows and movies are uploaded and removed from Hulu and other sites regularly. Not only does the availability of videos expire, but they can also be casualties of unexpected changes in licensing deals or network policies. This is what happened in January when the FX channel pulled the, I can assure you, ironically titled It's Always Sunny in Philadelphia, from Hulu, right, without warning. So again, the decision of corporations and the capriciousness of the market should not be able to determine the content of education. This addition to the proposed class, I think, would add a giant barrier around the use of the exemption. Let me turn to the most important element of our proposal, the creation of an exemption for student work. As we demonstrated in our two written comments and in our audiovisual submission, use of multimedia clips in student assignments is a widespread practice in media studies classrooms. And for all of the reasons that faculty need access to high-quality images, students need them as well. Students need to use clips in class when they're doing oral presentations, a very common assignment. In that SCMS study that I mentioned earlier, 63% of media studies faculty said that they assign in-class presentations that involve the use of clips. Like faculty, students need to be able to use their pedagogical time efficiently. They need to be able to create transformative works by mixing clips with text, still images, and occasionally additional clips in the same slide. And of course, students need to show high-quality images to illustrate the detail of the clips they're analyzing. Increasingly, students need to use digital clips when assembling video essays, a form of assignment that becomes more common every semester. Not only do professors now assign video essays to replace some forms of writing assignments, but many professional critics have moved from print to visual essays, including the former New York Times critic Matt Zoller cites. It is for the creation of visual essays to fulfill course assignments that students have the greatest need for high-quality digital clips. One of my colleagues, for example, has his students annotate clips in his Mexican cinema course. The students add voiceover narration discussing the visual style or performance in a scene. I was taken aback by another example presented to me by a different colleague just this week. 4 students created a short video essay on media violence in children. They used the audio of a decade-old lecture by media scholar George Gerbner, and they illustrated it with clips from recent animated and live-action films, including Family Guy, Saving Private Ryan, and Kill Bill. What surprised me is that the student video essay was ineffective. It wasn't ineffective because it was poorly edited or conceived, just the opposite. It wasn't ineffective because Gerbner's thoughts on violence were outdated, though that may very well be true. We couldn't even get far enough to discuss the content. The video essay was ineffective because the students used over-the-air broadcasts and YouTube clips as illustrations. The power of blood spewing from a severed arm and the impact of a gun being placed in a young boy's mouth were nullified by the muddy, pixelated images that they had to use. It was a clear case, and one that I wouldn't have thought of, in which high-quality digital clips were absolutely necessary. Another question that came to mind is, how do you grade a project that's smart, thoughtful, and well executed, but ultimately ineffective because students were not allowed to use the material they needed? I would go so far as to say that you cannot be a 21st century student of media without being able to use clips to illustrate classroom presentations and in essays. The only arguments made against this new class are, I think, unconvincing. In its comment, the MPAA suggests that the increased scale of class presentations of the class represented by the proposal will, quote, pose substantial enforcement problems. Yet in the same paragraph, they conclude that, quote, there have been few, if any, known abuses of the 2006 media professors exemption because, quote, faculty members' status provides strong incentive to act responsibly. I would just point out that the same responsible faculty members would be administering and overseeing the student assignments. Rather than an opportunity to blur the lines between legal and illegal decryption, as the MPAA suggests, I think this is exactly the place that students should be learning about the contours and indeed the boundaries of fair use and the DMCA. In closing, I'd like to add my support to the other Category 4 exemption proposals. I think it made sense to limit the exemption to media professors in 2006 since we only had evidence of media professors' practices and needs. But we now have compelling stories from educators who span disciplines, institutions, and levels of instruction. It seems clear that language professors, history professors, and many others need to create clips in order to use classroom time efficiently and to be able to teach with the detail and precision offered by high-quality images. Moreover, if professors need to circumvent encryption, I can't see the logic of excluding K-12 teachers. The teaching exemption should clearly be extended across disciplines and levels. So in conclusion, I would urge you to consider expanding the current exemption to include media students as well as professors, and I hope you'll be as persuaded as I have been by the other Category 4 proposals. Thank you.
Thank you. Jonathan?
Thank you very much. I am Jonathan Band, and I'm testifying today on behalf of the American Library Association, the Association of College and Research Libraries, and the Association of Research Libraries. The MPAA and the joint commenters in the reply comments concede that they have no objection to the substance of the existing film clip exemption. They also concede that they do not object to the exemption's application to DVDs found in any library on campus, not just the Film Studies Library. So the only remaining question is whether the exemption can be used just for film and media study classes or all classes at an institution of higher education. The rights holder's primary objection to extending the exemption to all classes is the assertion that only film classes need the high quality that results from a digital copy made after circumventing the CSS encryption. In making this assertion, the right holders completely ignore our submission that, quote, and this is in our opening comments, sound quality is critical in language classes to ensure that students can understand the dialogue and detect dialectical differences. Music and theater classes need high-quality sound to reflect correctly the tone of musical instruments or the inflection of the human voice. High image quality enables students to see the nuances of facial expressions and hand gestures. These subtle, nonverbal forms of communication may convey the essential point of a clip used in psychology, sociology, or literature classes, end quote. Further underscoring the importance of high-quality images is the following statement from Paul Clark, who teaches criminal justice classes at the North Central Technical College in Wausau, Wisconsin. Quote, police officers must develop a variety of skills, including observing behavior, correctly interpreting it, and recognizing its significance in order to make appropriate decisions about actions they take. There are a variety of ways to conduct this type of training, but using professionally developed video, Hollywood feature films, yields a cost-effective and time-effective way to provide groups of students with the same audio and visual stimulus as they observe, as they practice observation and interpretation. Take the film Tombstone, for example. The scene leading up to the shootout at the OK Corral is overflowing with body language and emotion. One exercise I have students work on in class is to watch the scene for purposes of observing the facial expressions and body language of the characters in order to determine the underlying emotion. They then decipher what specific mannerisms lead them to the conclusions they've drawn. It's not enough for a police officer to simply report that a suspect was nervous. He or she needs to describe with the specific behaviors observed as the basis for the conclusion. Most of us are unconsciously competent at making these judgments, but an officer must be able to describe the observations that give rise to the belief if they are going to use that belief as a proper basis of police action. Because top actors are excellent at accurately portraying the nonverbal elements of communication, feature films are an excellent tool for these exercises, close quote. In sum, high-quality sound and images are important for classes in all disciplines, not just film classes. The rights holders contend that instructors can create high-quality clips through camcording. This argument proves too much. If camcording can produce high-quality images, why does the motion picture industry bother using CSS? Why does the industry support the DMCA? And why are we in this hearing? We should all go across the street together and ask Congress to repeal the DMCA because it is completely irrelevant. It has also been suggested that screen capture technologies such as Snagit can provide an alternative to circumvention. Here, too, the quality is not comparable to DVD ripping. Also, I am informed that Microsoft's new operating system, Vista, prevents the operation of Snagit software. Thus, screen capture technologies do not provide a long-term solution. Time Warner stated in its comments that it will give instructors permission to use film clips. However, as we've heard, its permission letters state that the permission is contingent on the instructor getting publicity rights approval from the Screen Actors Guild. Thus, the Time Warner permissions by themselves are of little value. Finally, putting aside the question of quality and alternatives, we have to ask ourselves why the rights holders are opposing the modest expansion we seek. Why are they so reflexively confrontational? They know that the uses we seek will not harm their market in any way. They also know that whether the exemption is granted or rejected will have absolutely no impact on the level of infringement out there. They should welcome our use of their content in our classrooms. They should make our legal use as easy as possible. We shouldn't even have to apply for this exemption. They should proactively declare that they won't bring DMCA actions against higher ed institutions for assembling film clip compilations. Instead, they insult us by treating us as potential infringers who can't be trusted to use a technology any 12-year-old can download right now from the internet. The Librarian of Congress should disregard the frivolous arguments raised by the rights holders and allow circumvention for film clip compilations for higher ed classes in all disciplines. Thank you very much.
Thank you. Okay, next is Ms. Hobbs. Ready?
Good afternoon. My name is Renee Hobbs. I am offering testimony on behalf of the media literacy educators who work at all levels of American education. I've prepared a slide here that gives you some background on my experience and credentials. Since many people in this room are unlikely to be familiar with media literacy education, I'd actually like to offer a definition. And I'd like to do that in the form of the media literacy remote control. So, if I may. The media literacy remote control is a visual metaphor that articulates idea of thinking critically about media and technology messages. You can see from the remote control that you can use it with all different kinds of media, including books, newspapers, film, magazines. But when you use it, metaphorically speaking, you get to explore issues like what's accurate and inaccurate, the true-false button. Who's making money from this message, the private gain or public good button, and the values check button, looking at how media messages depict our understanding of moral and ethical behavior. In fact, over 15 years ago, media literacy educators got together at the Aspen Institute and came to a definition that reflects media literacy as an expanded conceptualization of literacy. Just as literacy includes the ability to participate in speaking and listening, writing and reading, literacy is the sharing of meaning through symbolic form. And so media literacy includes critical viewing and media composition. In fact, media literacy offers a powerful conceptual set of themes for exploring multimedia genres, introducing students to how to analyze authors and audiences, messages and meanings, representations and realities. Media literacy practitioners have a discrete set of instructional practices, a set of key concepts and core principles established by the community that emphasize how media and technology can be understood in relation to the building of skills involving critical analysis and communication. Why are we so passionate and dedicated about our work? Well, middle school students spend 4 to 6 hours a day in screen activity, and 4 out of 5 of them say no one talks to them about the media messages they encounter every day. So 80% of 12 and 13-year-olds are soaking in a rich and complex media culture without opportunities for critical thinking and communication skills. Moreover, we have a strong movement now toward helping our students develop the 21st century literacy skills they need to be effective in a knowledge economy. Those include skills like being able to use technology tools, being able to apply analysis, critical thinking, and ethical judgment, being able to be creative and expressive with these new forms of communication, and being able to engage in teamwork and collaboration. And media literacy addresses all 4 of those components of 21st century literacies. So I'm here today to ask for a functional use-based exemption of CSS circumvention because it's essential for media literacy education to thrive. Media literacy educators must make use of copyrighted works in order to build those critical thinking and communication skills. And so I'm speaking on behalf of that large number of teachers and students who need to be able to use DVD clips for teaching and learning media literacy education. Now, one critique that was offered to us was that this class of users is too broad. There are, in fact, 56 million students in K-12 schools. Based on our best evidence of interviewing teachers, reviewing state standards documents, and looking at national conferences and the topics and issues presented at national conferences, we estimate that about 85% of middle school students get some kind of media literacy education in the context of their health class. This happens mostly as health teachers help students to critically analyze the representation of alcohol and tobacco in mass media. Right now, we only estimate that about 20% of secondary students get that opportunity in their high school English classes, although we think that trend is growing. Last week I was just at the International Reading Association in Minneapolis, Minnesota, and there were probably 40 presentations that addressed this topic among the reading and literacy educators. But I'm here on behalf of the large number of students who won't ever have an opportunity to take a film class in college. In urban communities like Houston, Atlanta, Detroit, Chicago, and Philadelphia, 50% of those students won't make it to college, and so they need opportunities to have exposure to media literacy education during their K-12 years. Everyone, in fact, needs media literacy education. Now, another critique that's been offered to us is the idea that there are other options besides CSS circumvention, and other petitioners have talked a little bit about that. In fact, it's quite ironic the way in which the shifting technologies have impacted on teachers and students in American public schools. We don't have VHS machines anymore at home. We got rid of them when we got our flat screens, right? We teachers all moved to new technologies long ago, and our VHS machines are in the basement or at the garage sale. We haven't had them. We haven't been able to tape off the air, in fact, for quite a long time. The VHS machines are not frequently in our schools. In January, I was doing a staff development program in North Carolina for the North Carolina Teacher Academy. When I asked for a VCR, because I hadn't digitized a particular tape, it took them a day to find it, right? And when they found it, it didn't hook up to the data projector, so we actually couldn't show it on the screen. VHS machines are less available in schools. It's difficult to make effective educational use of DVDs for all the reasons that were presented by Peter DeCherney 3 years ago. One most notably is a high school English teacher who wanted to have students look at the suiting of the astronaut scene in Apollo 13. You may remember a very moving and lyrical moment when the astronaut is suited up in all the complex technology required. She wanted to do a close analysis comparing that scene to the scene in Beowulf, where Beowulf prepares for his exciting battle with Grendel. But in fact, she had to watch as her students giggled and got distracted as she quickly tried to fast forward through Hellboy, The Mummy, and American Gangster, really destroying the mood of the activity that she was trying to implement. Of course, in many schools, in public schools, teachers can't access YouTube. The internet software, filter software in schools makes it impossible to use video sharing websites in the context of K-12 education. I myself, as head of the Media Education Lab, put up 56 videos on YouTube for educational use by teachers for media literacy education, materials we have created ourselves at the lab. Teachers can't access them. So we must find other ways to provide curriculum materials for them to do media literacy education. So I hope I've made clear to you that media literacy education is not like what you might have experienced back in the day, simply using media and technology for instructional use. In fact, it's just beyond viewing and discussion. We're using media and technology to build critical thinking and communication skills. But I'd like to close by offering you an example of a real teacher in a real classroom in Texas who had a very, very powerful learning experience. She wanted to create an opportunity to explore how depictions of romance in mass media and literature shape people's expectations about social relationships. Her instructional practice was very specific. First, students would view and discuss a teacher-created video which introduced the formula, the tropes, and the stereotypes about romance as it's presented in contemporary film and television. Then she would model the practice of critical analysis using a contemporary film excerpt and an example from literature. And finally, students would select a personally meaningful film excerpt that depicts stereotypes about romance. They compose an analytic essay and make an oral presentation that comments on the film excerpt. Ms. Scheffler's doing this in part because in the state of Texas, media literacy is mandated. It is part of English language instruction. It is required. It is part of her curriculum. But back in the day, she used to use this really interesting video back in the late 90s and early 2001. And about 2002, she reached out to me and said, Renee, I'm really sad I can't do this activity anymore because the video that I created to use with students, well, it just doesn't work anymore. Students are not familiar with the films and the materials, and I want to be able to update it. But she can't update it. Let's take a look at the video that Mrs. Lisa Scheffler developed for her high school English class, the videotape that she can't update anymore. She can't update this anymore. Let's see if I can find it.
Love and romance have always been a part of the popular media. Starting with the earliest silent movies, audiences have watched countless relationships play out on the screen. Over the years, the major elements of the story haven't changed much. A couple meet, like each other, and flirt a little bit.
Where'd you learn to dance like this?
And though they may dance around each other in the beginning, everything is leading up to that all-important first kiss and passionate declaration.
Golly.
Never knew I could feel like this.
Yet the course of true love rarely runs smooth, and there are always obstacles to overcome before happy ever after.
I love you.
I know.
Some heartbreak is inevitable in every good love story.
It basically indicated that Linda was not coming today.
And so it goes until the day you die. This thing they call love is gonna make you cry. I hate you. As much as I adore.
This familiar romantic tale finds its way into all forms of media, from movies and television programs
All I could see was you.
to commercials
And you changed my world with just one kiss.
to popular music
It's the moment we've all been waiting for.
and even so-called reality
Will
TV.
she say yes? Find out right now on The Bachelor.
But
All right.
beyond the predictable story
All right, I think you have the idea of what Lisa Scheffler was trying to accomplish. This tape doesn't work anymore because her 14, 15, and 16-year-old students are living in a different time, in a different context, with a different set of mass media references that tell us about romance and sexuality in relationships. Her students need the chance to reflect on how media depictions of romance shape their own understanding of social relationships. But here's the assignment that's very difficult for Lisa Scheffler to do in a 50-minute class period in McKinney, Texas. She wants to help students compare and contrast how the topic of contraception is addressed in the recent film Juno, how the topic of commitment is addressed, and how the topic of consequences are presented. To do that, she needs to be able to use 3 two-minute excerpts side by side to illustrate how media messages work to shape our understanding of adolescent sexuality and teen pregnancy. So, in conclusion, I'm here to make the case that teachers and students need to be able to use DVD clips for teaching and learning of media literacy education. Those of us in media literacy education are guided by an old quote of Umberto Eco, who long ago wrote, "The language of the image must be a stimulus for critical reflection, not an invitation to hypnosis." Thank you.
Thank you. All right, let's move on to Jeff Clark.
Thank you. My name is Jeff Clark. My institutional home base is James Madison University, but I'm here this afternoon to represent the Consortium of College and University Media Centers. CCUMC is a higher education professional organization that encompasses media and instructional technology-related support services, as well as companies that provide products to them. Our members in colleges and universities provide both library-related collection services and technical support services for instructional technology and media production. Our service units might be within an academic affairs division or within the IT organizations on our various campuses. Because of CCUMC's membership composition, we expect our testimony on a proposed DMCA exemption that's being championed by library-related organizations and by faculty will both support and augment their arguments. CCUMC's testimony is in specific sympathy with the proposed class of exemption here at this panel under 4A through G, all being variations of an enhancement on the 2006 exemption that Peter DeCherney and his colleagues achieved for audiovisual works in the Educational Library of a college or university's Film or Media Studies Department. We believe the version of the proposed class closest to our membership is in 4A. Commercially produced DVDs used in face-to-face classroom teaching by college and university faculty, regardless of the discipline or subject taught, as well as by teachers in K-12 classrooms. The bulk of our testimony will focus on the nature of the class of work involved in our proposal, its users and uses, and the expansion of scope sought for all three. CCUMC believes that the enhanced scope of the original 2006 exemptions class of works should have at least these salient characteristics. DVDs include that are CSS or other access protected and are commercially available or lawfully made, as it's often termed in Title 17, and are subject to a first sale doctrine or are purchased. 2, be eligible from any source. Collection items in a film or media studies library, a multi-type library representing these and other academic disciplines, or a personal resource of the faculty member. 3, include any individual work of content within the DVD, whether primary or ancillary, supplemental material. And 4, be subject to non-infringing educational use and face-to-face teaching strategies by faculty in any academic discipline. The first of those characteristics, commercial DVDs subject to sale. A few more comments. DVDs acquired from sale subject to the first sale doctrine are the focus of that characteristic, since licensed product, whether in physical format or more often made available for streaming and download, is likely to be subject to contractual terms beyond copyright law. It's excluded from our consideration. Licensed online content may also be of lesser quality than provided by DVD digital encoding, a point relevant to the circumvention proposed here. All for-sale DVDs now contain content that may no longer be available by other non-licensable means, analog or digital. Commercial releases on video cassette, at least of feature films, ceased in spring 2007. More recently, JVC, the major manufacturer of standalone VCRs, ceased production of the equipment in fall of 2008. While what's termed combo decks, or combination VCR and DVD players that are heavily used in our higher education campus classrooms, while they continue to be made, a dwindling number of models in the market and common speculation among professional colleagues leads us to conclude it's mostly a matter of another year or two before their availability may cease. These units may or may not be replaced by a combo deck that incorporates VHS and Blu-ray playback capability. Panasonic announced such a player, the DMP BD70V, in January of this year, but so far they appear to be alone in their announcement. Both developments, the diminishing access to the software and to the hardware in analog video format, tend to channel the availability of content to DVD, Blu-ray, and online subscription or purchasing services. The majority of DVDs, unless from specialized educational publishers, is access and copy protected in its content. To comment on the second point, commercial DVD content from any source of collection. Other testifiers have noted, both on this panel and in earlier posted comments to this rulemaking, the limitation on type of institutional users to a film or media studies educational library, that it does not speak to the reality of resource organization in many, even most of our institutions. It's more common to find the multi-type library, as colleague Gary Handman has termed it, which collects and houses subdisciplinary collections on behalf of such departments engaged in film and media studies. Even this expansion of scope, however, is insufficient. Faculty often use personal copies or acquire them with departmental funds for their own instructional use or in an informal, quote, departmental collection, unquote, which doesn't in fact really exist as a facility. There is no need to consider these avenues of acquisition any differently, so long as lawfully made commercial copies are involved in teaching uses which benefit from extraction and compiling of their content for effective instruction. They should all qualify as sources for the new proposed exemption. On the third characteristic, DVD's useful content, the primary and ancillary work on the format. It's been observed as early as the 2000 round of exemption hearings that ancillary or supplemental content on feature film DVDs, along with the primary content, tended to be increasingly available, and that the encouragement of access and copy control technology had a role in this. Much of the ancillary material has been unavailable on VHS video cassettes or even on the now fully obsolete Laserdisc releases of the same feature films. Since that time, even documentary film releases have tended to augment their primary work with additional material not incorporated into the film or expanding the perspective on it through background context on its subject or the production process in the real world. All of this material is useful to film studies faculty and courses. However, ancillary material can also be useful to faculty and subjects outside of that discipline. Documentary supplements often include contextual material that reflects historical realities of the time period rather than focusing on the feature film or the nonfiction film release itself. Any of this material, given its variety, can be useful to faculty in other humanities, social sciences, and physical science disciplines, even when the primary film on the DVD release is not. This is especially true when dealing with vintage feature films whose ancillary materials are not newly produced and retrospective about the film, but also documents of the period during which the film was made. Despite reasonable arguments that DVD access and copy protection has encouraged the availability of ancillary materials, we don't believe that it has much cogency any longer as the years have passed, especially for archival materials that are assembled for older film releases, that is, not newly produced for them. The importance of ancillary materials as time and observation can show us in social experience has more to do with marketing factors other than protection of content. Such materials enhance the desirability of film releases that don't themselves automatically command a widespread must-own status because of overwhelming audience popularity. A glance at random comments by Amazon.com users focused on movie releases having little or no supplementary materials on their DVDs confirms this impression. Supplements are the expected norm, not the exception, and disappointment ensues when they're absent. The value of ancillary material of the general consumer can be seen not in its intrinsic value, but in the value-added novelty and the bargain it offers as part of the purchase transaction. But for the educator, the equation's more likely to be reversed. The supplements can be valuable as new content to meet teaching strategies, and as a bonus in that the content can be both useful and relevant even when the primary film it accompanies is not. Thus, in the case of the educator, quality, not quantity, is the governing force in the desirability of ancillary materials. The fourth characteristic, educational uses by faculty in all of the academic disciplines. Other testimony and earlier comments during the rulemaking have amply cited specific teaching examples from multiple disciplines beyond media studies for which an enhanced DMCA exemption would be useful. In reviewing communications among CCUMC members over the past 3 years, both in person at our annual conferences and across our listserv, we do not find any other novel examples to add to the inventory we've already got. However, I'd like to recast the examples already given into a kind of quasi-classification scheme of teaching uses that span across disciplinary application of AV works on DVDs. First, there would be the medium-specific aesthetic. Film and media, other communication studies, and even music are most directly involved here. The form and technique of the medium for creating affect and meaning are as or sometimes more important than the subject content considered for itself. 2, artistic dramatic. Adaptation of any other form, literary work, to the film or video medium, which are of interest to media, literary, and performing arts disciplines in the humanities. 3rd kind of use, subject content specific. Use of the subject content for its anticipated cultural value as information or knowledge. Feature film might offer useful awareness of current events or of history, however popularized. Nonfiction films for general audiences do the same, and discipline-specific instructional film and video are obviously targeted to mastery of subject and skills. 4, the medium's material content selectively and pedagogically repurposed. Incidental aspects of the feature film or other audiovisual work-specific audio and video content can be used outside of the purposes in 1, 2, and 3 just mentioned. A feature film could be used to generate ideas for theatrical set design or to illustrate concepts or styles for architectural studies. In general, educational, or specific instruction, though no longer relevant to current teaching of a discipline, may still be useful for historical study. For example, changes in nursing practice.
We've had an indication that this may be caused by cell phones, so folks would turn their cell phones off. I'm probably guilty. That would perhaps get rid of that problem.
Mine's off now, I know.
Blackberries included, yes.
Number 5 type of use. The medium's intellectual content selectively and pedagogically repurposed. Intellectual here comprises the cultural meaning and expression that are both inherent in and a viewer response to the material content, seen as a product of its time and society. This is an enormous category of usage for teaching faculty, as comments and testimonies have been verifying. Mining feature films especially for their expression, provocative or formulaic, coherent or confused, of social issues, is in widespread teaching use in higher ed. Cultural images of roles and the understanding of processes is not the exclusive domain of media studies either. A biology professor teaching a general education course on science for non-majors may excerpt American B science fiction films from the 1950s to illustrate popular conceptions of the scientist's role in society and of how science works. That specific example occurred to me a few years back. He may be using 1960s films by now. And finally, 6, the transformative use of media material in remixing and digital writing. We've had comments and are having testimony on both of those variants of remixing and their importance to student learning. We should affirm that the activity is important for students' mastery and analysis of subject and of creative expression, as it is for citizens engaged in a conversation with their own culture. CCUMC notes that faculty should be included as well. They may use remixing to stimulate or inspire student efforts. Even the clip collection activities sought to be enabled by the proposed circumvention exemption may be engineered into a presentation and software context for class that's hardly distinguishable from an instructionally oriented remix. On the need for the circumvention exemption rather than an alternative workaround, at this hearing panel of the Motion Picture Association of America is going to demonstrate an alternative software and hardware system to enable screen capture of video segments without circumvention of access controls and without resort to the point a camcorder at a monitor display solution that we've had in several years back. We look forward to this demonstration with an eye to its effectiveness in terms of quality results and efficiency of implementation. Barring a non-circumvention solution that's fully effective, however, CCUMC would argue, along with our library and other educational colleagues, that the quality of a film or other audiovisual works presentation is as important to other teaching faculty as it is to those involved in media studies. The best quality that can be achieved from a DVD transfer, a porting of the clips from the digital software files themselves, is crucial to fidelity of visuals and clarity of details in other disciplines as well. All visual arts and the humanities obviously benefit from image fidelity and clarity, and the experience of service support staff confirm that faculty everywhere are demanding on this count. Other disciplines benefit likewise when the detail in the image is expressed unambiguously in guiding the learning of a critical technique, as in nursing or other applied and physical sciences. In addition, because of the nature of CCUMC as a professional organization for technology support in higher ed, we know the realities of dealing with solutions to faculty teaching support that are staff-intensive. New material solutions that assist staff in meeting the needs of faculty are easier to effect from material operating budgets than from staff resources. That is, service solutions that can't be scaled into existing and viable service structures, but become time-intensive special service niches, are a concern for our organization's members. If meeting a faculty's teaching needs for clip collection via circumvention of access controls is more efficient in the use of staff time, as well as of higher resultant quality, our concern over the negative practical impact of a less efficient and less effective alternative solution is obvious. Finally, in closing, CCUMC wishes to restate our support for faculty in higher ed and their mission, which compels us to testify on behalf of an anti-circumvention exemption, assisting their efforts in general. The proper domain of education is the transmission of culture and cultural skills, the empowering of fully independent thinking and acting citizens, and the creation of new knowledge in the process of fulfilling the first two functions. Because of this expansive domain of activity, every cultural artifact of our global society is a potential object of instruction and learning, a text, as Gary Hanman's testimony put it at the Palo Alto hearing, a focus of study and use in one of the classifying ways I've outlined above. So we commend the Register of Copyrights to consider favorably an exemption of any enhanced character that would effectively empower faculty beyond those privileged by the 2006 exemption. Thank you.
Thank you. Now we turn to Roger Skalbeck, and I think we need to do some audiovisual setup. Is that right?
Yeah, I'm going to have all of a statement, then I had one or two clips that I'd like to play.
All right. Do you want to do whatever you need to get ready for that, and then we'll let you start?
Wherever. And that can be played from... and this will be at the end, so... What I'd like to do is read the statement, and then I'll come back to
Sure.
showing the examples or whatever. Okay. Thank you, everybody, to the Copyright Office for the opportunity to speak. in today's hearing. I'll read a brief statement, and then I'll turn to playing some of the clips that I have prepared here, but not all of them. They're more of illustration. My name is Roger Skalbeck. I'm the chair-elect of the Copyright Committee of the American Association of Law Libraries, and I'm also an associate law librarian here in Washington, D.C. at Georgetown's Law Library. Pursuant to the notice of inquiry published by the Copyright Office on October 6, 2008 in the Federal Register, the American Association of Law Libraries, the Medical Library Association, and the Special Libraries Association submit the following comments to exemptions that should be granted pursuant to 17 U.S.C. Section 1201A1C. Our three associations collectively represent more than 20,000 members, both here in the United States and worldwide. Our associations work together to address copyright issues that affect our members, and we are particularly concerned today with the needs of faculty and students in the many educational institutions we serve. Our request for an exemption is specifically aimed at literary and audiovisual works, usually commercially produced and lawfully acquired DVDs, when circumvention is used to make compilations of brief portions of works for educational use by faculty members in a classroom setting. Specifically, we request that the exemption granted to faculty in media and film studies programs after the 2006 rulemaking proceeding be broadened to include faculty of the law and health sciences areas, and that exemption be extended to include lawfully acquired copies from any source permitted by 17 U.S.C. Section 110 sub 1. As a little background, Section 1201 of the Copyright Act prohibits circumvention of technological measures or access controls employed by or on behalf of copyright owners to protect their works. To ensure that the public can engage in non-infringing uses of copyrighted works, the prohibition is limited. Non-infringing uses of any particular class of works are exempt from the prohibition when users are currently or in the next 3 years are likely to be adversely affected in their ability to make non-infringing uses of that class of works. 6 classes were exempted when the final rule was published after the 2006 rulemaking proceeding. The first of these exemptions, of course, was for audiovisual works included in the educational library of a college or university's film or media studies department, and we know the rest how that goes. The final rule noted that the concern of copyright owners that the proposed class be as narrow as possible to prevent an overbroad range of uses. We hope to show through our examples that the exception made for media and film studies faculty should also be broadened to include law and health sciences faculty. Educational programs in law and health sciences increasingly include role-playing and other real-life exercises that help students gain a better understanding of professional practices. For instance, how to counsel clients, how to diagnose an illness, and how to ensure patient safety. The best way to prepare students for such exercises is to show short clips that include illustrations of the right and the wrong way to handle various situations that present themselves in the everyday practice of law and medicine. Such scenarios are present in a wide variety of films and television series that are concerned with the practice of law and medicine. There are many examples of full-length law and medicine-related motion pictures that are available for classroom use through the fair use and educational exemptions in Sections 107 and Sections 110 of the Copyright Act and Title 17 of the U.S. Code. Unfortunately, there are no equivalent provisions available that cover situations when a faculty member in a law or medical program simply wants to compile a set of very brief clips from longer works to introduce, for instance, role-playing exercises in an ethics or patient safety class, or to provide a spur to facilitated discussion about client services. There are also many situations, particularly in intellectual property classes, where a faculty member may need to show examples of multiple works in order to clarify a point of law that no amount of verbal communication can provide. For purposes of argument, we assert that the encryption method known as the Content Scramble System, or CSS, which is embedded within DVDs and prevents most manipulations of them, is an access control measure that prevents efficient use of portions of a work. For educators who want to use short clips from audiovisual works, if one cannot circumvent CSS, one is left with the options of foregoing use of the clips in the classroom or creating poor replicas of the higher quality originals from their inferior versions of the films, if available. The CSS makes the contents of the DVD inaccessible to all users, including those who would use a small portion for educational purposes. Without the ability to circumvent CSS in these circumstances, the small portion of the work needed requires a time-consuming setup and that actually works against the purpose of enhancing the student's educational experience. One can argue that the fair use factors of Section 107 of the Copyright Act are relevant to an argument favoring the educational use of short film clips. Fair use, of course, is determined by weighing the purpose and character of the use, including whether such use is commercial or nonprofit educational use purposes, the nature of the work, the amount and substantiality of the portion used in relation to the work as a whole, and the effect of the use upon the potential market or value of the copyrighted work. We are seeking the exemption for literary and audiovisual works that are of importance to a program of study in which the work is used only for nonprofit educational purposes and only in a classroom setting. This mitigates against the potential harm caused by unauthorized commercial use or by widespread copying and distribution of a protected work. In the examples we have gathered, the portion to be clipped from a work is invariably short in relation to the work as a whole. The works themselves are legally acquired. In most cases, the DVD is in the collection of the educational institution's library, which exists to support the teaching program, and occasionally a work is owned by a faculty member who has purchased it specifically for classroom use. We hope that the following examples will help illustrate both the importance of these clips to the educational experience and the lack of a suitable alternative absent the ability to take short clips from the films. These film clips have been used in law school and health sciences classes to illustrate specific, focused, topical discussions of often complex issues. In addition, we provide hypothetical uses that could be made if the exemption is granted. As we show, the curriculum of a law or health sciences class can be greatly enhanced by the inclusion of short clips together with traditional classroom materials. Our examples demonstrate that clips from popular media can be used to discuss legal battles over media usage, fictional portrayal of real-life situations, as well as matters relating to patient care, ethics, and professional practice in law and medicine. Turning specifically now to the clips, material included in television programs and films can often form the basis of legal battles in court. For law students to better understand the nature of these cases, there is no substitute for seeing the specific material that is under dispute. There have been several lawsuits in the area of copyright and trademark law, typically with the person suing the movie company over how a product or original work appears in that work. By illustration, an intellectual property professor at Georgetown Law Center has used clips from movies to show students divergent treatment courts to give to seemingly incidental appearance of objects in specific scenes. For example, in an episode from the HBO series Rock, a poster version of a folk art quilt appears in the background of a short scene. The quilt creator objected to having her work of art appear in the episode, arguing that she was not compensated for this use. The court held that this was not a de minimis use, which is a legal concept meaning that it was not trivial. Contrasting this, the professor plans to show a scene from the Mel Gibson movie What Women Want, where a pinball machine appears in the background of a scene lasting less than 5 minutes. In this instance, the court held that the use was de minimis and was therefore not infringing. By seeing the specific subject matter of two cases involving a nuanced legal issue, law students have a better basis for discussion. A written description of the facts in each case would be far less effective than allowing students to see the short clips together. In fact, it might be pedagogically unsound to do so. Following are additional films where material appearing in a short segment has been the basis of a legal dispute that I'll describe just very briefly. The movie 12 Monkeys, in this movie, a distinctive chair appears in 4 separate segments. The chair was based on a drawing by the artist Labaeus Woods. The district court found that the movie studio chair clearly infringed the artist's work. The film Batman Forever features a building used by Warner Brothers in an agreement they had with the building's owner. An artist created part of the building's exterior decoration and sued the studio for unauthorized use. In a segment of the film The Devil's Advocate, a distinctive sculpture in the office of a lawyer played by Al Pacino comes to life, portraying the figures in the sculpture making provocative and erotic gestures. This sculpture was similar to something found in a fresco at the National Cathedral in Washington, D.C., and although no case was decided on point, showing the clip of the movie together with the actual sculpture or picture of it would be very effective. 2 final examples from this area. In 7, 10 reproductions of copyrighted photographs appear in a scene lasting less than 40 seconds. The photographer sued the studio and lost in a decision from the Second Circuit. And finally, in the film The Long Kiss Goodnight, a segment of the Three Stooges film Disorder in the Court appears for less than 30 seconds. Owners of the Three Stooges material sued the studio for trademark infringement, and they lost. Another area where we would argue that film clips and use of them would be very effective in the subject area is as follows. One area where they have been used effectively in legal instruction is in a seminar called The Law of 24, and I'm submitting the syllabus for this together with my statement at the end of this hearing. This was taught at Georgetown Law Center by a senior attorney in an intelligence division of the Department of Defense. This course provides a serious examination of United States domestic and international legal issues concerning counterterrorism in the context of the utilitarian and sometimes desperate responses to terrorism raised by the plot of the Fox television drama 24. Integrated with a syllabus covering a broad range of complex issues, the professor played short clips from 24 as a catalyst for classroom discussion. Students were also assigned a traditional textbook, and each participant completed a 25-page paper for the course. If the requested exemption is granted, instructors will be able to offer similar substantive courses, perhaps in the form of a medical ethics course related to the series House, or a trial advocacy seminar based on or related to the legal drama Boston Legal. By being permitted to extract specific short clips to integrate with an otherwise traditional class format, a health science or law school professor could very effectively teach complex subject matter while keeping students engaged. Through the use of very specific clips, an instructor can keep classroom discussion focused and on point. This also makes it possible to portray focused examples that may not be from the same season or movie. Absent this exemption, an instructor teaching this kind of class would risk having the students in the class become more about entertaining rather than educating their students. A few last examples that have been used in classes. Additional examples showing how law and health sciences faculty have used clips from film or television programs to spur substantive discussions. A professor at the University of North Carolina used short clips from The Verdict and Anatomy of a Murder as examples in a course entitled Ethics for Litigators. At Elon University School of Law, an intellectual property professor, showed a segment from American Gangster to emphasize a concept from trademark law. In a film, the main character is a heroin dealer who sells high-quality heroin under a specific brand. Other drug dealers begin using the same brand with lower quality in heroin, and conflict ensues. Very interesting. A criminal law professor at the University of North Carolina uses several short clips from The Simpsons, Pulp Fiction, and Cape Fear to illustrate elements of criminal law relating to concepts discussed in class. At Georgetown Law Center, an intellectual property professor shows a clip from the TV show Homicide, where the Baltimore detectives discuss the differences between the Baltimore Colts and the Baltimore CFL Colts, illustrating important concepts from trademark law. In a first-year property course at Elon University, a professor uses a clip from the film Braveheart to introduce the concept of feudal estates. Additional examples from the health sciences courses illustrate the range and usefulness of short film clips to illustrate various medical conditions. A clip from the movie Tom and Viv is shown in a psychiatric nursing class to help illustrate the rights that Viv will lose as a result of being committed to an institution. A short segment of Good Will Hunting is used to illustrate the main characters coming to grips with the abuse he suffered as a child. A brief clip from As Good as It Gets shows a character with obsessive-compulsive disorder. And in A Beautiful Mind, the main character checks with others to determine whether the young girl he sees is a real person or is a hallucination. We have shown a range of examples where the use of brief film clips greatly enhances the educational experience of the students we serve, and we hope that this testimony has helped to shed light on the problem that access control devices cause in making film clips available for educational uses. Our associations are very grateful for this opportunity to testify at this rulemaking hearing, and we appreciate the kind assistance of the Copyright Office, and I respectfully submit my hearing testimony. What I'd like to do now is just play. There are a series of 8 clips here. I won't go through all of them. They are all very short. I think the longest one is 3 minutes, and all of the rest of them are less than 2 minutes long. What I'd like to do is play 2 clips from infringement cases where they have specifically show elements that have been litigated in decided law cases. And the thing that I'll point out here is these were prepared so they are available to be played on any DVD player. This doesn't rely on any particular classroom technology other than standard DVD players. The first one that I'll show here is a scene from, The first one that I will show here is a scene from The 12 Monkeys, and it's a very short scene. Let's see if we can get here. Might be left-handed mouse here. Ooh.
Why don't you sit down, Mr. Cole?
Thank you, Fred.
We appreciate your volunteering. You're a very good observer, Cole.
Thank you. We have a very advanced program, something very different.
An opportunity to reduce your sentence considerably.
And possibly play an important role in returning the human race to the surface of the Earth.
We want tough-minded people, strong mentally. We've had some misfortunes with unstable types.
For a man in your position, an opportunity not to volunteer could be a real mistake. Definitely a mistake.
And I'll just play one more clip here. So in this clip, the issue at hand is...
Everybody stay outside.
What I'd like to point out with these two particular things here are a couple of things that may respond to some concerns that that would be addressed, or sort of counter arguments to them. First of all, if these were low quality clips, the difficulty with these is that in the first clip, what we have here is the 12 monkeys. The issue here is an issue of substantial similarity between a two-dimensional drawing, and it's also an issue of derivative work and some other things. The issue at hand in the case was somebody had a drawing of a chair that the movie producers in the 12 monkeys then made a version of and used in the work. It turned out to be infringing. And so the issue there we have is substantial similarity, and we also have an issue of a derivative work nature where you need to really see what the nature of the work is that you're looking at to understand how it comes into play, taking from a two-dimensional to a three-dimensional, but also seeing what is the difference between these two clips here, between these two works of art or works at issue. And in the second clip that I showed here with 7, the issue is whether this is de minimis use. It's a very poorly lit scene. It's very dark. It's very short. It's very difficult for me to even cue this up to find it. I had to fast forward through the movie a couple of times to figure out where it is. At issue in this clip is the use of the black and white photographs that are along the wall to the right as the two men walk in the room, and then on the left that we find right underneath the receipt from the store there. So the fact, if this was a low-quality clip, it would be really difficult to understand the nature of the use that was complained about here. I will very briefly describe the purpose that the rest of the clips would be used for, but in the interest of time, I will not show the rest of them. In Anatomy of a Murder, this would be a perfect example of a clip to be played. The one that is queued up here is an example of research being done in a law library where they're using the American law reports. This would be a clip that would be relevant in a legal instruction class. They're using the American law reports, and they find a case that's cited in there. It talks about it could be used to illustrate the importance of secondary materials over just going to the law cases themselves, and it also would show the fact that some of these types of materials have been used over a series of a number of years. The Devil's Advocate clip, this is one of the clips from a litigated case. The issue that would be shown here is the sculpture that's sitting behind Al Pacino's desk, where it then transforms into a series of scenes and a series of sort of provocative things that was not looked upon nicely by the sculptor that created this at the National Cathedral. Of course, this is the devil, and God's at the other end of the spectrum in a sense. One reason why editing them is important versus queuing them up is that in the Devil's Advocate scene, I've edited it specifically to end before there's a sex scene afterwards, and it involves some other things. It distracts from the particular issue at hand, and if we are unable to excerpt them specifically, then this would be a difficult problem. Very quickly running through the rest of them, the issue in House here, this could be used in a medical instruction for research. Basically, the doctor in House is saying, well, you need to research this particular issue. Well, you start with A and you go to Z, and it's more of an advocacy piece saying, well, you should turn to libraries and you should rely on these types of materials to get the point across. The next one, The Long Kiss Goodnight, this is about a 35-second clip. There is a clip from the Three Stooges movie Disorder in the Court that's being played in the background of a particular scene, and that is a thing where it's interesting. They sued over that being a trademark infringement and not a copyright infringement, so it's a different case, but it's another type of thing, like showing multiple things together. Is this de minimis or not? Would be very useful and very pedagogically sound to do it that way. The Pelican Brief is a brief segment where it describes, there's a research scene there where there touches on, this would be a great clip to show for issue spotting in a legal research class. You could show to touch on issues of ethics, issues on access to materials, issues on expediency, things like ethics for journalists and things like that. And there's a couple of other things in terms of student records and privacy issues that come up there. 7 we saw briefly, and finally in my statement here, What Women Want, we do discuss that in our statement. And in that scene, in the background, there's a Gottlieb pinball machine that's included very incidentally, and it's found by the court not to be, or to be a de minimis use. So it is not trivial. It is trivial and not infringing. So those are the clips that I'm submitting. I'm not going to play any additional clips from that. Thank you very much.
Thank you very much. Let's move on now to Carlton Jackson.
From the specific back to the general, thank you for providing me with the opportunity to speak here today. I am Carlton Jackson, and I'm a media librarian at the University of Maryland in College Park. I'm one of 2 librarians within a 10-person staff of one of the few academic libraries devoted exclusively to audiovisual media, and it serves as the Central Audiovisual Research Facility for the university, the campus, and the system of the Universities of Maryland. I serve as an acquisitions, reference, and curricular instruction librarian. In the latter role, I work with faculty of all subjects, disciplines, and interests in curricular planning and the use of audiovisual content. I'm listed on the panel today as a representative of our University Film and Film Studies Initiative Working Group. The group began as an ad hoc group of media, visual, history, and culture-oriented faculty, staff, University Film and Film Studies Initiative Working Group. The group began as an ad hoc group of media, visual, history, and culture-oriented faculty, staff, and librarians who promote information exchange about teaching film and teaching with film. Members of this group some are here today and available for testimony or questions later as needed. So, from that point of view, I'm representing them, and we are here to testify in support of the proposed educational exemptions of the works from the DMCA prohibition. Now, first, in the interest of full disclosure, I am also a member of other groups supporting the exemptions today and are represented by the panel. I am also on the board of directors of the Consortium of College and University Media Centers, and we our group is supporting their testimony. I am also the chair of CCUMC's Government Regulations and Public Policy Committee. I'm also a member of the American Library Association and a founder and past president of ALA's Video Roundtable, of which you heard the testimony of Gary Handman in California, and we are co-signers of that document that he presented. I'm also on the VRT Executive Committee, and I'm also a member of ALA's Office of Information Technology Policy Video Roundtable Working Group on Best Practices in Fair Use for Librarians. So just giving you that perspective that I'm working with these faculty, and the faculty wanted to have a voice here today to talk about what their perspective is. So, again, a little bit background again. I offer as evidence the fact that our library is one of the oldest and largest video resource centers in academic libraries. It opened in 1973, primarily as an audiovisual learning and curricular environment for undergraduates. The use of media by our faculty has never waned in these years. There has been exponential growth since video became easily accessible and procurable. As students from the 70s, 80s, and 90s grew up and became teachers, media collections became a preferred text for many, many classes. Our collection comprises documentary and educational works, primary source materials, news and television programs, as well as research-level collections of international feature films. As we serve a research function, we continue to maintain access to all our obsolete and legacy format collections, unless they've been replaced by new formats. And at the same time, we acquire these new commercially available materials in the best available, most usable format, which, of course, is today the DVD. Our Film and Film Studies Initiative working group members represent diverse nationalities, ages, genders, orientations, perspectives. We, and I'm part of this group, we use media from a variety of disciplines, backgrounds, and countries. We teach and or support classes with the word film, cinema, movies, and the like in the title and in the course description. But we teach even more classes without these words in the title. And as learners of media, we have used all forms of media. As teachers and librarians, we use all formats to connect our current teaching to our students, to use all forms of educational technology with it to enhance this teaching. So which departments and programs are the biggest users of our collection? Well, the University of Maryland is the largest university system in the Baltimore, Washington area, and the College Park campus is one of the largest in the immediate Washington, D.C. area. But the university does not have a film studies program, and that is unlike most of the other area universities. Yet we teach or support many classes with the word film, cinema, movies, and the like, and we teach even more classes without them. We teach classes with the words images and movements and sound and speeches and colors and emotions, representations in the content of the class. And for our students, the realities inherent in teaching this context exist for hours and minutes and seconds. The learning exists in real time, as in film reel, and real time, as in time. And the persistence of vision for days, months, years, and a lifetime in our classes. So I refer you again to all the class of Category 4 documents that have been submitted. I even received a tweet before I turned off the phone from our other viewers in the background saying they agree with everything that everyone said up to me, and I'm sure after this, and wish to point to that. I have a handout floating, I guess, with the folks up there that lists our departments and our classes that use media. Both the ones that have film or something like that in the title and the ones that do not. In the list of departments, you'll see just about every department in our university has a class or two or three that uses some sort of film. And when I say film, I don't mean film. I mean, it can be video, can be any of the formats before, but of course, the majority is DVD at this particular time. You'll also see, or the people have this document, that there are some classes that are core classes that are not film classes, but they rely so much on film that it's become an integral part of every class session. These classes are core classes. They have 200 plus students. They meet, unfortunately, only 50 or 75-minute lectures 2 or 3 times a week. And none of these classes feature a face-to-face showing of an entire work, but multiple clips are needed for each and every meeting. Just as an aside, films, documentaries. We've not really talked about the documentary film, but obviously that is the majority of the things that our people show. And the same rules as far as the exemptions apply to those as the dramatic works that we're existing for most materials. As noted in prior testimony, teaching with a pedagogical perspective requires the ability to compare sequences or scenes in same or multiple works, to zero in on a sequence that addresses a specific point being made in class, to incorporate clips into the context of PowerPoint presentations, educational learning systems such as Blackboard. This technique has become central to teaching and is exactly the same as the strong pedagogical arguments offered last year, which lead to the expansion of circumvention allowances for film studies and media studies. Before DVDs arrived on the scene, our group knew how to appropriately and reasonably use video in a classroom teaching and how to exercise fair use to accept a limited number of short clips. Current prohibitions have, in a sense, trumped these fair use rights and have created a roadblock for our media literate faculty and other academic users. None of our group wants to violate a law. DMCA has basically prevented faculty and librarians from doing our jobs effectively and legally and taking full advantage of educational technologies. We do not believe that there are any workable technical alternatives to circumvention. It's clear to any teacher who has stood behind a lectern that shuffling multiple DVDs in order to show various clips or using a remote in the dark to find clips on a single disc does not work. Inserting a disc in an open tray and arriving at the menu takes an average of 50 seconds. To find a chapter 5 takes an additional 15 to 20 seconds. This is time lost for teaching in class and after class. DVD and Blu-ray are likely to be the first of a long list of incompatible digital video formats that librarians and educators will need to deal with in the future. No rule written today should be allowed to tie the hands of tomorrow's educators. In summary, we believe that we will continue to need access to discrete portions of legally acquired video information in all formats, even if exemptions are not allowed. The current prohibitions have the unfortunate effect of criminalizing proven pedagogical practice. Moving images are the texts of the world's culture, and limiting circumvention allowances to the formal academic programs as film and media studies, and limiting the exemption to the use of materials in departmental or campus libraries is completely unrealistic in light of current teaching practice, current institutional resources, and evolving trends in education and scholarship. In the 21st century, a literate population is a democratic requirement. Audiovisual content is at least secondary and often primary information sources of most people, and this means that studies for all disciplines, all subjects, if media is involved in any way, are in effect like film studies, and at its broadest point, it is media studies and media literacy. Our faculty needs access to media sources in whole and in part, and in the best available format to teach with clarity and depth. And I urge the Librarian of Congress and his advisors to expand current exemptions in order to support the legitimate teaching, learning, and research needs of faculty and students for today and tomorrow. Thank you.
Thank you. We'll now move on to Martine Courant-Wright. And you have something to show us?
At the end of my presentation, I wanted to be able to show this.
Sure. Okay. You want to just give us your presentation first and then do that? Oh, great, great. Oh, and by the way,
It's actually the only ones that I have.
okay. Carlton Jackson, you said you had a Mr. Jackson, you said you had a handout of some sort. It hasn't made its way to us yet.
Okay.
So please make sure we do get it.
I will. And the testimony. Thank you.
Thank you very much for having me here today. My name is Martine Courant-Wright, and my institutional affiliations are Lansing Community College and Michigan State University. I have been studying for the last 3 or 4 years the impact of copyright law on the chilling of digital speech. My study, which I completed, which was part of my dissertation, was called "Is There a Chilling of Digital Communication?" And it was an empirical mixed method study that included a digital survey taken by a randomly selected population of professional writers and interviews with digital student writers working in educational settings. My study was approved by the Michigan State University Institutional Review Board for the ethical treatment of human subjects. I explored knowledge levels about copyright law and also levels of chilled digital speech, i.e., is copyright law chilling speech? The study was written into my dissertation, Rhetorical Invention in Copyright Imbued Environments. My research was funded in part by a grant from the College of Arts and Letters at Michigan State University and supported by the Writing in Digital Environments Research Center at Michigan State University. And my appearance here as well has been supported by both Lansing Community College and Michigan State University, and I've been helped and counseled by many colleagues prior to my appearance here, including the co-directors of the Wide Research Center, Drs. Jeff Grable and William Hart Davidson, whose support I have here today. I also have the almost 400 participants of my study supporting my appearance here, as I have a very overwhelming responsibility to them to push some of the issues that arose in my study forward. These people donated about 30 minutes of their time without being paid to do my study so that I could get a PhD. So I'm indebted to them. I teach composition at both the university and the community college level. Most of my teaching experience has been at the community college, where latest statistics show that almost half of all students will attend, particularly for their first year writing requirement. I just finished teaching my first graduate course at Michigan State, Composition Studies, Issues, Theories, and Research, and I had PhD students and MA students in my class. I tell you this to indicate my level of expertise with the literature and research in writing studies, as we have some research that might inform your decision here today, in addition to my study. I'm also a licensed attorney with an active license to practice in Michigan and an inactive license in Colorado. I was admitted to practice law in 1985. I want to be clear here that I'm defining writing broadly throughout my testimony to include multimedia text, including audiovisual compositions, and of course, alphabetic text. And what I have at the end, I hope, is to be able to show you an example of student writing that would be legal because it's fair use, but for the DMCA. My handout, I passed out, I only made 30 copies, so this is in the hands of the Copyright Office, and I'm also happy to give anyone copies who didn't get one if you just let me know. I'm not going to read from a handout, I'll let you read it on your own time, but what I want you to extract from that is that digital writers, teachers, and students in professional writing programs are people who will act ethically and legally when given a reasonable opportunity to do so, but like most educated people, will evaluate any given situation in order to assess how reasonable the law is. We understand about civil rights and free speech in the academy, and we care about these things. We also care about copyright law. We want to learn more, and we think fair use is very important. We want to do the legal thing and the right thing, but these are responsible, smart people that I'm arguing for here. These are the people I'm representing. And my handout also shows evidence, empirical evidence, that copyright law is chilling speech. I understand by reading the 2006 recommendation written by Mary Beth Peters that you're looking for ways to limit the exemption. I understand that. So what I'm going to do is offer some language that cuts across all of the fours, and then I'm going to justify that. And tomorrow I'm arguing for something broader, so this is my argument in the alternative. The exemption that I'm arguing for is motion picture and audiovisual works released on DVD, comma, housed in a U.S. library collection where the student attends or where the teacher is employed, comma, or legally obtained and owned by the teacher/student, comma, where circumvention is undertaken solely for the purpose of extracting clips for the inclusion in videos or multimedia texts that do not infringe copyright and that are composed either as part of student coursework or as part of course curriculum. This exemption shall apply even for works that are gifted from students/teachers to community groups/nonprofits as part of service learning or community outreach. In justification of that last part of this class that I kind of is part of my testimony as trying to synthesize everyone's wish from the educational community, service learning and community literacy we have a literature of that in composition and rhetoric. I'm asking the Register of Copyrights to see the writing classroom not just as something that takes place in 4 walls. We're working very hard, and we have a literature to professionalize undergraduates. So I'm frequently asked to be a guest speaker in first-year writing classes where students are doing work for community members, doing writing for community members, and they want to be sure that the works they create aren't creating liability for nonprofits that they're working with. So there is an active effort with community outreach. So I'm asking for the exemption not to be limited to classrooms and for there to be some way to see that through. I'm also asking for the exemption not to be limited to face-to-face environments. During this last academic year, I taught 8 virtual classes. I would have had no use for this exemption. Online teaching environments are increasing exponentially, and not only that, but Angel and Blackboard course management systems are used in face-to-face teaching environments. I always use them when I teach face-to-face. Students are uploading assignments there, and there's also hybrid. We also have hybrid classes now, which are half online and half face-to-face, or how different institutions configure them differently. So to limit the exemption to face-to-face is to harm disenfranchised students and teachers working in online spaces, spaces which are also leveraged now in face-to-face environments. I'm also asking you not to limit the exemption to library use. And let me tell you why. At Lansing Community College, our holdings are so much less than at Michigan State University. So the students at Lansing Community College, they have less fair use than the students at Michigan State when you do that. We have, at Lansing Community College, we have 2% of the amount of books that Michigan State does. We have 25%, they have 75% more digital materials than we do at Lansing Community College. Also, in the student writing I'm going to show you, these are popular movies, and I checked at Lansing Community College and Michigan State University Library. Neither library has any of these clips. I looked at the top movies that are available in DVD: The Dark Knight, Hancock, Indiana Jones and the Kingdom of Crystal Skull, Iron Man, National Treasure, Into the Wild, 3:10 to Yuma. None of these popular movies are owned by either Michigan State University or Lansing Community College library. So if I was to give a writing prompt, which would be typical, examine images of men, women, Asians, African Americans, etc., in the most recent movies, i.e. popular culture. Create a multimodal argument incorporating text, visuals, and sound about how these people are represented in the media. On the exemption that the way you have crafted it now, limit it to libraries, my students would be not able to complete this assignment realistically. So there's chilled speech. I am asking that students be able to use DVDs like they use books. I would, if they could, I would encourage them to purchase DVDs like they purchase books. I don't understand why the motion picture industry would want to tie this into the library rather than encourage individuals to buy these. I don't buy DVDs because I can't use them in the way that I need to use them. I would use Camtasia. I would be making film clips in my classes. I would be making film compilations, but I don't do that because I'm considered an expert on copyright law, so people look to me as a role model, so I can't be actively infringing or inducing my students potentially to infringe. I can't do that and sleep at night. So please try to imagine students and teachers as active producers of text and not just consumers, because that's how the motion picture industry is contextualizing us as consumers. VHS, I think we've heard enough testimony about that. It's basically a collector's item at this point. I don't have any VHS players in my house anymore because you can't rent that, and I have no use for them. I wouldn't have a clue how to get something in VHS into digital format, which is what's going to be required for delivery at this point. Why permissions don't work, I have something to add to the arguments. I think it's Time Warner that argued last year and also this year that permissions just aren't sought but should be. Since no one has ever appeared from my field writing studies, I can explain that permissions, the idea of permissions or asking permissions to use or be sent movie clips 3 to 5 days ahead depends on something false, which is a linear model of writing process. Writing is not, we have research in our field going back 30 years that clearly demonstrates writing is not linear, but it's recursive. And the writer revisits and revises decisions multiple times, continuously synthesizing information and changing things around. And here I cite the work by Flower and Hayes, Janet Emig, Sandra Pearl, Lee Odell, and my study that examined digital composing process. Some digital texts that arose in my study took over 150 hours and many months to complete. Some took years to create. Some were created by multiple authors over a period of many years, where one author wrote for a while and then another one took over. Time Warner's view of writing is this: you know exactly what movie clips you need, you ask for them, you receive them, you place them in your text in specific places, and voila, you are finished. Would that it were writing were that simple, it would make my job so much easier. However, writing is complicated and it's recursive. And also realistically, does the motion picture industry want 1,000 requests per academic year just from my students? I worked with almost 100 students this year. There's 5 writing assignments in each class. Realistically, that would be 1,000 requests just from me alone. I also ask you, although this isn't exactly relevant, Section 1202C8, specifically in the context of copyright management information, it specifically tells the register not to require any personal identifying information about a user of a work or of a copy, etc. And that appears in two places of the statute, in C and in subsection 8. And I think that gives a spirit that a user shouldn't have to identify themselves. They have to identify the copyright information, but there's a reason for that language being in this other section of Title 17. Read that in context with Section 107. Mary Beth Peters, in her prior recommendation, said she would only grant the exemption if, 1, it's not a matter of mere convenience, 2, there's no alternative formats, 3, the use will be non-infringing. For number 3, I want to show the student work, which I'm arguing is a fair use, and my legal citations on that are Campbell versus Acuff Rose, 1994 Supreme Court opinion, as well as the Second Circuit case of Graham Archives versus Dorling Kindersley, 2006. It's not a matter of mere convenience, and this is my writing studies perspective. There is a stark difference between convenience and normalcy. If I buy a book, it's not merely convenient for me to be able to lay it open on the table next to me and type a quote directly in my computer, or if ebook format, to cut and paste the text into my composition. This whole idea of having writers move away from their computers to use expensive and complicated VHS conversion equipment, or to purchase expensive camcorders and record the screens of other media devices and then import this into their digital compositions, even though they own the DVD, which they can easily view on the computer. The computer is the tool we write with now. This is like requiring me to first handwrite the alphabetic quote I want to take from the book I own, laying open on the table next to my computer, and then go outside and hand chisel that quote in a rock. Take a picture of it with my digital camera, bring it back into the house and download the digital picture of the chiseled rock back into my computer so that I can obtain the quote from the book laying there on the table next to me. It's not mere convenience at this point. It's normalcy. Please don't craft an exemption such that writing teachers are forced to teach students bizarre, abnormal, and unseemly workarounds to what is occurring naturally in digital composing environments. The computer is the tool we write with now. And the issue of there's no alternative formats, we've already had testimony today about how the VHS is an antique. So I'm not going to argue any more on that. I want to give an example. I discussed this in the handout of my student writing, of some student writing that I collected during the empirical study. This is the kind of work that the DMCA prohibits. It was performed both in an academic conference, it was performed in a classroom setting, and it was submitted for credit towards a degree. And again, none of the movies, except for the 1997 version of Men in Black, is available at either library that I'm associated with. So I was going to show it real quick. It's not very long. Is that?
Resume what movie? Yeah, it'll take a minute to read it. There we go.
Okay, I want to also inform you about the idea of writing and composition. This is like 25% of the composition what I'm showing you, because, and this is relevant to the Graham Archives case that I cited. One of the factors that court said to look at was how much of the creator's new ideas are appearing in the composition. And in this case, the student would have been standing up in front of the audience at an academic conference talking about how she was going to show how African Americans are represented in popular movies, citing literature within the field, contextualizing, explaining the whole conference presentation, a max of 15 minutes. Then showing one example of how violence against African American women are offered up for the public's entertainment, and then stop this composition and give some more information, and then show a montage about how African Americans are stereotyped in 3 different ways, and her, she had different categories she put them in. I'll just show one example of a montage that I'm talking about. Where's the mouse? Oh. Okay, so this would be playing in the background.
Yeah.
What?
Move over to where the button. Yeah, there you go.
Sorry. Wait, I don't want this one to show first.
Shazam! Up yours, job, turkey. Traitor! You lying, sucker.
Oh!
15 seconds to launch. 10 seconds to launch. 8, 7, 6.
Why are you just so loud? And make sure you take your behind to class today.
Yo, I do be going to class.
Lunch is not a class, shorty.
It is when you got the munchies.
See, that's why you such a dumbass.
Your mother.
You my brother. That's your mother, too, jackass.
Oh, yeah. Well, then your father's stupid.
So, I don't know him.
Yeah, me neither.
Shorty, I know you ain't driving without no papers.
I got papers, blunts, bongs, all the ingredients to make a high nigga pie.
Well, even if I had an extra man, who would want such a bullshit assignment? Well, it's a disgrace to me. It's a disgrace to my department. It's a disgrace to... Dan, I'm sending someone right over.
All right. It's okay. It's all right. FBI. Take a picture. It's okay. Wait a minute. You just kicked me? You must be out of your mind. You want some of me? I'm finna give you a LAPD ass kicking. That was childish, man. That wasn't even called for. Now, I came down here to see Juntao because he told me to come down here because I'm his half-brother from Beijing. Me and him got the same mama. I'm Blackanese. I feel the buzz. Hunter, get on. Come on, Hunter. Get on, Lee. Come on. Come on.
I don't know how to get to the other title. What? Here? Okay, well, I'm not gonna waste everyone's time some more, but that's just an example of the montage. There were 3 sections to that, contextualized with academic writing. The first clip was a single clip of I think it was from Scary Movie, and it's basically an African-American woman being stabbed to death in a movie theater while everybody cheers the other people on, and it's really quite disturbing. But anyway, that was, this is an example of something that is definitely fair use under the 4-factor analysis, and something that we'd like our students to be able to do, not just in face-to-face classroom settings. And so that's the end of my
Very good.
talk.
Thank you.
All right, I believe we're going to move on to Fritz Attaway, who I assume will express his gratitude to the previous...
David, if it's possible, could we reorder our
Okay, fine.
just briefly, and I'll introduce it.
Okay.
Well, thank you. I appreciate the chance to be here again representing the 9 copyright industry organizations, the joint creators and copyright owners. I spoke about the Exemption 4 issue in some detail at the Palo Alto hearing, so I'm not going to repeat all that, especially in the interest of time. Let me just say, in an attempt to kind of frame what you're going to be hearing from the next few witnesses, we've seen in the submissions, there are many, many examples given of educational uses of commercial audiovisual material. And we've seen a lot more examples today and heard a lot more talked about, and we look forward to actually reviewing this testimony and the submissions and getting a little more detail on some of the proposals that were brought forward today for the first time. But I think I can say that almost without exception, I hate to say absolutely no exception, but virtually everything we saw, we have no objection to. We think these are perfectly legitimate uses and valuable educational uses of this material. So we don't object to virtually any of the uses we've been shown of these works. We do object to the Copyright Office and the librarian under this Section 1201A rulemaking, granting permission to circumvent access controls in order to make these uses, when there are a host of other alternatives that are available that would not put our valuable intellectual property in the clear and at risk. And I think what you're going to hear mainly, if not exclusively, from the next few witnesses is about the alternatives. So let's put that issue of whether these are good uses or bad uses aside. We support these uses, and the question is how do you make these uses? How do you get from point A to point B? We want Mrs. Scheffler to be able to show her 3 2-minute clips in the English class in Texas. We want the police academy to see those scenes that are overflowing with body language and emotion. We even want people to learn about the trademark rights of heroin dealers. So let's just put all that aside and start talking about the alternatives. Before we turn to the alternatives, I do just want to make a comment about our proposals or our suggestions for narrowing the existing exemption. And Professor DeSherney is right. We did not oppose, if the office finds that the burden of persuasion has been met, we wouldn't oppose an exemption similar to what it currently exists. We did have several suggestions for narrowing. Professor DeSherney referred to a few of them, and I'll just briefly mention that first, we think that the evidence still, with a lot more evidence today, we may miss something, but overwhelmingly this evidence is about audiovisual works that are on DVD protected by CSS. There may be a few stray examples that don't fit that categorization, but virtually everything does, and we think that any exemption you recognized should be conformed to the evidence that's presented to you. Second, we think it should only, the exemption should only apply when it's truly necessary to circumvent in order to create a clip compilation. Specifically, we think that a consensual path or a permissions path, obviously that is a non-infringing use, and if that is available, and obviously that's a contested issue, but unless the proponents can show that it is not available, and we think there will be evidence to the contrary next few minutes, then the exemption should not apply. The necessary language is something you have used before. You have also used before in other exemptions the limitation that all existing digital copies of a work must contain the access controls that prevent the use that's in question. This is not an unworkable standard, and it can certainly be applied in a practical way, but there are many more alternatives available now, some of which you will hear about in the testimony, and it's not unreasonable to say you can't circumvent if you can find, if there's a reasonably available alternative means that doesn't require circumvention. Again, you've used this in the ebook exemption for the last 2 rulemaking proceedings, I believe. We believe that any exemption should be limited to what's necessary solely for the purpose of creating the clip compilations for educational use, again, phrasing that you've used in other exemptions. And finally, we think it is important to specify who is able to engage in this circumvention, who's able to exercise this. And now that the office has moved down the path of defining exemptions by particular categories of uses and users, I think it's important to give as much clarity as possible on who is entitled to exercise the exemption. We disagree with the proposal that this should be extended to students, and we can certainly talk about that. That's obviously an exponential increase in the universe of people by any standard who are able to exercise the exemption. And as it's a big step on the path towards circumvention becoming the normative behavior, and that's certainly not something we would like to see. So in any event, we think it's important that the exemption, if you grant any exemption in this area, it should specify clearly who is entitled to exercise it and who is not. Finally, I would like to, because of an issue that came up in the last hearing, I just wanted to briefly state something for the record on this question of Snagit. At the hearing in Palo Alto on May 1st, Rob Kasnick played clips from feature films and trailers that he stated that he had excerpted from a commercial DVD protected by the Content Scramble system using a software tool called Snagit. This demonstration was the subject of questions from the Copyright Office to panelists appearing at the hearing, including questions to me as counsel to the joint creators and copyright owners. This is the first time that the 9 organizations we represent have been asked to take a position on the use of this software tool. In fact, as far as we know, it's the first time it's ever been mentioned in this rulemaking proceeding. The next business day after the May 1st meeting, we convened a meeting of our organizations to discuss the questions posed, at least to the best of my recollection, since no transcript is available yet. Of course, we were also discussing many other issues in preparation for the 3 days of public hearings that have begun today here on many other topics. Clearly, a response to the questions posed, again as I recollect them, will require a full understanding of how the Snagit tool works in its various applications, how, if at all, it interacts with the various technological protection measures employed in CSS, and many other technical issues. It would then seem to call for a legal analysis and opinion about whether use of this tool constitutes a violation of Section 1201A1, and if so, whether uses in a particular setting would fall within one of 8 proposed exemptions that are contained in the Notice of Proposed Rulemaking. Our organizations don't have enough familiarity with this particular application to provide that analysis today, especially considering that only 2 business days have elapsed since we were first asked to do so. As we stated in our previous submission, as we repeated on May 1st, as we are reiterating today, we strongly believe that the proponents of the proposed exemptions 4A through D and 4F through H have not satisfied their burden of demonstrating that the prohibition contained in Section 1201A1 is having a sufficient adverse impact on the non-infringing uses they wish to make of the audiovisual works at issue to justify an exemption. In part, this is because alternative means not requiring circumvention are available to them and would satisfy their legitimate pedagogical needs. One important such means is the camcording of excerpts of the works from a TV screen or monitor. This means will be demonstrated at this hearing, and you can judge for yourself how it compares with the example that Professor DeSherney provided of circumvention under the current exemption. There will be discussion of the availability of uses with permission or consent, as I mentioned. Of course, those are non-infringing uses. There may well be other means discussed as well. For the reasons I've stated, we're not in a position today to give our views on the technical and legal issues surrounding use of the Snagit tool in this context. Of course, we would do our best to respond to any written questions or any questions that appear in the hearing transcript after we've had a reasonable opportunity to undertake the analysis that's summarized above. So I'd like to turn it over at this point to Fritz Attaway for the next presentation.
Okay.
I was so certain that you were going to give us a break.
We thought we'd give you guys a break when we reach the end of the testimony before we go into questions.
You're tough, particularly for a guy my age. I will necessarily be brief.
If you're telling us you're not up to it without a break, Fritz, we'll break now. But
no. I can hold out. Thank you. As Steve pointed out, a great deal of the testimony that we've heard so far goes to the fact that movie clips are an effective educational tool. And of course, we have no issue with that. We agree with it. They are an effective educational tool, and we have no problem with them being used. for that purpose. The issue here is whether movie clips are readily available without having to engage in circumvention of a technical protection measure. Jonathan Band pointed out in his testimony that the circumvention utility for CSS, which protects DVDs from copying, is readily available. That we all understand that. Nonetheless, CSS has been an extremely effective protection measure because it's inconvenient and the copies it produces are not always of optimum quality. That is what keeps most people from illegally using the circumvention utility, and it's what makes CSS effective and useful in protecting the integrity of our copyrighted movies. Now, if you accept in this proceeding inconvenience or lack of optimal quality as justification for circumvention, you've basically voided the anti-circumvention provisions of the DMCA and frustrated the intent of Congress. That should not be the standard here, convenience or optimal quality. The standard here should be whether film clips are reasonably available without having to circumvent. And the essence of our testimony here is that they are. Now, just you know this, but just for the record, you know that the Second Circuit has said that, quote, "We know of no authority for the proposition that fair use as protected by the Copyright Act, much less the Constitution, guarantees copying by the optimum method or in the ideal format of the original." The Copyright Office has said repeatedly, I'll quote from the 2003 review proceeding, quote, "Existing case law is clear that fair use does not guarantee copying by the optimum method or in the identical format of the original," unquote. So I think it's pretty clear that convenience and optimal quality are not the standard here. The vast majority of audiovisual works are available in some form in the clear, on VHS, on broadcast television, on cable channels, on satellite channels, and frequently on the internet. Clearly, for that material, there's no justification, there's no need for a DMCA exemption of technical measures that may be applied to that same material in other formats. For the material that is not available in the clear, or when it's not convenient to access that material, there's yet another way to exercise non-infringing uses, and that is by taking screenshots off of a television or computer monitor. Again, the Second Circuit Court of Appeals and the Copyright Office has both mentioned this opportunity as a legitimate alternative or an effective alternative to circumvention. Second Circuit said, quote, "The DMCA does not impose even an arguable limitation on the opportunity to make a variety of traditional fair uses of DVD movies, such as recording portions of the video images and sounds on film or tape by pointing a camera or camcorder or a microphone at a monitor as it displays the DVD movie," unquote. The Copyright Office has made similar statements in its DMCA review decisions. Having said that, my colleague Dan Seymour is going to demonstrate how taking shots off of a television monitor or a computer monitor can produce clips of movies easily using equipment that is readily available and affordable, and producing a result that is certainly comparable to the clips that we've seen here this morning and that have been offered as a reason why circumvention is necessary. I think our demonstration will show you that, in fact, circumvention is not necessary to produce the kind and quality of film clips that the educators that we've heard today would like to use. And with that, Dan, it's all yours.
Thank you, Fritz. Instead of trying to do a live camcorder demo, we actually recorded a camcorder of a TV screen. So I'd like to play that first, and then after that I will play the result of that camcording. So here's the setup, which is we use a tripod to obviously to minimize shake. Now there's a camcord which gets mounted. For this particular session, we captured the audio directly from the DVD player. You can see the image that we're recording is in the upper right. And incidentally, using this method, you can, once you have the setup, you can find a clip, record it, stop the recording, change your disc, find another clip, start the recording, record your clip, so you can get multiple clips from multiple discs, one right after another. And now she's just adjusting the zoom. The issue here is to get the frame so that there's no external, no parts of the TV itself in the image. And we've always found that it's best to do these recordings in the dark. So this is the actual session. And I won't go through the entire clip because I want to show you the result. Oops, sorry. Now this is the resulting camcord clip.
He really is out there, isn't he? We've got to be able to defend ourselves. And if Umbridge refuses to teach us how, we need someone who will.
This is mad. Who'd want to be taught by me? I'm a nutter, remember? Look on the bright side. You can't be any worse than old Toadface. Thanks, Ron. I'm here for you, mate. Who's supposed to be meeting us then?
Just a couple of people.
Now that was recorded off of a TV monitor. What I'd like to do very, very quickly, these are 18-second clips, is show you a camcord of a clip off of a computer monitor and then the DCSS version of the same clip.
That we obtained from the Copyright Office website that was submitted by Professor DeCherney.
Thank you.
Was this a Blu-ray that you took it off? What's the
No, that was standard DVD. This again is the camcord. And this is Professor DeCherny's.
Submitted on DVD, but then recoded and then uploaded to the internet. So there's a number of transitions before it got there.
The camcorder that we used was a standard consumer grade Sony. It's about a $900 HD camera. You don't need to use an HD if you're just recording off of standard DVD. The monitor was $300. What we did is we looked to see if there was comparable equipment at universities. And in fact, there's much better equipment at universities, which I wish we had access to.
What you saw, particularly the setup, you saw how long it took to set up the camera and make the recording. It's not anywhere near equivalent to having to get up from your book and go out into the backyard and chisel the phrase in stone and then come back and take a picture of it for use in your classroom presentation. It's pretty easy. Maybe not as easy as using a circumvention tool, but pretty easy. And again, I just can't overemphasize the fact that convenience simply cannot be the standard that you use in this proceeding. It's got to be more than mere inconvenience. And I submit to you that for virtually any audiovisual work, the ability to make a camcorded clip for non-infringing use is readily available, affordable, and not all that inconvenient. Thank you.
Okay. Could somebody hit the lights for us, please? Thank you. Okay, next up is Bruce Turnbull.
Yep.
From the DVD Copy Control Association.
Yes, I'm Bruce Turnbull of the law firm Weil, Gottschall, and Manges, LLP. I'm pleased to be here, as you just said, representing the DVD Copy Control Association. We appreciate the opportunity to present our views on the various issues set forth in the hearing notice. I believe the panelists and the Copyright Office in general is familiar with DVD CCA, so I won't go into all of our background and particulars. We are the licensor of the Content Scramble system, and I also wanted to note that we'd be happy to respond to questions on other issues that we presented written testimony on, if you had any, beyond those that are at the hearing today. As the licensor, the owner and the licensor of the technological protection measure that's at the subject of this afternoon's hearing, I wanted to make a particular point that our interest is in the preservation of the commercial viability of that technology. Now, obviously, we have a great interest in preserving the copyright owners' interests as well, but our interest is particular to the preservation of the viability of that technology, and we believe, in fact, that's what Section 1201 was aimed at principally. Now, obviously, the technological protection measure has to be for the purpose of protecting copyrighted material, but 1201 was aimed at protecting the viability of the technological protection measure. And so when you consider these exemption requests, we ask that you start with that proposition in mind. And also recall, as you have each time this proceeding has come around, that this proceeding is intended to be a fail-safe mechanism, not the ordinary course, oh yes, we'll grant, a long list of exemptions. The purpose here is to provide a fail-safe, not, and at the same time to be able to preserve the viability of the technologies that are accomplishing the protections here. As an overall matter, I do want to emphasize that DVD-CCA believes that the change that was made in the 2006 decision to define class of works, at least in part based on the nature of the use of the user, was a mistake, and that you ought to go back to the previous understanding of the law and thereby actually avoid a large can of worms. Having said that, moving to the various educational exemptions at issue this afternoon, to the extent that the 2006 interpretation is maintained, as has been indicated, we do not generally oppose the renewal of the Film and Media Studies professor exemption, nor do we oppose the inclusion of DVDs that are held by the library of the institution where the professors teach, although we would agree with the joint commenters and others who request that the exemption be limited to circumstances in which other means of achieving the professor's goals are not available. And we think there are, as has been demonstrated and discussed, a number of other such means. We do oppose the expansion of the exemption to the other purposes for a number of reasons. These proposed expansion, and let me start with the educators in general at this point. I'll get to the students in a moment. As Steve said, the proposed exemptions would exponentially increase the current exemption that's limited to film and media studies professors. And in the context, again, of focusing on the preservation of the technology as a viable matter, exponentially increasing the exemption is a very serious concern for us. As the decision in 2006 specifically stated, educators at large do not all have the same pedagogical needs as film and media studies professors whose areas of instruction are uniquely concerned with film and television qua visual mediums. And regardless of the quality level that might be desired, there are alternatives available to achieve such results without requiring the circumvention of CSS. Users can employ the camcorder method, which I think was very well demonstrated just before. That the viability of such alternatives was acknowledged by the Register in 2006 as well. As a second alternative for a number of the requesting professors, and I went through in some detail in preparation for the hearing today, the list of uses that we've heard a number of today, the Pioneer player would be a perfectly adequate alternative to circumvention. That was something we demonstrated in the 2006 hearing. We chose not to take your time again today, but that player remains on the market in different forms at very affordable prices. It allows the queuing of the DVD to several different places in a particular disc, so that you can start at one place and then go in an order that you've created, or in a random order based on the computer programming that you've done in advance, to various places in the disk. And where a single disk is at issue and can serve the purposes for a particular teaching purpose, that player is, I think, a perfectly good substitute. And again, if we're talking about the variety of proposals that have been made for how to use DVDs in the classroom, I think a reasonable percentage, I didn't count all of them, but a reasonable percentage of them talked about uses that would be specific to a single disk. And there were a number of the proposals also that clearly contemplated that some educators can and do plan their courses in advance. And for them, seeking permission from the movie studios to use certain clips is a full solution to their situation. Also, the movie server that some of the studios are in the process of setting up, when that's up and available, is also a viable alternative, even if you don't have advance, because it would be available, as I understand it, simply on demand, in the middle of the night and without asking in advance. In short, there are a number of reasonably available alternatives that should be sufficient to satisfy the needs of the non-film studies educators. And also a number of these should also inform the Copyright Office in relation to even the film studies professor exemption as to narrowing it to those circumstances where it's actually necessary. With regard to students and the proposal to allow them to circumvent access controls, the proposed exemptions, if granted, would really confound efforts to administer and police circumvention. Students would have a green light to hack CSS or use available hacks of CSS under the guise of class assignments. It would be difficult, if not impossible, for DVD-CCA and the owners of the content to distinguish between activity that falls under the exemption and that which does not. The difficulty of administering this exception is actually exemplified by Professor Hobbs' comments, which assert that professors can be gatekeepers of such an exemption. While the professor and others may have the best of intentions, I sincerely doubt that professors can realistically monitor such an expansive exemption. Additionally, the proponents of the exemptions articulate that in part the exemption is needed so that students can become familiar with basic aspects of manipulating visual media and to move students toward an audiovisual form of academic presentation. Students can certainly achieve such skills in the absence of the proposed exemption, as there's original material available from sources other than CSS encrypted movies, and there are the alternatives mentioned before to gain access to content that protected by CSS, perhaps particularly the camcorder example. An expansion of the current film and media studies exemption would undermine the technological and legal underpinning of the content protection system that is the basis for the DVD movie business. Once widespread legal circumvention of CSS is permitted, the ability to limit the scope of the use of the circumvention may well be impossible, thereby undermining the whole system. The key to that system has been to keep legitimate retailers and users from adopting the circumvention technologies that are admittedly available. As indicated at the outset, we're happy to respond to questions about the demonstrations made today, about our views on the issues that were in the hearing notice, and about our views on the exemption requests. Thanks.
Thank you. Finally, we hear from Sandra A-Stars.
Thanks. Since we're coming on 4 o'clock, instead of actually making any prepared statements, I'll just try and respond to a couple of points that were made during the earlier testimony and add my knowledge of what's going on with respect to the USC Film Server project, and also talk a little bit about the non-objection letters that we at Warner Brothers issue on a regular basis. I'd note, and I think Fritz noted similarly, and Bruce as well, that attention needs to be paid to the purpose of the proceeding and to the standard of the proceeding. And while I'm sympathetic to the educational uses that are being suggested, and in fact Warner Brothers actively works to enable such uses, I would encourage the Copyright Office to be careful not to fall into the sort of rhetorical technique that I think is being employed of suggesting that if a technical protection measure causes any sort of difficulty to anybody anywhere at any time, then it should be circumventable. That's just not the standard in the proceeding, and not the purpose of the underlying law. Let me just say a few words about the USC Film Server project. We at Warner Brothers, and I'm speaking on behalf of Warner Brothers, not for any of the other studios or for the MPAA here. Warner Brothers has been working very diligently, along with other members of the MPAA, to figure out a means to facilitate educational uses of film clips by film professors. And we've been talking about this, for a couple of years now, in part due to the issues raised by Professor Descherney the last time around. The proposal that we're looking at would allow film professors to register and create an account for themselves. They could then go on and browse through a full copy of each film title that's available on the service online, and then use a custom player application to select the exact clips that they're interested in and submit automatically online a request for those clips to be delivered, and those clips would then be either made automatically accessible to them, either by way of a download or on a secure URL. And there's no charge contemplated for the clips, and there's also no requirement that the film professor or the associated school in any way establish that they have a copy of the film title for which the clips were requested. It would be simply a matter of the clips, the motion pictures that appear on the server. In terms of where we are, we're currently working with USC to develop a list of films and TV titles that are most critical to have available via the service once the service launches. And our anticipation would be that additional titles would be added over time. And the goal, at the moment, we're working to identify a service provider that could operate the service. We've had an RFP out. We've interviewed numerous candidates that have made proposals. And the goal ultimately would be to try and beta test the service sometime later in the year. Admittedly, it's not up and running, and not all of the issues have been fully addressed and vetted, but I point to this only as an example of good faith efforts by the studios to try and accommodate educational uses that have been brought to our attention, and also to support some of the comments that Steve made earlier, that to the extent a exemption is granted, it should be limited to instances where it's actually necessary to use the exception rather than, for instance, go on the film server to get access to the clips. The other thing that I wanted to mention, and in the interim while the film server project is going forward, Warner Brothers continues to work with educators to try and enable their uses within a classroom of our motion pictures and of clips from our motion pictures. The requests that we get for permission to use clips are relatively infrequent and declining when it comes to educational users. I cited in my written testimony that in 2007 we only received 99 such requests, and in 2008 only 34 such requests. So we don't have evidence of the demand for these clips from our own personal experiences that we can point to. There is one instance in which we were actually this was in January of this year, where we were asked to supply a clip for a user to show in class. The professor had pointed to the difficulty of shuffling discs around and so forth, and we met that request, and we were able to provide the requested film by return email, and we absorbed the lab fees for that. Professor DeSherney has raised some questions about our work with educational users and has termed this a licensing scheme of some sort. I think he called it labyrinthine. But let me just answer a couple of the points that he raised. The first being that it's not a new licensing scheme that we're offering. We're merely noting that it's possible to work cooperatively with us to get clips if you need them, and that we're doing our best to accommodate uses that are brought to our attention. As copyright owners in our films and in TV programs, we have the ability to, and we regularly do, grant no objection letters to users concerning bona fide educational uses of our works. Given the nature of the uses at issue, those no objection letters tend to be based on Section 110 of the Copyright Act. So the letters aren't intended in any way to represent a new alternative licensing scheme. They're simply explanations to educators that they don't need a license from us for certain uses. When we issue our non-objection letters, we waive the rights that we have to the use of the work as described by the educator to the fullest extent that we can. Namely, we waive them with respect to the copyright in the film or the television program that we own from which the educator seeks to take the clip. Obviously, there are others who potentially have an interest in those clips. The guilds were mentioned, and actors represented by the guilds have been mentioned. And so we direct educators to appropriate contacts to facilitate waiving those rights should that be necessary. And we've had no feedback from any educator to indicate that such permissions have not been forthcoming in instances where we've waived our rights. Another point that I think, I don't recall if it was Professor DeSherney or if it was Jonathan Band that raised it, was the question about whether studios will engage in censorship or fail to approve uses that present their works in a negative light. And I note the proponents have not submitted any evidence to support this assertion. And in fact, to the extent this is a concern, while not directly on point with regard to educational uses, our testimony actually did include a letter from a documentarian who wished to use various clips from Warner Brothers owned movies to critique the depiction of African civilization in popular media in the 1930s in this instance. The clips that they were looking for were clips from Tarzan the Ape Man and from Bosco Shipwrecked, two movies that we own the rights to. The particular clips that they suggested they wanted to use included features of Tarzan swinging from a vine, used to demonstrate representations of African culture in popular media in the 1930s. They similarly wanted to use explorers in battle with African natives to demonstrate the introduction of white civilization in Africa. They wanted to use cannibals dancing around a fire in order to demonstrate representations of African civilization in popular media in the 1930s. And the last clip that they described was a feature of cannibals running, used to demonstrate, again, the representations of African civilization in popular media in the 1930s. The documentarians who were engaged in preparing the show contacted us and said that they believed that these uses were fair use, but they were contacting us in good faith to see whether we agreed. We issued a letter saying that, while we weren't going to opine whether it was fair use or not, irrespective of whether it is or is not fair use, our letter said that, we have no objection to the use described, and the production was able to go forward. So, to the extent that there's any evidence in the record as to whether studios are likely to restrict uses of their clips because they negatively portray either the media or media culture, I would point to this as at least an example to show that that's not necessarily the case. I think the last point to mention, and it doesn't fully address all of the uses that the educators have proposed, but again, I offer it as a suggestion that the studios are in fact looking to be creative in enabling the sorts of functionalities and features that people have brought to our attention. And in that regard, I'll mention the BD Live demonstration that I did this morning. I think it definitely has applications in an educational context, in particular for those who weren't present this morning. The demo shows ways in which you can add narration, either audio-visual or purely audio, and then have that narration play back while you're playing back a copy of the movie. And that's a feature that can be used both while you're in your classroom or through a community screening function that can be set up with other BD Live users. There are other examples that I mentioned this morning of features that we've used in other formats and are contemplating here, some of which involve editing suites and the like. So those are just examples of ways we're trying to accommodate the interests of the educational community. And I will end there.
Thank you very much. Well, we've been going on for well over 2.5 hours. It's probably time for a break. Shall we say we'll start up again at 4:15?
Okay. I think, first of all, I wanted to get some idea from the proponents of the exemptions and those in support of it, if there is any way of distinguishing between some of the different types of uses that we have seen and been shown here in the proceedings. That the last exemption for film professors was fairly narrowly tailored because of the particular pedagogical needs of film professors, and there was a lot of discussion in the testimony and the comments about the needs of film professors and that those educational purposes for being able to show minute differences in aspect ratio, various angles that were only available on DVDs. And from many of the demonstrations we saw today, I was not seeing that same level of necessity. Now, I heard necessity mentioned many times by most of the proponents of and supporters of the exemption, but I'm wondering, are we seeing different levels of necessity now from what we were thinking about and talking about 3 years ago? Peter, maybe you can be a good place to start.
I'd like to say that I'm convinced by so many of these examples that there really is a need beyond media studies. And we've talked about them, but the example of facial recognition by policemen or by medical staff thinking about patients, or some of the others. The example of sound, the looking at body language, the question of legal intellectual property scholars thinking about substantial similarity, question of the de minimis use in 7. These all seem like cases where it's very clear that you needed a very high level of image. But is there one catch-all that would separate these issues other than disciplinary status? I actually can't think of one. Maybe other people have ideas. Is there a way of separating out the sort of necessary uses? And I would say a few people mentioned limiting the film professor, the media professor exemption to times when it's necessary. And I just think that's too abstract a concept to apply. Who would then determine when something was necessary? As far as I know, there's no legal standard of necessity that would be relevant here.
But if necessity was formed a part of the basis of the last exemption, and then now we're discarding that particular feature which formed that basis, aren't we in a very different environment this time? Aren't we getting more towards basically a class use exemption, an educational use exemption for on a particular type of work, which is something that had come up early in the rulemakings in relation to educational uses, having an exemption that did not come out the same way, at least as the film professor's exemption. Jonathan, you mentioned necessity.
Well, again, I think the point is that the aspect ratio and so forth.
Professor's exemption. Jonathan, you mentioned necessity.
Well, again, I think the point is that the aspect ratio and so forth. Those were examples of the kind of sharpness of image that you would need, or the reason why you need a certain level of quality to make effective use in the classroom. Now, I am sure that there will be some cases where, if you're simply talking about general plot and it's a little less important to have the high quality, but I think there's an awful lot of situations where the high quality is important, or also, as we've heard, where the lack of quality is frankly simply distracting from the ability to really understand what's going on or really pay attention, because we have now, again, things change, and so we're used to seeing high-quality images. A lot of us do have, as Fritz has pointed out, we do have, these HD TVs in our basement, and that makes Bruce's clients very happy because his clients make them. And so we've bought them because they told us that they were good to have. And so we're used to high-quality images. And so if we then go to a situation where it's blurry, it frankly distracts from the whole impact, and it distracts from the educational message and the use. So I think to some extent, again, in certain cases, the necessity is greater than others, but I would submit that it largely because of what the folks on the other side have done and how they have changed our expectations, we need that quality across the board, because if we don't have that quality, it just doesn't work in the classroom.
But I still saw the use of a number of clips that were of older films or VHS, quality films that were being shown in some of these works. So if what you say is true, why were those included in those montages? Well,
first of all, partly because that legacy items, and partly also it was pretty distracting. The first thing that strikes you when you see an old black and white thing is you say, boy, that's kind of fuzzy. It's distracting. It doesn't have the same impact. You're not focusing as much on what you're supposed to see because it's.
And actually, just before we go too far down the road of thinking about quality as the main determinant in crafting the exemption, there are a number of other factors that we wouldn't want to lose. So what about works that are only available in protected digital formats? What about this question of disk shifting and use of classroom time efficiently, which I think was a major part of the 2006 exemption. So if you did sort of move the exemption so it was primarily about the quality, we would lose a number of other important reasons, and actually a lot of uses that are enabled by the 2006 exemption.
But that does not get to the point of what type of how you get that work, whether you need to get that through decryption of the CSS or whether you can get that through some other version.
Yes, no, you're right.
Okay, then, and maybe one thing I can do, because I'm not sure, there was a small clip shown before getting to the other issue of just showing what is in the record for Professor DeCherney's that we have on the website. They're playing those full clips, at least the one clip of the educational use, not for now leaving aside the student use. I'm going to put that up on the
This is an excerpt from a lecture that I submitted to those. Okay.
That is part of your reply comment.
And I will again just remind people that this was submitted as a DVD in DVD quality, and then it was re-encrypted, recopied, and then posted up on the web.
I'll keep asking questions while it's down.
So obviously significantly diminished resolution you can already see, but
okay.
Deli Carpini and myself in the 2009 DMCA exemption rulemaking. I'll be modeling a typical undergraduate lecture. Really, this is a short excerpt from a lecture on computer graphics, or CG, that I use in a History of Hollywood course. More specifically, I'll be discussing the rise of digital characters and the more specific technique of morphing. So with the availability of laser scanning, the computer graphics work of George Lucas's Industrial Light and Magic, ILM, with their Pixar computer, digital characters began to take off in the 1980s. Morphing is really the first step towards digital characters. In 1988, in Willow, Ron Howard's Willow, there's a character who changes a few times throughout the film. In Inner Space, the year before, morphing is used to have characters shrink in size. The film Indiana Jones and the Last Crusade from 1989 had a much more extended morphing sequence in the so-called Donovan's Destruction scene that you're seeing right now. As with many new technologies, the big studios were not the first to exploit computer graphics. The independent production company Coralco was really the first company to take chances on using CG on a large scale throughout an entire feature film. In 1990's Total Recall, Carolco used CG in a few stunning scenes, but the use of CG was restricted to scenes that simulated futuristic computer graphics. Terminator 2, at the bottom of the screen, released the following year, used CG on a much more ambitious scale. The film was directed by James Cameron, who had used some CG to create a character in The Abyss from 1998. ILM created the Abyss character, which only took up 900 megabytes on a computer drive, on a hard drive, which indicates, I think, both the lack of complexity of the graphics at the time and also the short amount of screen time that that particular character received. For Terminator 2, ILM created the T-1000 robot. The character was dependent on morphing throughout the film. He also interacted smoothly with his environment and with other characters. Surprisingly, there were only 47 CG shots in the Terminator 2. The production team used a number of tricks to make it look like many more. One technique that you can see in this clip is the use of a man in a silver suit intercut with composite CG shots. See if you can note the man in the silver suit. So there we see a simple CG shot, and here a much, much more complex CG shot. And for Heronin, it's mostly a man in his silver suit.
Well, this is a great
Now there's
example.
one more CG shot coming in this clip, but it's interesting to note the economical use of CG for the film that proved to Hollywood that digital characters were a real possibility. After the release of Terminator 2, morphing started to appear everywhere. By 1992, home computer software for morphing was released for the Macintosh. Many feature films, like Lawnmower Man at the bottom right here, started to have scenes of morphing. Then you started to see morphing on television with Babylon 5 above, Reboot in the bottom left-hand corner there, a Saturday morning cartoon. The explosion of CG and digital characters led to the inevitable discussion of digital actors replacing real actors. I want to show you a quick clip from a documentary included on the DVD of Star Wars Episode 2, Attack of the Clones. In this clip, George Lucas and his animation team confront this very question.
George, you met Kevin before, I think, but he's the one who's working on the Widowmaker shot? The Widowmaker.
So you got brought in. See?
We wanted just to share the love with Kevin here. So Kevin, front and center, please. All right.
This is called performance.
All right, so this is where Kevin has brought us.
Victory, the shroud of the dark side, has fallen. Begun this Clone War.
I just wonder about his ears.
Okay. How much they fall? How much they droop at the end?
I would
This Clone War.
maybe let him stay up a little bit more. Yeah, it's a little too hangdoggish.
Begun this Clone War.
Yeah, I think it'll work.
Okay.
So are you going to suggest that a camcorder version would have worked in this scene? Where I should remind you that we're talking about Yoda's ears here. It's something important.
Is that a question in general, to witnesses in general?
Go
I think
for
that's
it.
a perfect example of one where a camcorder version would have worked, because basically, in terms of quality, you had a bunch of people sitting around looking at a computer screen.
Yeah, what were they talking about, though?
They were talking about what's on the computer screen, but as I've watched the clip, you were stressing the interaction and the decision they had to make about whether to use a real actor versus CGI. I mean, I don't want to oversimplify, but that's my recollection from having looked at the clip, and I think that's a good example of one where I think it would be very hard to maintain that the highest possible quality would be necessary to achieve your pedagogical purpose.
Yeah, actually, I might have agreed until we saw it here at the much lower resolution than the one I had originally submitted. But Yoda's ears are important to the scene, and you couldn't see them at all at a much lower resolution. It's not just the interaction between people, but they're talking about how to create a new form of art, and it's hard to see them talking about that without actually seeing the artwork itself, which is on the screen.
And one topic that hasn't come up yet in this issue of image quality is how important it is for us to consider the varying contexts in which the screening takes place. When you work, as Professor Czerny does, in an environment where with one touch of a button you can lower the lights to the optimal level, right? That's one kind of environment. But if you're working in an urban public school, in a high school, where the blinds are broken, for instance, you can't really darken the room appropriately. It's different showing it on a data projector than it is on a 32-inch monitor to 35 kids in a room where you can't control the light levels. So quality matters differently in different kinds of contexts. And I think one of the things we want to realize is that we don't all experience context in the optimal settings. That's why we want image quality to be superior, to account for those differences that are part of different classroom environments.
Well, I guess a point about that. How much should we be taking into consideration? How much can we take into consideration in terms of what is needed for a particular purpose, what the conditions are in the particular school? For instance, I was kind of surprised in your testimony that the schools who want to get access to content that's protected also can disallow access in a media studies program to YouTube, which is would seem to be an important component of the media studies environment. So how, given the variables that may exist in particular school systems, how can that become attributable to the quality that is necessarily provided, or the demands that you're going to make of that particular content?
Well, I think educators want to be able to make non-infringing uses of copyrighted materials. To do step number 2 on this list of critical questions, what techniques are used to attract your attention, you have to be able to look pretty carefully at the screen. You have to be able to pause, and you have to be able to rewind. You have to be able to see a clear image in that context, to be able to do a careful visual analysis. We want to do that with students in grade 4, right? In grade 7, in grade 10. Now, the reality of it is internet filtering is used in schools for lots of really good reasons, since 90% of what's on YouTube is dreck, right? And in fact, seeing YouTube, I think we've clearly established this highly compressed little image doesn't work in a classroom that doesn't have a data projector when you have to use a 32-inch monitor. You can't use image display the same way in those contexts. In those contexts where a 32-inch monitor is a standard in the corner of the room, you've seen it in every high school in America, right? The only presentation format that works is DVD.
Okay, a question about that particular clip and now you've made a point about the Yoda's ears.
Yeah.
So this is the additional content that was contained only on the DVD. And some question, I guess one thing would be in terms of the quality that can be captured from alternative means. For instance, the demonstration with the video camera. Is that kind of quality, leaving aside for a second the impediments to making that picture, is that quality something that would be acceptable, and in fact, does that quality perhaps exceed what we were just watching here from that last clip, which is, as you said, degraded quality from what you would have shown?
Yeah, no, I have to say, the MPA has much better interns than they did 3 years ago. This clip looked much better. I still noted a lot of issues that disturbed me about the quality. One is just that they were using a telephoto lens and there was noticeable distortion, and there just always will be. But there was discoloration. There was a reddish cast to the images. They were still a little muddy and blurred, and you could see bleed through in the lines. But also there was especially because they were showing dark scenes, there was actually a lot of detail that was lost that wasn't captured by the camcorder. I would still concede that, obviously, every time I show a clip in class, I don't need the absolute highest quality. I think most of the time I do, but I don't know how you would put that into a craft, and how you would craft that into the exemption. Other than saying only when it's cell phones. Other than saying only when it's necessary, when again, I just don't think that is, I think it's just too abstract a standard to introduce.
Well, in terms of the particular piece of evidence that you submitted then for that, in terms of the CG, to what extent was any higher quality necessary? It seemed like you mentioned that there were 47 different instances within that movie. You showed 3 of them, and they were moving by pretty quickly. There was not any particular real focus on any aspect of that. It seemed to me, at least, to be somewhat in passing with a much longer generalized discussion of CG.
So what I was hoping, obviously, there's a problem with my lecture. What I was hoping to show was that there were 2 kinds of images used there that were supposed to look similar. But at a high quality image, you could actually discern them. Actually, with this one, you couldn't. So one were CG images, and we saw 3 CG images in that shot. The other was when they had a man in a silver suit who was supposed to look like he was a CG image. And if you're looking at it at high quality, you actually can tell the difference. I actually couldn't.
I saw the difference.
You saw the difference here?
Yeah.
Okay.
Well, okay. I guess that's. I guess let's turn to one other issue that, and maybe this, I'll use my other demonstration now, because we haven't reached any particular further development in understanding of how other alternatives. I gather that from many of the comments that the impediments to capturing from a screen in terms of setting up a camcorder, having all of that set up to capture those clips, although it seems like in many cases it will contain sufficient quality for many of the uses that many educators would want to make, that if there was a way to take away some of those impediments by using actually a computer as opposed to capturing from a camera, a separate camera, the question is, would that be something sufficient? And I'd just like to get a reaction. I know Steve saw this in California, but let me just show a short clip. It's getting captured. This technology was just something that I had used for screen captures in the past and tried it prior to the hearings just to see whether it would capture a DVD.
I'll see you all this coming fall in the Big Rock Candy Mountain.
Say, any of you boys, smithies? Or, if not smithies per se, were you otherwise trained in the metallurgic arts before straitened circumstances forced you into a life of aimless wandering?
Jesus! Can I count on you people?
Sorry, Everett.
Well, all right. We take off through that bayou. Then...
Wait a minute. Who elected you leader of this house?
That's probably good. This was not a pre-selected movie. It happened to just be what was sitting around from Netflix, and I haven't even watched it yet. But I know, and I'm sure all of you could see that there was pixelation issues with that. But the question, I think, is, again, going back to my first question in terms of that first concept of necessity that was at least part of the basis 3 years ago for the exemption, is that how do we categorize for many of the uses that would be required or desired in the academic setting, in how many cases would something of that quality, and particularly if we don't have an answer to whether this is circumvention or not, there may be some issues. I'm looking forward to hearing more on that. But to what extent would this be sufficient for many of the purposes that educators desire?
Can I let me start with film professors, and then we can move on.
Yeah.
Or do you not?
Sure.
Yeah, I mean, I think this would be acceptable in a tiny, tiny percentage of uses that media professors would have. I mean, it's really so distorted, not so much by the pixelation, but even more by the reduced frame rate, that it has that look like a silent film being played at the wrong speed. That I think that's so distracting, it would be hard to talk about other issues beyond that. Also, it's a potentially infringing technology, and I think a likely infringing technology. But I know that's not the issue.
I guess just to address film professors then first and foremost, are film professors not more likely to have the kind of equipment that the motion picture industry is talking about? I mean, do not film students film things in the... I'm a film professor. I'm sorry.
You're not a witness.
Not a witness. So, okay.
Yeah. No. I mean, anyone is just as likely to have Handbrake or DVD Ripper or Back the Ripper on their computer, I think, as yeah.
But I just going back, is this just so? This is not a part of most. I'm asking the question. I just don't know. Is that filming is not part of any aspects of film studies?
No, it would depend on the institution. In our institution, we offer film production courses, and so that equipment is available. Many of the people who teach film studies, critical studies, don't have access to that equipment and don't use it and don't know how to use it. I'm actually not sure why that's relevant, but that's right.
If it's a question of who has equipment, and I know that one of our other people said they checked with colleges. Again, I'm the university, the big one that doesn't have a film program. But we do have journalism, but we don't have a film production one. But we're in the process of creating a film studies department, which would only be some of these people that I represent. But the separation of production and the content of film studies happens, I think, in a lot of campuses. The people who are doing film studies and the people who are teaching film who are not in that department are often in the arts and humanities. And you talk about a digital divide out there for the students. There's often a digital divide on campus between the people who are in arts and humanities and the people who have the big money. We have no professors who officially have their own equipment or that would be bought. Our language department has a language media lab. They try their best to help folks out. There's a Center for Teaching Excellence that helps people with the concept of how to do all these things, but a central facility that actually can do this type of capturing for people for classes would be impossible. Too many professors, too many thoughts and ways to do things, and too many possibilities to have one place and one person doing it all for people.
I also wanted to add that as a writing teacher, or as someone who was in graduate school, about 4 years ago I took advanced multimedia writing, and you would receive a lower grade if you had pixelated images in a montage. So as a writing teacher, my inclination would be to give a higher grade to someone who had higher quality images. But see, the reverse is, I'm in a dilemma. You're going to place me in a dilemma because I actually should flunk the ones with the higher pixelated images because they did something illegal, potential. There's going to be this whole regime that develops, like with plagiarism, where I'm going to have a responsibility to evaluate, did this student hack and that student didn't hack? mean, that's really scary to me.
But wouldn't the higher quality then that is being expected by some professors be necessarily the circumvented technology?
Right.
Okay, so the school itself is imposing the necessity on other students to circumvent in order to get it. I'm hearing a number of different academic institution issues that are actually contributing to some of the problems in terms of having different departments that aren't, and teachers who are imposing perhaps undue restrictions on students given the law.
But it's not, writing teachers care about the quality of writing. I'm just asking you not to go down a road where you say film studies teachers, they need quality, but writing studies teachers, they don't need quality as much. And that student writing, a montage of African American stereotypes, that person shouldn't really care about quality. It's not that important. But this person over here who's a professor at a university needs quality. I mean, that's just very unjust. I'm just asking you not to do that.
Can I just get some clarification? It's been bothering me for a while since you started talking. It's been a few decades since I went to college. When I went to college, writing had a particular meaning that I don't think is the meaning you are using. Can you explain to me what you're talking about when you talk about writing studies? I don't think you're talking about writing in the conventional way.
I did clarify in my opening statement that I'm defining writing broadly. This is a report put out by the National Council of the Teachers of English, authored by Kathleen Yancey. And basically, writing is, we don't consider alphabetic writing to be our sole domain anymore due to the advent of digital writing. So by writing, I consider a montage to be a composition, a piece of writing. It could have text or not. So I'm defining writing broadly, and this is how people in writing studies see it. So I'm from a humanities. I think I'm the only one here from a humanities discipline, though. But we think that maybe not. But yeah. Do you have any further questions about clarification about how I'm defining writing?
I think I follow that.
Okay, thank you.
Well, I guess just to get a little broader sense of that, Roger, you had a number of different examples dealing with particular instances in legal, and I'm certainly familiar with some of these uses in legal institutions.
Can I, before we get to that, can I comment on the Snagit example specifically?
Sure.
I don't know if you're going to, just very briefly, not addressing the question of quality. I'm actually pretty surprised by this. I had heard from the Palo Alto hearing that this was shown as an example of, hey, what do you think? I, in my office, downloaded a trial copy of Snagit and tried with 3 different DVD playback technologies to duplicate specifically this. Try to get one of the examples from the movie Seven, for instance, to do this. I ended up getting a blank screen on each one of them. There could be technical reasons. Maybe
it's hardware acceleration.
Right.
You right-click and just move the slider down.
I removed it from the playback technology that's embedded in this, the interactual, the player that automatically plays with this. But so it could be just a matter of settings with that. But what I'd like to know, or what I'd like to hear once there's been better analysis of it or whatever, is I'd like to raise the issue that once you've changed this hardware acceleration setting, or once you've figured out the right configuration, are we then going to be guaranteed that this is available under new operating systems such as Windows Vista, where they're trying to do a little bit more in terms of locking down the delivery of information on there? And I also had tried it with a higher-end desktop caption software called Adobe Captivate, which should be greater technology, but the difficulty with that is, though I was able to capture actually a lower resolution version than this, it does not allow me to contemporaneously capture the sound. I can have the sound coming from a line-in source, so I'd have to figure out a way to snake it around without feedback, or I can have a microphone coming in. So just very briefly, I just wanted to go on record saying I tried it. You're right, it's probably the settings. Clearly, it can be done with Snagit, but I had difficulty, and I'm not convinced that the DVD playback software or the operating system that it runs on would be guaranteed to allow me to use that as something. So I'd be a little cautious to accept that as the technological alternative to CSS circumvention for the next 3 years, just knowing that there's some tenuous sort of status of this.
But of course, there's no necessity to move to operating systems that restrict what you want to do, so
Yeah.
that there is a certain amount of choice that would be involved in some of these things. But some of the questions that I wasn't trying to, as I said, I did not buy stock in this company, and I'm not trying to push this. This just happened to be something I use. I'm sure there are many more, that many of them may work in many different ways. And I think in testimony I believe Fred von Lohman mentioned in California that there was some mention in the 104 report that we had raised questions about whether certain types of technology, and in particular I think that had to do with music, and the particular technology we were dealing with at the time was Total Recorder, which actually replaced a driver as a consequence in order to do what it's doing. My understanding of some of the capture technologies is that there's no actual driver replacements. It's essentially doing on a software basis what is being done by the video camera, getting the analog output and converting it to a digital file. So my question for you in general, without regard to that particular technology, if there is any thought about that, is do you have any opinions of if this technology was doing it effectively what the video camera is doing, but obviously removing some of the obstacles that I could see some people say would be conveniences or doing this more conveniently, but if this did the same thing that the video camera was doing, would there be any problem with that?
Just to clarify, Rob, I think what you're saying is, but I want to make sure the question is clear. You're saying that if this technology, this software, actually captures the analog signal on its way to the screen, would that be something that you would consider circumvention? Is that what you're saying?
Or the analog output, what is just being portrayed to the eyes, essentially, as it's coming off of the screen?
You've asked questions that we'll be glad to answer after we've analyzed the technology and lined it up against the legal obligations.
And this is not just, the question didn't specifically have in terms of, I just want to clarify in terms of raising the Snagit technology that this isn't specifically about Snagit, but we're trying to get some understanding in general about if there are certain types of capture technology other than a video camera that may be able to alleviate some of the educational concerns. So we will try and ask that. Jonathan?
If I may, and with all due respect, Rob, there is a very surreal quality to this line of questioning, but also to this entire proceeding, and a lot of the testimony we just heard. I mean, obviously, and this going back to the point I made in my testimony, either the quality is equivalent or if it isn't, or it isn't. Now, it's pretty clear to me that the quality isn't equivalent. But if it is equivalent, then, of course, the DMCA is a waste of time, and all this stuff about a speed bump and all those kinds of things obviously makes no sense. Because if there's all these other alternatives available that really are good enough for the vast majority of uses, then Bruce's poor members will not be able to sustain their technological protection system. But that leads to another question. Okay, let's assume that they're, putting that fundamental paradox aside, I just can't understand, to the extent that we're saying, okay, we're really concerned about normative behavior, and we don't want to encourage circumvention because that would somehow be a bad thing. Again, that's sort of ignoring the fact that we live in this, I think it was Jack Valenti who always talked about we live in this sea of infringement. So here we have this little island in the sea of infringement where people are trying to do the right thing. And so instead what they're saying is, okay, well, there might be this slippery slope if we allow circumvention. So instead what we want to do is encourage camcording? I mean, that seems to be the absolutely most bizarre argument that I've heard. And again, it was surreal when Fritz made that argument 3 years ago, and unfortunately the Copyright Office rejected it at that point. Talk about normative behavior. The MPA has been going around the country getting states to pass laws against camcording, and it included ratcheting up of the federal copyright law to prevent camcording. And so to sort of say, well, what we want to do is somehow encourage camcording and have this wonderful demo. We should put that on YouTube about how you especially, hooking up the analog outputs. I mean, why would you want to do that? Why do you want to make this difficult? This is an easy problem. There's an easy solution to the problem. Why are we going through all these convolutions, again, ignoring the fact that all that infringement is going on out there. It's going to go on out there no matter what we do here. And so why either encourage camcording or encourage instructors to break the law? That seems to make no sense. If we want to encourage good normative behavior, just say, yeah, of course you should circumvent for this purpose. The quality is so much better. It's so much easier and more efficient. Why make things difficult for people? I must say, this is a totally bizarre situation.
Anyone on that side want to respond?
Yeah, I'll respond briefly. The fundamental point from the technology proprietor's perspective is that you don't want to have the circumvention tool become something that is available and out there as in the legitimate marketplace. Now, we tried to prevent the circumvention tool from being available at all. That failed. But the notion that the tool itself is something that becomes ubiquitous and accepted as part of the legitimate marketplace is something that is a significant threat to the viability of the technology going forward. The use of the camcorder for the limited purpose to make what is stipulated to be a fair use of the image does not threaten the technology. It allows the kind of fair use that has been discussed here, but does not threaten the technology. And the limited, well, we were concerned about the film studies exemption 3 years ago. The limited nature of that exemption and the understanding of the pedagogical needs of the film studies professors was something that we've been able to get our minds around and understand and accept, and have found that it has not actually had the kinds of concerns that has not resulted in the kinds of concerns that we might otherwise have. But to expand it exponentially, I think is the concern, is the viability of the technology.
Can I make a point to that?
And that is what Section 1201 is about. And so to have this proceeding become something that effectively eviscerates the protection that's available under 1201 and that was available, in the development of this technology, it seems to me is not what this proceeding should be about.
Rich, then Renee.
As I said earlier, convenience simply cannot be the standard of this proceeding. If you make convenience the standard, then there's no more prohibition against circumvention, because it's not just educators and film professors that have the ability under our copyright law to engage in fair use or other non-infringing uses. You can, I can, everybody can. So if inconvenience or convenience is the standard, then everybody should be able to circumvent, because everybody is entitled under our copyright law to engage in fair uses. So there is no prohibition against circumvention. You basically eliminated, voided the circumvention prohibition.
So made Jonathan very happy.
Yeah, it would make Jonathan very happy.
It's not just about convenience.
And while I have the microphone, Jonathan, just responding to Rob's question, even if this utility did nothing more than what a camcorder does, I would point out that under 1201, if it is marketed to avoid, bypass, remove, deactivate, or impair a technological measure, it's still a circumvention device and prohibited by Section 1201.
Well, I think one thing we're trying to get out of you folks is an evaluation, and granted, you're not going to be able to do it overnight, but an evaluation of whether it in fact is just that, or whether you think it's something that does in fact, permit people to engage in uses that don't violate Section 1201, and in fact isn't even a violation of 1201B. We don't know at this point. Maybe you don't know at this point, but that's something we'd be interested in hearing from you.
I just want to make a point in response to Bruce's idea, because he says basically the tool shouldn't be available in the legitimate marketplace. Earlier in his testimony, he said teachers can't be gatekeepers. I've just spent the last 2 years working with K-12 teachers all across the country, working on the Code of Best Practices for Fair Use in Media Literacy Education. And what we found over and over again is teachers want to make lawful, non-infringing uses, and they want to help their students understand their rights and their responsibilities under copyright law. They want to help students make the distinction between the fair use of copyrighted materials and pirating. But in fact, I think we're like on your side, because we actually think that if we enable unlocking CSS for fair use purposes, it provides the perfect teachable moment to help students understand the distinction between fair use and pirating. Right now, we have a situation where teachers and students are ignorant, or they're fed some propaganda, essentially misinforming them about the nature of copyright. If students want to pirate, they don't need to go through all the trouble of going to get the encryption code. There are plenty of technologies are readily available for students who want to pirate. But what we have going on right now in American society is an erosion of respect for the law. And we educators are here, right? We're here because we are deeply concerned that without being able to enable students and teachers to make legitimate, non-infringing uses of copyrighted material, erosion of the law will continue. And in fact, we believe that teachers and students both deeply respect copyright owners and respect the rights of owners to make technology so that their materials can't be easily copyrighted. But at the same time we respect that, we also respect the rights that we have under fair use. So we actually think we're kind of on your side here, and that's why we don't really understand. You say you don't mind fair uses, but you think that access to this technology is going to destroy your market. But we think actually quite the opposite, that by helping all Americans understand the distinction between a pirated use and a fair use, it's going to strengthen respect for the law, and it's going to strengthen the future of copyright protection in the United States.
Okay, just a couple more quick questions to get a couple things on the record. One, with Roger, I don't think you ever got back to the question I was going to ask you, which was about for legal and use in legal and medical education, and in particular the legal clips that were shown. Yes. To what extent is variance in quality sufficient for pedagogical purposes? And I'm bringing something to this in having used many film clips in order to make particular points in class. To what extent is that, and to what extent have you considered, or do you consider whether there are alternative means available? Because, for instance, in a couple of the clips that you showed, I know that they're available on benedict.com, which is a website that I use quite frequently for some resources.
Well, a couple brief things to say about that. I don't know all of the sources available for these different things. When I made them, what I did is we bought the DVDs and we made clips from them. I think that quality is going to be particularly important in the area where the question of law is substantial similarity. So you need to see, what does the chair look like that Bruce Willis is sitting in, and you can see kind of the three-dimensional aspects of it and how it appears in context of things. It's also going to be, quality is going to be important in a movie like Seven, where the lighting of that particular scene is really dark, and it's really hard to understand the way that these black and white photographs appear in the backdrop of things. So there are specific examples. I don't know if they're the exceptions or they're sort of the defining rules, but there are specific examples, in my opinion, where quality is of utmost importance for the legal context of particularly these focused issues of substantial similarity and other types of things where it's, the type of use that's involved. So that said, I think that you could still get across some of the points For instance, one of the clips that I prepared but didn't show was from Anatomy of a Murder. Any copy of that is going to be necessarily sort of grainy based on the fact that it's old and that it's a black and white film. We did get it from the DVD version of it, so we did get the best quality version that we had available, but it's still going to be a little grainy. The purpose of showing that would be more for the subject matter of the material that was there rather than focusing on how particular objects were used. So I think that in that sense, having a clip that was not 100% pristine digital quality might still get the message across.
A question for opponents of the exemption. There was some question about limiting any potential scope of an exemption to the not otherwise available from other sources. How is one to go about being able to identify that? I mean, in terms of if things are being put up occasionally on various sites like Hulu and others, but to what extent would someone have to, if an exemption was limited to if it wasn't otherwise available, how do we sort of figure out what that universe is?
Well, the reason we suggested that is because you've used that before in the past in the ebook exception, at least twice. It's all other digital edition. I'm looking for the exact wording of it here, but it's all existing ebook editions of the work, including digital text editions, contain access control. So this is really the same type of thing. No, I mean, yeah, it's obviously there's a certain question of reasonableness here about how far you have to look. There's a lot of examples of that in other exemptions. You did that in the dongles exemption, where you said it's not reasonably commercially available or something like that. But when I saw all the examples that we were given here, a lot of them are on DVD. The main, at least the main digital source is going to be on DVD, protected by CSS. There are some, I think, there was some comment that there are some recent television shows and so forth that haven't made it to DVD yet, so there would be other means there. Are they protected? A lot of those are in the clear, so you wouldn't need to circumvent in order to get access to a digital version. But and Hulu is a source of many current, not just Hulu, but also the various network websites and so forth. I think people that are reasonably savvy to this would know at least the sources that they would look for to try to find whether there's an unencrypted digital version. And I don't think that you couldn't probably take an absolutist position about it, that if somewhere in South Slovenia you could find an unencrypted digital version, then the exemption wouldn't be available. But I think some requirement that you show that in order to make the use you want to make, you have to decrypt, I think it necessarily implies that if there's some reasonably available unencrypted digital version, you can use that.
Should we have a reasonable search requirement with best practices?
That's where we'll end up.
Not to get into that. That's for one question about Blu-ray that came out. A lot of the discussion has been focusing on CSS. There were some discussion in the comments about Blu-ray. I'm just trying to get some sense of to what extent are there works that are available only in Blu-ray format, not available in any other format.
Fritz actually might have better.
Look at the wrong side of the room.
Well, I think you're the one who raised Blu-ray, so that's why I was looking to anyone.
We haven't identified any titles that meet that description, but I'm not saying there couldn't be, but we're not aware of any.
Okay.
Yeah, not to seem unreasonable, but the question was to whether or not whether or not the exemption could be restricted only to DVDs. And clearly, there are many cases when DVDs are good enough. There are other cases when Blu-ray would be much better and much more effective. There are other cases when someone is teaching a media studies class and uses as teaching a video game, and might want to take a clip from a video game, or some other source. And we wouldn't want to discriminate against people who need even higher quality. There are actually cases when Blu-ray wouldn't be good enough. It's as good as something that's available, but obviously if there's something out of a higher quality, that would be even better. So there's obviously this range of material that's out there. There's a range of quality that's available, and there's also a range of media that's taught in media studies classes.
Well, that points out the slippery slope that you get on when you start talking about the best quality that's available. The best quality available is going to be the computer disc in the digital theater that is much higher quality than even Blu-ray. Does that mean that there should be an exemption in the law to allow Professor DeCherney to enter a theater and make clips from the computer disc in the digital theater? I don't think so. The question is not optimal quality. The question is reasonableness and good enough quality to meet the legitimate pedagogical needs of educators. And I think we've demonstrated quite clearly that camcording meets those needs.
Right, but last time around, whether you think we did it right or wrong, we came to a conclusion that for certain uses, and it was precisely the kinds of uses that Professor DeCherney and his colleagues in film studies, the need that they have, sometimes best quality or in any event really, really good quality is what you need. And I don't know whether I would say you conceded that, but certainly we at least concluded that he had made a case 3 years ago that he needed to be able to get that kind of quality for his particular needs. So let's assume that nothing's changed with respect to that analysis. I'd be curious to know, hear from both sides, whether, fine, last time around we were only dealing with DVDs protected by CSS. That's what was out there. Now Blu-ray is out there. It's protected by a different kind of access control. I would imagine Mr. DeCherney would say, but I'll give him the opportunity to tell me whether he would say that for his pedagogical needs, when Blu-ray is available, he really needs Blu-ray because that gives him the image in a much better form that for his pedagogical purposes, at least in very many cases, makes it for a much better teaching experience, one that we could probably all understand at that point. If that's his position, I'd be curious then, and I will give him the opportunity to speak first, I'd be curious then to hear what the folks on this side of the aisle have to say about whether the case has been made for permitting circumvention under those circumstances, because I believe your submissions have said this should be limited to DVDs protected by CSS. So I detect at least a potential difference of views, even if we're sticking essentially to the same exemption that we had 3 years ago, but updating it now to look at the marketplace now. So let's start with you, Mr. DeCherney.
So first of all, as far as I remember, the 2006 exemption was not only for DVDs. So we're not going down a slippery slope.
It says audiovisual works.
I don't think audiovisual works. Yeah.
Actually, it wasn't. You're right. It was much broader. So
yeah. So I just want to remind you, we're not going off starting down a slippery slope. We went off the cliff 3 years ago, and
or we didn't know where the cliff was, or that it was there. But okay.
And I mean, DVD, Blu-ray, and HD DVD has been around in the market for several years, while the exemption has been around. And as far as I know, it hasn't destroyed the market for Blu-ray or had a significant impact on it. So I can't imagine that extending it another 3 years would cause a significant change.
Can I just interrupt? Do you know whether there have been instances where film professors, not you certainly, oh no, actually into this, maybe you could, have actually used Blu-ray and circumvented with the access controls on it in order to make clips?
Yeah, actually I haven't. I don't know if it's been done.
Okay, but go on. I just wanted to. I was curious because it came up.
Yes. No. So I've used Blu-ray in teaching. I actually haven't. But I haven't circumvented in order to do that. I would like to. It would be great. I don't know how to do that.
All right. So
yeah.
Let's hear a reaction.
Well, the longer we go on this afternoon, and as we proceed through this proceeding, we continue down the slippery slope, and we hear more and more uses. 10 minutes ago, Professor DeCherney, or 5 minutes ago, for the first time said he wants to be able to circumvent video games. That has not been said previously in this proceeding. I don't believe it was said at all in 2006. But now we have that on the table. We've had literally hundreds of examples given today and in the proceedings so far about circumvention of CSS on DVD. Every single one of them, as far as I know, was a circumvention of CSS on DVD. That was also the case 3 years ago. The Copyright Office, in its wisdom, didn't see fit to include that limitation. In other words, it didn't conform the exemption to the evidence that was before it then. But I would suggest that the overwhelming majority of the evidence before it now is limited to DVDs protected by CSS. Yes, in theory, there might be some, and we just heard also that as far as anybody knows, there are no works that exist only in the Blu-ray format that aren't also available, in at least of the commercially released works, that aren't also available in DVD protected by CSS. So our concern here really is to conform the any exemption that you recognize to the scope of the evidence, and I think that's what the statute requires you to do, because you have to find that people are now being impeded in their ability to make non-infringing uses because of the prohibition, or that they are likely to be, more likely than not, in the next 3 years. And I simply don't think the record here would support that finding, even in the case of the film professors, for anything other than DVD on CSS. I think Professor DeCharny is correct. We are, and you're correct, that we are seeking a narrowing of the existing exemption in that regard. We think it should have been narrowed 3 years ago. It wasn't, but we're asking again that you be faithful to the statute and only allow the exemption to the extent that there is evidence in the record that people are now being impeded in their non-infringing uses, or that they are more likely than not to be impeded in the next 3 years.
I didn't mean to hijack your questioning, Rob, so that's good.
Fritz.
If I may just respond to Mr. Carson's reference to our demonstration 3 years ago. And the evidence before you then caused you to conclude that an exemption for media studies professor was justified. And I'd just like to point out that Professor DeCharny is absolutely correct that the competence of the person doing the demo has improved markedly. But aside from that, it is a fact that technology has improved markedly, at least affordable technology has improved markedly in those 3 years. And I think that you need to take another look at the exemption that you allowed 3 years ago to determine if it is still justified in light of today's technology, because there has been a dramatic change.
Two more quick points about that I just want to clarify is with the film clip service, Sandra, that Warner's working on. You said that was hopefully going to go into beta towards the end of this year.
That's our goal.
That's a goal. And that would be initially at the time of the beta anyway. Is this just a Warner Brothers project, or this is a?
It's not a Warner Brothers project, but since I can only speak for Warner Brothers, that's who I was speaking for in talking about our enthusiasm for the project and the work that we've done on it. But it's a goal that's shared by all the studios, and the work is being done under the auspices of the MPAA.
Okay. One clarification just in terms of the permissions. One thing that was raised earlier, and I was kind of surprised by when I came across it. You had mentioned the request in for the Tarzan, the letter that was appended to your reply comments, responsive comments, and but there was one before. It seemed like the three letters, film requests and responses in there began to change in terms of tone, but the first one included a statement that there were, in order to give permission, that there were that there were a number of different conditions that had to be satisfied. One that being exception is available only to nonprofit educational institutions. Copy of the motion picture was lawful, purchased or rented. The exception applies only to performances rendered in the course of face-to-face teaching. And then there was that last point that was mentioned about screen actors, that in addition to the above criteria, our lack of objection to your use is conditioned upon your obtaining a permission letter from the person or persons appearing in the clip. You may be able to do this by contacting the Screen Actors Guild and giving the address there. To what extent is, later on it seemed that this was, that Warner Brothers said that makes no representations, warranties, or indemnities should any claim by any other party be raised. But initially it looked like there was a conditioning of permission on getting a subsequent permission from all the individuals contained on there. And I just wonder why that was necessary. And isn't this imposing sort of additional hurdles on the permissions process that perhaps could be if that could be a solution?
I'm not the author of the letter, but as we were submitting our testimony, we were providing the only examples that had come in. The first letter that you referred to, the criteria that are contained in that letter are intended to inform the requester of the requirements to qualify for the classroom exception. The statement that we, don't necessarily control all the rights associated with the use of the clips is, simply a statement of fact. And
well, that got better at the end. The first one was our lack of objection to your use is conditioned upon. So it was going beyond that.
I can say that I've had conversations
Okay.
with the people who've drafted the letters, and I understand that our current practice is now not to condition the permission on that point, but rather to simply make the requester aware that there may be others that have claims on the use of the clips, and that we are giving them a waiver of our rights, but they may need to contact others.
Okay, thank you. All right, let's continue on the permissions thing for a moment. And I guess this will be addressed initially to Sandra, but since you can only speak for one company, I don't know whether Rich or Steve might be in a position to give us more general information. So a professor gets in touch with a studio asking for permission to use a clip in the kind of context we've been talking about here. How quickly can one ordinarily anticipate it would take to get a response?
As I noted in our testimony, we very rarely get those requests, and typically we send out it's a standard letter that basically says, these are the requirements to meet the classroom exception, for instance, and the letter that you saw, that we waive our rights to the extent they're ours to waive, and depending on whether the person that sends the letter out is in the office or not, it's usually done within 3 to 5 days at the, on average. But actually, when I went through the records in preparing both this time and then the last time that we testified 3 years ago, most of the letters were actually issued the same day that they came in or the next business day.
Fritz, any idea whether the practice at other studios is any different? No. Okay.
Try.
All right. Let's assume, and it's not necessarily a solid assumption, but let's assume that if you were to write to a studio asking for permission to use clips that you identify in your classroom, within 3 to 5 days you'd get a response. Is that an insuperable obstacle for you? How big a deal would it be if you had to do that? Any of you?
It'd be a huge obstacle for me, because in the course of a single day-long staff development program, say for instance like the one I did in January for teachers in North Carolina, in a single day I might use 30 clips. So that would be 30 letters, and that would be 30 paperwork, filing, and organizing. So for me, that would be a big burden, because I'm multitasking already, well, I'm teaching college and teaching K-12 teachers and consulting. So for me, it would be a substantial burden. I think for K-12 teachers, the burden is more substantial. What they tell me when they've explored that option or modeled that option with their students is that just finding where to write, just finding the right address and the right contact person, just getting the name of the person to write to is a challenge.
Peter, how about you?
mean, I would agree with that. Figuring out who to ask permission is a significant issue. I'm sure everyone's seen films in which there's title after title of production company.
But there aren't that many studios around, so after 4 or 5 times, you'll probably figure out who they all are. So once you've done that homework.
Actually, it's probably not true. If you looked at media studies generally, the major studios, the films they produced probably make up a very tiny percentage of the films that are actually taught at universities and at colleges. So yeah, it's hundreds, probably thousands of studios and production companies you have to write to, and descendants of rights holders and that sort of thing.
Okay.
And you also a lot of the movies that people want to make use of are foreign.
Mm-hmm.
So you have that, and they're still, even though they're foreign, they still have the U.S. copyright, and so there's that whole added layer. And we need to remember that again the statute says, is this going to adversely affect fair use? I've got to say, or a lawful use. And so if the status quo before and status quo ante DMCA was that you just used it, then having to write even a single letter is I think by definition, adverse effect.
I understand that point. I certainly understand that.
But we're just saying, it's multiplied, again, using the word exponentially. It's multiplied exponentially when we're talking about all these companies and layers of production companies and the international dimension, which is a very important part of what we're talking about.
I'd suggest that if you're working in the United States and seeking to use a film in the United States, somebody has the rights to that film in the United States, and it typically appears with the logo at the beginning of the film, and you could contact that studio, and you typically do not have to contact 5 layers of production companies. One studio owns the rights for the territory in which you're seeking to use it.
Well, all right, so I agree with what's been said before. It is a difficult proposition. Just one answer to the question there. A lot of us have to do this other layer of things, which has some connection here, which is the performances of media for groups and classes and festivals on campus. And we do use the traditional swank and all of those guys to find the appropriate rights. But time after time after time, for various festivals, international film festivals and things like that, we end up with holes, people we just can't find the rights for. Or we talk to Swank, they don't know the rights for. Or we talk to experts at Kino or New Yorker before they died or something like that. We go direct to various sources who are in the film industry, and they're often the best film for the best purpose often is not, there's nobody to find the rights from. Or we'll find the company that is the last rights holder, and we send a letter, and we may or may not ever get a response back because we can't find the key person for that. So we always have to have 5 and 6 backups for everything, for every festival, just in case we can't find the rights holder for the best one. And it happens more frequently for the important, serious films that we need than the ones you're going to go down to your local video place and rent. So, and the fact is, and I have on my flash drive the list of all those classes, and I don't want to drop because you asked one question earlier and then we didn't get to it, which was the non-film studies people. There's those people who are non-film studies people and are not used to having to negotiate rights or to find clips. They do pictures and stuff for their books and their research and all that, and it's a similar process in a way. But true teaching and a lot of those things are so serendipitous that no matter how much planning they do, in a week or in a 2-week period, there's always going to be something else that would have been great to be able to add based on discussion or something like that. And I don't think any of those people are set up to constantly be looking for rights, getting the rights week after week after week, just in case. And if I did it with all the companies, all the classes that I have on my flash drive that I just wanted to show in this example, then each class would probably have someone getting, as you said, let's say 10 to 12 clips a week for a semester for the 100 classes that I have here. And none of them are film people. But they're all visual culture people.
Yeah, I'm not in the rights granting business, but just in looking at, and again, looking at the examples that were provided by the people who submitted comments in the proceeding, there are clearly a number of instances where the time, a 3 to 5 day turnaround, wouldn't be an issue. I mean, there was a group from New Mexico who filed where they were preparing commercial, in effect, commercial, but within the academic context, materials that were used over and over and over and over again, and that they were providing to people. This is something they were doing long in advance of the actual use of the work. And so I think, again, part of my point is that there may be a number of different solutions to the issue that people need to be told to use those solutions that fit their circumstance, and only if they don't, then you get down to the question of is it necessary to authorize circumvention. And again, I think the presentation of the camcording probably, from my standpoint, says even at the end where you can't get the permission or whatever, there is another alternative.
So if I'm hearing you correctly, Bruce, at least you're suggesting that there'll be many, many cases where you should have to get permission. There may be some cases where, because of the circumstances, you just don't have the time and you should be excused from that. If that's the case, how do we write that into an exemption? Are we going to have a 4-factor test or something? I mean, it gets to the point where it just becomes impossible to administer, impossible to write an exemption that's not 7 paragraphs long.
If I can weigh in, at least I'm not suggesting that a first step to every use would be seeking permission of the copyright owner. I think there are uses such as Fritz's example with the camcorder, which you're not circumventing. It's a perfectly usable clip. It can be used to illustrate many of the points that were talked about here. It can be used and edited with other clips together. And for that sort of use where you're not circumventing, and if you're making a fair use and you're relying on your fair use analysis that your school has done, why contact us?
Okay. Steve.
Just to point out, we did provide on page 30 of our submission a proposed revised exemption if you determine that the film professors have made their case this time, given the technological advances that Fritz was talking about and the improved quality of the camcorded version. So it's not 7 paragraphs long. It is a little bit longer than the existing one, but not much. So that would be our proposal, at least as a starting point.
Yeah, and I think that what I was trying to say was fitting in with what Steve was saying earlier in terms of the reasonableness of under the particular circumstances. And again, that's not an unusual kind of legal standard.
I respond as well?
Yeah, please.
First of all, I just reiterate Carlton's point about the spontaneity of teaching and the importance of having to reshape lectures even, and especially discussion material a day or the same day as the class. It happens all the time. Even courses I've been teaching for years, the day I give the lecture, I change it. I would also just remind you that students are also on the table. And so we think about a permission system. We want to think about the impact that would have on students if there was an exemption created for students as well, who were doing coursework, often without much lead time, whether or not they would be able to make use of an exemption. And finally, I don't take this question of censorship too lightly. Mrs. Stairs was very interesting that she brought up the analogy of documentary filmmakers. And I think it's a good analogy. Documentary filmmakers are often engaged in educational projects, and they're often turned down for the use of clips for all kinds of films. I'll give you two quickly. A film about Enron, or actually anyone who's ever wanted to use a clip from The Simpsons. They always get 2 letters, one from Matt Groening, which is absolutely use it, one from Fox, which says Matt Groening doesn't own the copyright, you absolutely cannot use it. I had students to make this incredible film about Philadelphia and its the curse on its sports teams, which existed until this year. And they asked ESPN for the right to use the material in their film. And ESPN actually wrote that since it wasn't historical and they couldn't prove their theory, they refused the use of ESPN material. So this is an analogy, and this is one of the few that we have, a place where there's educational licensing. True censorship really exists.
And I just want to add again, to try to inject a level of reality here. We're talking about big decentralized institutions with, how many faculty members do you have at the University of Maryland? I mean, you must have 2,000 just at that one campus. and you know, a lot of them are using this kind of content, and more want to use this kind of content. And to come up with this, you know, and again, it might shock people on the other side. They're not all lawyers. I mean, they're teachers. They might have PhDs, most of them, but they're not lawyers, and they don't understand all the nuances of copyright law, let alone, you know, the para-copyright of the Digital Millennium Copyright Act. And so to try to have a workable solution that's practical on a big campus with lots of different people who are making a lot of spontaneous decisions, and to have, you know, not only two sets of rules, which is one set for the film studies, whatever that is, okay, given that we have no idea what that means, especially on the Maryland campus where there isn't even a department. One set of rules for them and another set of rules for everyone else. But now we're talking about all these other layers of complexity, of nuance, of trying to say, well, did you search enough websites to see if it was available somewhere else? Is the kind of use you want to make of sufficient quality? I mean, come on, what's going to happen? Given the availability, the easy availability of thesis, and that, you know, let's try to be realistic. Let's come up with a rule that everyone can live with, instead of sort of doing all this legal jujitsu and end up in a situation that we know is not workable. I mean, we want to comply with the law. So instead of, you know, make the law workable, make an exemption that is usable, as opposed to coming up with all these contortions that will mean that inevitably you're just, you know, pushing people into illegal conduct. Because the bottom line is they are going to use this content in their classes. That is going to happen, you know, with an absolute certainty. So why not make it work as opposed to make it difficult? Again, it's just, you know, there's this unreality to this whole discussion.
I think the equal unreality is that we're suggesting that the solution to a legal problem presented is to push people to use an illegal circumvention tool. We should somehow legitimize that here, and I think that's the concern that underlies all of our testimony here, and particularly when it comes to, you know, next generation formats like BD, Blu-ray.
We're here to get an exemption. We want to do it legally, but if you know, you're basically giving us two choices: either do it illegally, or to camcord. I mean, those are as a practical matter, those are the choices that you're giving us. And you know, we've said we don't think the quality of the camcording is good enough. But again, even if it were, hypothetically, why is that a desirable result?
But the Copyright Office doesn't have the power to grant an exemption to the delivery and marketing of those tools.
Oh, but that, of course, you know, that highlights a bigger problem, which we've talked about before, how arguably, again, this whole proceeding is a farce and a sham, because you can only give an exemption to the act of circumvention.
If it's a farce, what are we doing here? And what can we do about it? So let's stick to the topic.
Right. Exactly.
Left and Steve.
I was just going to say that, you know, after many years of these proceedings, I'd always be concerned with a record in which we were relying on my friend Jonathan Band for doses of reality. Just put it that way. He has a finely honed sense of the bizarre. He's already expressed that this afternoon. But when you look at, let us look at the submissions and the record in terms of the reality, in terms of this issue of censorship. There is no evidence about the issue of censorship in this context. The proponents have an ideological aversion to requesting permission. If you look on page 9, they say literature professors do not need to license the quotations that they read in class. Chemistry professors do not need permission to use a particular compound in class. I'm still working on the copyright implications of that one. Requiring media professors to license clips for use in class would endanger academic freedom and diminish the educational experience for students. For these reasons, licensing cannot constitute